Welcome to the first hearing of Portfolio Committee Number 1, Premier and Finance, for the inquiry into budget estimates for the year 2025-2026. Firstly, I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Jeremy Buckingham and I am the chair of this committee. I welcome Premier Minns and accompanying officials to this hearing today. Today, the committee will examine the proposed expenditure for the portfolio of the Premier. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. To the witnesses, welcome again and thank you for making the time to give evidence. All witnesses will be sworn prior to giving evidence. Premier, I remind you that you do not need to be sworn, as you have already sworn an oath to your office as a Member of Parliament. For all other witnesses, could you please state your name and position title and swear either an oath or affirmation? And I will begin with Mr. Draper.
Thank you, Chair. Simon Draper, the Secretary of the Premier's Department. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Ms. Boyd.
Good morning. Kate Boyd from the Cabinet Office. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Ms. Boyd. Today's hearing will be conducted from 9:15am to 5:30pm. We are joined by the Premier for the morning session from 9:15am to 1pm with a 15-minute break at 11am. In the afternoon, we'll hear from independent integrity agencies from 2pm to 3:30pm. We will then have a 15-minute break before holding a session with departmental witnesses from 3:45pm to 5:30pm. During these sessions, there will be questions from the opposition and crossbench members only, and then 15 minutes allocated for government questions at 10:45am, 12:45pm and 5:15pm. We will begin with questions from the opposition. Mr. Tudorhope.
Good morning, Premier. Good morning, Ms. Boyd, Mr. Draper. Premier, yesterday morning you were interviewed on Radio 2GB and I think you had a conversation with a patient at Concord Hospital, Jane, and she was obviously a bit distressed by virtue of the fact that she'd been sleeping on a bench, I think, or some chairs in the emergency department at Concord Hospital. Do you recall that conversation, do you not?
Yeah, of course,
Yep.
yeah.
And in the course of that conversation, you quoted some statistics and effectively you had empathy for her situation, and at the conclusion of the conversation, you had this conversation with her. I appreciate the fact that some improvements have been made. We have always dive into statistics, all right. Well, there are positive figures I'll share with everyone. But then you go on to say this. But you know, we've got to do something about the fact that people are sleeping on hospital floors. Do you recall saying that?
Oh, could you just give me the full quote?
Well, this is attributed to you. Now, this is the transcript of what you said. Now, I'm not sure that's what Jane is really wanting right now. I mean, I appreciate the fact that there have been some improvements, and we can always dive into stats and say, all right, well, here's a positive figure, so I'll share that with everyone. And then you go on. But you know, we've got to do something about the fact that people are sleeping on hospital floors. Do you recall that?
I mean, not directly, but if you're saying I said it, then
No,
I believe
that's
it.
what you said. Because it's the truth, isn't it, Premier, that on the 11th of September 2024, there was some significant coverage in relation to Blacktown Hospital. And you may recall scenes or shots then of patients sleeping on the floor. Do you recall that?
Sure.
Okay. And do you recall that at the time you said this? I have to look at Blacktown in particular. There's major stress on our public hospitals. We want to do better when it comes to health outcomes. Do you recall saying that?
I'm not, perhaps. I don't have automatic recall of everything I've said, but if you can get to the question, then you've got...
No, but
if
you don't recall
If
saying
the general question is, do I remember verbatim what I said last week or last year or last month, unfortunately, I'm not going to be able to do it.
Yeah,
but I'm happy to answer the question. What are you getting at?
We're a year later now, aren't we, from the 11th of September? You've really let down the voters of Western Sydney, haven't you, in terms of what is happening at Blacktown Hospital?
Look, Damien, I appreciate the question, and I think that it's absolutely reasonable that you ask it. And I think the circumstances are important here. Firstly, no one can promise a perfect health system. No one can promise a perfect emergency department. It might surprise members to know there's about 6,000 to 8,000 people that enter a public hospital every single day. In some cases during the middle of winter, during the peak flu season, that number can escalate even higher than that. And it's very difficult to predict. I was at St George Hospital late in the evening a couple of weeks ago, and they had a relatively mild night. The day before, it was absolutely chock-a-block. I gave my number to the nurse unit manager, who said that the day after it was absolutely chock-a-block as well. As a result, there's an enormous amount of people that go into the public health system. The only thing I've said is we've determined to make improvements to the health system. And the statistic that I think I quoted on 2GB yesterday morning was that 50% of category 2, so they're people who are in a life-threatening situation, was receiving treatment within time, which is generally considered 10 minutes. We've got that up to 63 or 64%, and we want to get that even higher. Now, that's not at 80%, and that's not at 90%, but it is an improvement. And I just wanted to make the point that the health system's so large, and we've seen such an increase in the number of people taking or having access to the health system. I think it's grown by 5 or 10% in Blacktown just in the last 18 months. That progress will not be, perfection is not going to happen, but progress can happen. And the government's only ever said in the election campaign and afterwards that we want to have fewer people in difficult situations because we're giving healthcare workers what they need. And the biggest thing we can do, and the biggest change we've made, is to remove the wages cap for healthcare workers.
Well, we'll come to that. If you're doing everything you can, you would expect that the delivery of the extra beds for Blacktown Hospital would be accelerated, wouldn't you?
Well, I'd love that to be the case. Unfortunately, structural change to the hospital is required. Blacktown Hospital, to give credit to the previous government, Blacktown Hospital was built. It's good that it was built, but there was too few beds in there, Damien. Yeah, unfortunately, you've got a situation where if you're looking at critical healthcare in Western Sydney, we had to plan not just for the population as it exists today, but also tomorrow. Now, we want to add 30 beds to Blacktown Hospital. For the layperson, it's not as simple as doing that. Well, we have to... I want to get this out because I can see that you're taking this seriously, but the context is really important. Blacktown in particular is a story that needs to be told. So this is for category 2. So they're people who go into the emergency department, they are in a critical condition, or they're suspected of being in a critical condition. When we took office, 16% of patients were seen within time. That is a miserable number. We've got that number to about 45%. Not 80%, not where it should be, but again, it is a dramatic improvement. And I just posit the largest reason for that is because the healthcare budget for Western Sydney Local Health District has increased by $500 million under Labor. We believe that money is making a difference.
The initial infrastructure spend in relation to Blacktown Hospital had in fact these extra beds being delivered by 2028. In the infrastructure statement in the last budget, the completion date of those beds is now 2029. That's hardly, in fact, treating this hospital with priority, is it, Premier?
Well, I really wouldn't rely on the latest budget released by the previous government.
No, it's your budget.
There's a specific reason why. So much of the health budget needed to be redirected to the 1,100 COVID nurses that were on what's commonly referred to, but maybe people don't necessarily understand, is a funding cliff. And there's a little bit of history here that's important. During the COVID pandemic, quite laudably, and I think Gladys Berejiklian did a very good job here, 1,100 nurses were recruited to deal with a massive increase in demand for our public hospital system. It was done quickly, it was done incredibly efficiently, the money was allocated to them. What the general taxpayer may not know, Damien, is that the money stopped next year or last year. In other words, the final budget of the previous government didn't allocate any money for any wages. But it's important. It's important for this budget, and here's the reason why.
It's these beds, Premier. These
but
beds
Damien,
for 20,
the beds without. This is my point. Beds without nurses, they don't make any difference, mate. You have to have nurses and you have to have healthcare professionals to make the beds work. Otherwise, it's an out of aged home care or a hotel or a motel.
Well, Premier, so it is 2029 that you're now promising these beds. And in fact, your healthcare minister, issued a media release on the 31st of July 2025. I don't know if you saw his media release, did you?
If it's going to be an automatic recall thing, I can't do it. I can't do it. But I'm happy to answer the substance of your question.
Do you recall that the media release? Did you recall that the media release was in fact accompanied by digital photos of beds in a hospital?
Would you mind showing me a copy of it, perhaps?
Sure. I'm happy to. I'll just bear with me, but assume that photo is available.
But I'm happy to take it as given, Damien. It doesn't require my acceptance of it. I'll take your point if you want to get to your question.
So what do you say, though, to the person, the 70-year-old man lying on the floor in Blacktown Hospital, when he's told how good the hospital is and the health announcement by the health minister delivers a digital photo of a bed?
Well, I think in fairness to the government, I have not said the hospital's perfect. I've not said it's completed. In fact, I've said the government acknowledges there's serious challenges out there. But I also think I'm entitled to say that the $500 million from the New South Wales government, which isn't my money, it's taxpayer money, is resulting in better outcomes. Not perfect outcomes, and no government and no Premier and no health minister can promise perfect outcomes in New South Wales hospitals. As I said, 6,000 to 8,000 patients every day will present in a public hospital somewhere in New South Wales. I think you'd appreciate there's a lot of miracles as well, right across our health system.
Certainly appreciate that, Premier.
People that go into hospitals and get life-saving, world-class treatment for $0, nothing. They don't pay a cent. And that is part of the story too. Now, that's not in defence of the government, but that is in defence of some of the most highly trained, incredibly skilled, passionate healthcare workers that are employed right across our health system.
But see, I think you'd agree with me that Blacktown Hospital and Westmead Hospital are two of the worst performing hospitals in Western Sydney, are they not?
Well,
Mount Druitt probably thrown in there as well.
Well, I think a couple of things are important. Again, Blacktown Hospital in particular, because of the $500 million that's gone into the Western Sydney Health District, has seen we've gone from 16% of people who are having a Category 2 life-threatening presentation to the emergency department to 46%. Now, that's an improvement. Again, one of the reasons why it's under so much stress is I don't have automatic recall of the figures, but my understanding is that the presentations have increased by nearly 10%. 10%, massive increase. One of the reasons why we've made a decision to allocate hundreds of millions of dollars to Rouse Hill Hospital is precisely to take pressure off one of the fastest growing communities in Western Sydney. And, I have spoken to people in Sydney's northwest who say that the delay, and this is an important part of the jigsaw puzzle for Western Sydney's health district, part of the real frustration when it comes to Blacktown, Westmead and Mount Druitt Hospital is that Rouse Hill Hospital was promised in 2015, 2019 and 2023 and was never built. And that kind of critical infrastructure in the neighbouring, suburb means that Blacktown acts like a magnet. It has to deal with their immediate geography, the people that require urgent medical attention immediately, as well as the community in the northwest of Sydney.
Well, let me ask you this.
But Damien, you'd agree, Rouse Hill Hospital should have been built, surely. Can we have a common understanding on that?
You can ask me the questions later on when I'm sitting in your chair and you're sitting here. But Premier, let me ask you this. It is clear that there is a problem with Westmead, Blacktown and Mount Druitt. Would you support a parliamentary inquiry in relation to the manner in which the Western Sydney Local Health District are administering those hospitals?
Well, look, I wouldn't automatically support it. I think that the most important thing we can do is three things. Firstly, get on with the job of building Rouse Hill. Secondly, I think there should be an unambiguous and united position that we should not return to a wages cap for healthcare workers in New South Wales. That is just so fundamental to healthcare in New South Wales.
Why haven't you agreed to
I need to get this out, Chair. This is super important. Well, these are the conditions for an upper house inquiry. If we go back to a situation where we say to nurses and healthcare workers, in the middle of a pandemic, your pay rise this year is $0, it would be catastrophic for the public healthcare system in New South Wales.
Whoever did that?
You guys.
No, we didn't.
Yes, you did.
Well, Premier, let me just...
0.2. And I want to make this point because I think it's so... you're asking me would I support a parliamentary inquiry. The parliamentary inquiry needs to examine whether the people that run our public hospitals should be paid something approaching the conditions in which they live. And I would say that one of the biggest challenges that the health minister has faced over the last 2 years has been getting resignations back to pre-COVID
So you're not
levels.
going to have an inquiry, is that it?
Well, it's not up to me. It's up to Parliament.
Well, would you support it?
No, we've had
Yes, no.
No,
Okay. No, so
I mean, this is silly. I mean, you can have a conversation about healthcare, but surely it should be about not privatising hospitals, not reintroducing
Premier,
the wages cap.
You're
and
aware of a
beds into
decision.
Western Sydney.
The Imar Taylor, the president.
If you were to have a parliamentary inquiry into those three things, I think that would be important. Particularly Northern Beaches Hospital and the privatisation of hospitals.
Well,
I think
there's already
Damien,
been one.
that would be a
But
disaster for
what
New
do you
South
really
Wales.
say to the woman at Blacktown Hospital who was crying on camera because of the manner in which the services are delivered to her in circumstances where you sit here today and say, no inquiry necessary, your standard of treatment is appropriate? Is that what you're saying to her?
Oh, that's completely unfair.
But is it
I think a
appropriate?
reasonable person would say, at no point during my evidence here, or even my public commentary, have I said that the standard of healthcare is appropriate. That's
then
a really
why not
unfair
support an inquiry?
presentation.
Why not support an inquiry?
Because I think a talk
Because
fair,
that's what you would say to her,
Well,
that you
no,
care about her, Premier.
I think that's unfair, and I don't think a reasonable person would draw that conclusion. In fact, I've said the opposite. We need to do far better. What I have said is the solutions from the government's perspective is not to privatise public hospitals, not to reintroduce a wages cap, and to build Rouse Hill Hospital. Now, I think you're entitled to say to me, what's your solution to an undeniable critical situation for many people that enter an emergency department? And I can't be clearer than that. Build Rouse Hill Hospital, stop privatising emergency departments. And Damien, I know you've persisted with this, but a return to the wages cap would be ruinous for public health in New South Wales. And I would love to hear whether that's off the agenda, because at some point, you're right, you will be sitting here, your party will be back in government, and it's not the way to run public health here or in any other jurisdiction. And as a result, I mean, if you look at other states and other territories, none of them have followed that lead because they all realise it would be a disaster.
Have you read the decision by Imar Taylor in the Fire Brigade Employees Union versus the Industrial Relations Secretary? Have you read that?
I've read parts of it, but I'm happy to take it as stated if you want to ask me a question about it.
Yeah, well, you'd be aware of the observations he made in relation to real wages increases in between 2011 and 2019, would you not?
Why don't you read it out to me?
No,
Because
no,
I am aware of this.
Good. Okay.
I'd love to hear what your perspective of it.
And even in relation to the period where in fact you assert that the government at the time was offering a 0% increase, not the fault of the wage cap. Is that not what he said?
I think you'll find that in actual fact, the reason for the lift above 3% was precisely because the Fire Brigade Union presented evidence that they had real wage decline during your period in office. Is that right?
No, it is not.
Oh, I think you'll find it is.
Well, then, Premier, we'll explore that with you, but it is in fact entirely wrong. And in fact, this is what the President said. It is objectively the case that for most of the period of the wages cap, 2011 to 2023, public sector wages increased in real terms because the standard increase of 2.5% was in almost every year from 2011 to 2020. 2011.
Very interesting.
No, I'll come to the second part, Premier.
Did you notice that? Almost every year.
Almost every year.
What did he say about the years where you
greater
imposed
than
a 0%?
the change in the CPI? And then the very next paragraph he says, to the extent that there was a significant reduction in real value of public sector wages 21-22,
yes,
that was not the result of the wages cap.
It's because you put it to 0.
No, we didn't, Premier.
You put it to 0.2.
No, we didn't,
Is it 0? What was the number?
2.5%, Premier.
No, what was it during COVID?
Premier, Premier, in
No,
relation...
just help me answer the question. Could you just let me know during
we
the COVID period?
We didn't set it during COVID.
So it wasn't at 0.2%?
The Industrial Relations Commission did, Premier. If you don't know that, I ask you to go and have a history
For
lesson.
goodness sake, this is just...
Premier, a year ago you wrote to
deliberate
IPART.
misrepresentation of history, and I think it...
You're misrepresenting history, Premier. Premier, a year ago you wrote to IPART requiring them in their upcoming price determination to Sydney Water to consider the cost of living impacts of price determinations and opportunities to adjust project timelines within the price determination period and over the next 10 years to minimise price impact.
Well, actually, I want to go back to the previous question. I've got a series of questions, Mr Chair, and I think I'm entitled to answer them.
Are you pleased with how IPART has handled
the series of questions from Damien, and I appreciate answer them.
Yeah, order.
Sorry.
Yes, if you could allow the Premier to answer. Well, and whilst I appreciate the conversational order, Premier, while I appreciate the conversational nature of this exchange, the Premier's responses should be directed through me, the Chair, and we should allow each other the opportunity to ask the questions and reply in full measure.
Well, Mr Chair, I just want to make the point that
Premier,
the decision of the Industrial
Relations
Relations Commission,
I've had
specifically and deliberately, as I understand it, referenced the decision of the previous government to wind not just a wages cap of 2.5%, Mr Chair, but effectively 0. And the decision of the IRC to go above 3%, which was the government's offer, directly referenced that determination. But let's put aside the judgment of the Industrial Relations Commission.
No, don't put it aside.
If the government's if the opposition's position is to return a wages cap to New South Wales, that's a legitimate position for them to add. I would make the point that we've spent the first 20 minutes talking about public health in New South Wales. You cannot run hospitals without public health workers.
I agree
and if
with
we
that.
pay them 0% during a period when inflation hits 7 or 8%, they will leave. They will go to Queensland. They will go to Victoria. It is a terrible public
we didn't
policy
do that,
position.
Premier.
And as a result, the government has had to invest enormous amounts of time.
Premier, this is a
and effort
misrepresentation
to
of
try to
the
rebuild
truth. This is a
businesses in
misrepresentation
Order.
of the truth.
Order.
A complete misrepresentation.
Well, you're the
A
only
point of
one that
order's
believes
been
that,
taken,
unfortunately.
Premier.
No,
Thank
it's
you. A point of order's been taken by Mr. Nanva. I expect I know what it is.
It's not courteous to the witness or to Hansard or to the orderly conduct of this inquiry if members are talking over the top of each other, and I just asked that Mr Chitterhope be called to order on that basis.
Yes, if we could refrain from interjecting over the top of witnesses when they're giving an answer, that would assist the inquiry, Hansard, and everyone else watching. Thank you, Mr Chitterhope. We'll now turn to questions from the crossbench and Mr Borzak.
Thank you, Chair. Thank you. Welcome, Premier.
Thanks.
Good to see you got off to a good start today. You're likely aware of a bill that I introduced to Parliament, the Game and Feral Animal Legislation Amendment Conservation Hunting Bill. You've made some comments regarding invasive species in the media. Can you provide some of the government's views on this issue?
Well, I mean, I don't profess to be an expert on it. I've never gone hunting, and I don't think I've ever held a gun before. But I do acknowledge, particularly having spoken to Penny Sharp, the Minister for the Environment, that invasive species is a massive problem, an increasingly large problem in Forestry Corp, in national parks and wildlife, and on private land as well. And I think I was asked on a radio interview on 2GB about it, and what are we going to do about it? We've had a difficult, but I think necessary decision in relation to Kosciuszko National Park. Kosciuszko. Did I say
You
that
got
right?
it.
He tried.
We're going to change the vernacular here.
Bring out your inner Polish.
It's very, 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 very deep. But we've had a difficult run in relation to that. I think it was the right policy decision, but obviously it was very controversial. I think a lot of people, in fact, in all candour, I didn't know about this, but a lot of people would be unaware that pretty much every weekend and right through the week, private hunters do effective pest management control in New South Wales forests. And the suggestion was put to me that a bounty system could be put in place. I sort of looked at it and went, well, doesn't seem crazy to me. I was interested to see New South Wales farmers came out very quickly afterwards and said, we think that would be a good thing to do because goat, pigs and feral cats and other invasive species are really causing havoc to what is the natural beauty. Now, it's not a blanket support of anything. I think we probably need to tread carefully here and make sure we make the right decision because we want to make sure that whatever's in place exists for a long period of time. But we would consider it. And I think every political party is considering.
Have you got any statistics to back up the problem that invasive species present?
Not off the top of my head. I mean, what would be your understanding of the scale of the problem, just to help me in my answers?
I think it's a huge problem. I mean, you've only got to look at the evidence from the inquiry into my bill, what I think last Friday, a week ago, where the president of the Australian Pig Dog Hunters Association talked about in 12 months on private and public land, private conservation hunters killed 1.7 million pigs alone. And that by itself isn't a solution, but it's part of the solution. What do you say to that?
So was that 1.6 million feral pigs?
In 12 months.
I mean, that the scale of that is far beyond what I thought. That's shocking to me. And, in all candour, probably beyond the scale of the government's approach if we were to do it via contract labour or even using National Parks, Wildlife or Forestry Corp employees. I mean, that's all they'd be doing, and they've got other responsibilities in terms of attracting people to the national parks, the upkeep of the national parks. We're not even speaking about invasive species and its impact on private land, which is astronomical as well.
That number is across the board, both private and public land, and it's a very large number. No one really knows how many feral pigs are out there at any one time, but they're obviously millions and millions and millions. And as you said earlier, pig dog hunters and other hunters are out there every weekend and during the week on public and private land doing what they do. And it's a resource that should be harnessed.
Yeah, Robert, I'm told that invasive species are the highest impact contributors to the extinction of native animals, directly endangering 70% of threatened wildlife. 70%. So if we're knocking off 1.6 million feral pigs in a 12-month period, that's what we've got around to. I mean, a bounty system. Look, I've heard the arguments. I can't remember the name of the organisation, but there's groups that are opposed to it. I think on the understanding that it would lead to the cultivation of some of these things in order to claim the bounty. But in reality, there's such a huge number that's available in the wild that if we can get help.
Look, I think that sort of basically rubbish talk. They don't need to save or save up pigs from Queensland or Victoria or someone else to claim a bounty. There are plenty of pigs out there in the wild and on public land in New South Wales for their bounties to be claimed. That's really the way it works. What role do you think bounties will actually have in the end? Because we're talking about a bounty for pigs, and then we're talking a bounty for wild dogs, foxes, and especially feral cats.
Well, I guess the hope is that it would lead to a reduction in the number of invasive species in our national parks, our forests, and on private land. We spend, I've spoken to the Minister for Primary Industries, we spend hundreds of millions of dollars on invasive species management across, particularly for our agricultural sector. We want to grow our agriculture sector. It's a huge and important part of the future growth, future economic growth for the state. I think, most members would appreciate that from the perspective of the government and economic growth, our largest export is still black coal, and it still goes to effectively a single market. I think last year was between $40 and $50 billion worth of exports went to a single market, and it was largely black coal. Now, those countries will continue to buy it, and there's a future for those jobs. I accept that. But they've all indicated to us over different time horizons, in different ways, they'll be buying less of it in the future to the point where they don't buy any of it at all. That's the energy mix, particularly for Southeast Asia. Now, New South Wales is facing a situation where our single biggest export, we are being told in explicit terms, will decline in the years ahead. We have to think of export-led industries that are native to us, that we can grow, and agriculture is a massive part of it. But that's not going to happen if both the actual product is threatened by invasive species, or secondly, the perception about Australian agriculture and primary products is threatened as a result of invasive species. So I just think it's all hands on deck, Robert. I am concerned about it.
Do you want to talk a bit generally about biosecurity? What initiatives has the government put in place generally in relation to biosecurity, as it relates obviously to the farming sector, which is what you're talking about now?
Yeah, I can't remember the stats, but we've put more than any other state into combating varroa mite, which is a massive issue, particularly in the northern rivers. That's resulted in a lot of trucks being stopped at the border. We need to make sure that money continues to...
Well, you've got fire ants now too, invading New South Wales.
Yep. Do you have the latest data on that, Simon?
I don't have any data on it, but yeah, the northern part of New South Wales has had a lot of problems with it. Yeah.
Yes, I spoke to the farmers, New South Wales farmers, a couple of weeks ago about this particular issue. It remains a massive, massive concern for them. Particularly, one of the things that they've often mentioned to me is in regional communities where you've got farmers on all sides, obviously there's a big focus on... I say this, I can see Sarah looking at me quizzically, but I say this as a complete novice. Well, I'm not pretend to be a farmer. Although I have been watching Clarkson's Farm, so I'm getting there. No, but they did say to me that when you've got farmers on each side of you, it means that you're good neighbours. They all obviously focus on ensuring fencing's up, and that if there's some kind of mistake on one part of the land, the farmer and the farm is notified as soon as possible. They also make the point that when they border New South Wales government land, whether it's forestry or national parks, we're not considered good neighbours, and we've got to be good neighbours. And if there's invasive species that is being effectively mating, germinating, and then crossing over into private land, well, that's a big concern for us, for a sector that we need to grow.
Yeah, weeds is another whole big story by itself, especially as weeds migrate from national parks onto private land. It is a real big problem.
Yeah.
Real big problem, and local land services have got their hands full just dealing with that.
Is there any jurisdiction that does it, or maybe they all do it better than us, but what state's doing it better than New South Wales? What should we be looking at?
I don't honestly think any state does that sort of thing well at all in Australia. Not that I've ever seen. I mean, maybe Ms Mitchell can say something different, but I everywhere you go, you see the same problem, and there's not enough money in the New South Wales Treasury to try and handle these things in a way that farmers would be happy with right across the board. You can only do what you can do, and I think as far as the feral animal control situation is concerned, I think it's commendable that the government's looking at using, volunteer conservation hunters as part of the solution rather than ignoring them, as has been done in the past. That's my
Good
time.
advice.
All right, well, thank you. I'll take that as a comment. Thank you, Mr. Borzak. Premier, earlier this year, the Legislative Council unanimously passed a motion that under Standing Order 55, the Governor be requested to provide the police and criminal records of the mass murderer Ivan Milat. On the advice of your Executive Council, the Governor declined that request. Why did your Executive Council advise the Governor not to provide these police and criminal records to the Parliament of New South Wales?
Mr. Chair, if you don't mind, I might pass over to the Secretary of the Cabinet Office.
Thanks, Mr. Buckingham. Look, it's a complex issue, and the advice of the Executive Council to the Governor is obviously covered by Cabinet conventions, so we can't disclose the details of those deliberations in this forum. But I would say the files relate to ongoing criminal investigations, and so there would be a public interest against their disclosure in general, which is why they're covered by Standing Order 55 rather than the traditional approach under Standing Order 52.
Okay, thank you. Premier, earlier this year, the Legislative Council unanimously passed a motion that under Standing Order 52, the work records of Ivan Milat, who worked for the DMR and Water Board for 30 years, be supplied to the Legislative Council. Subsequent to this, the Legislative Council received just a few pages, almost nothing, which do not show in any way what his role was, what he was doing, and most importantly, where he worked and when. Premier, how is it that the government does not have or has not supplied these records?
Perhaps, Kate, you might be in a better position to...
Look, I'm happy to get back to you this afternoon, Mr. Buckingham, about the details of that standing order, if you like.
All right, thank you. Premier, I've got a photo here I'd like you to see. If we could hand that down to the Premier, and there's some for the other committee members here. Premier, this here is a identikit of a homicidal maniac who killed two young women at Wanda Beach in 1965, Marion Schmidt and Christine Sharrock. That's the identikit of him. The other one is Ivan Milat. Do you think they look the same?
I do.
Remarkably similar?
Yes,
Are
remarkably
you aware
similar.
that the MO of the perpetrator in the Wanda Beach killing is almost exactly the same as the MO of the Belangolo killing, abducting young women, stabbing them in the back, and then sexually assaulting them post-mortem? Were you aware of that?
I'm generally aware of the crimes of Mr. Milat, and I obviously know, having lived in southern Sydney, about the horrors of the Wanda Beach killings. I'm not. I couldn't testify that they're exactly the same or they've got a similar MO, modus operandi, but I'm horrified by those crimes, and they continue to haunt the Shire and the Cronulla community, and
They remain unsolved?
They remain unsolved. They're still incredibly alarming, and I'm sure the family of the women who were killed would be desperate for answers, notwithstanding the fact that it's decades ago.
Yes, it is decades ago, but just for the record, you think that those images are remarkably similar?
I'm concerned that they are incredibly similar, I do take your general point that if there's government information that can shine a light or a spotlight on further investigations, or even advocacy on your part can prompt somebody with some kind of information about these horrible murders, then I think it's worthwhile. I'm also conscious that there's been remarkable advances in cold case investigations, primarily as a result of DNA links. There's specific ones coming out of America that have resulted in what had previously believed to have been completely unsolvable murders that have brought justice and a peace of mind to victims and their families. So I don't dismiss it automatically. I understand the interest. I'm concerned about the likeness here of these two images. I was unaware of that. And let me take on notice your questions about the information that you're seeking.
Thank you. Premier, if one of your friends or loved ones was the victim of a crime, would you want that perpetrator brought to justice? And would you want that perpetrator brought to justice even if they were serving a custodial sentence for other unrelated crimes?
Look, I would, but I mean, I can have empathy for victims of crime even if they're not related to me, Mr. Chair.
course.
I mean, I think everyone in these circumstances, when you see someone, the heartache associated with a horrible murder, I think is compounded by the fact that they don't know what happened and they're not sure who's responsible for it, and justice hasn't been served.
Thank you.
I think the other part of it is that many families and victims of crime are concerned, because the case remains unsolved, have other people been put in a similar situation, or will other families be put in a similar situation? So I don't dismiss it. I can understand the deep interest and the passion for justice here.
Thank you, Premier. Premier, senior police who worked on the task force that led to the arrest of Ivan Milat, including the actual arresting officer, the late Detective Senior Constable Paul Gordon, and Detective Sergeant Neville Scullion, have publicly stated recently that other than the Belangolo 7 who were murdered in a 2-year period, they believe Ivan Milat and others were responsible for more than 80 unsolved murders over a 30-year period. Premier, do you think it's time to inquire into the true extent of the crimes of Ivan Milat and his associates? Will your government support the calls from victims' families for a parliamentary inquiry into the crimes of Ivan Milat and his associates?
Well, let me take that on notice. Perhaps the best thing for me to do is to meet with you, and I'm with you. Would be privileged to meet victims' families. I think that's an important thing to do, to understand not just their circumstances and their anguish associated with the loss of their loved one, but I wouldn't rule it out. I think that may be the necessary next step given the scale of some of the things that you're mentioning.
Thank you, Premier. Premier, on a lighter note, say a person were to be sitting in a pub having a cold beer, reading the paper, and say to their mate, "How about that Mark Latham? Isn't he fucking unhinged?" Do you think that they should be arrested for saying that?
No.
For using offensive language in public?
Well, no, I don't, no.
Have you ever sworn in public without a reasonable excuse?
Probably.
Are you aware
I've
that...
been in the Labor Party for 25 years, so probably.
Are you aware that 500 people a year are charged with offensive language under the Summary Offences Act in New South Wales, and 45% of those are Aboriginal? Isn't it just an offence created to criminalise an over-policed minority, and that the laws are clearly outdated?
Yeah, look, it's a difficult one, and I don't have a straightforward answer for it. I think it's probably where there's a collision of rights that the law can't and finds it difficult to find an adequate settlement for. And what I mean by that is there are circumstances where it's completely inappropriate to swear, outside of school, outside of preschool, outside of primary school, I don't know, in a church foyer. I mean, everyone would accept that there is going to be a situation where decorum dictates that. Aren't
those offences caught by the offence of offensive conduct?
I don't necessarily think so, because that would necessarily be a higher bar. The evidentiary burden of suggesting that somebody, particularly with body-worn cameras, for example, is reasonably straightforward. What I'm trying to say is it's generally policed via police discretion, and in lieu of a better legal settlement, despite being far from perfect, it's probably the appropriate framework in which we moderate the public's right to swear their head off, and the rest of the public's right to enjoy their community absent somebody, dropping the the F word or even worse. And I acknowledge that in some circumstances, Mr. Chair, it's not appropriate to swear like that. And police have got to be in a position where they can restore order and some decorum in the right circumstances. So I don't think it's one of those legal situations where an imperfect situation is governed via discretion rather than law. And the law is littered with examples like that.
Thank you, Premier. We'll go back to the opposition.
Thank you. Premier, corrupt former Labor Minister Eddie Obeid has been released from jail today. Can you tell us that since you wrote to the Crime Commission in May, what further steps have been taken, if any, to retrieve the $30 million of ill-gotten gains from Mr Obeid, or the Obeids?
Yeah. We've had deep discussions with the Crime Commission, and we're anticipating potentially legislative changes soon to strengthen their position in relation to this matter. We're very serious about what I would regard as the public's confidence that incidents of proven corrupt public conduct does meet the necessary reason for having the New South Wales Crime Commission. So it's an area of the law that I think is ripe for change. Recent examples indicate that that's absolutely the case, and you'll hear more soon.
Can you foreshadow what that legislative change looks like?
Are we in a position to do that?
I think if you review the Crime Commission's report on Operation Jasper, it highlights some of the challenges that the Crime Commission faced in terms of the evidentiary burden on the Crime Commission with regard to the recovery of criminal assets. So that is a good indicator of the kinds of things, yeah.
Thank you.
Ms Mitchell. Mrs
Thanks,
Mitchell.
thank you, Chair. Premier, I just want to turn to the local small commitments allocation program again, which I've raised with you before. We've had documents provided to the House now which actually finally reveal the initial and true election commitments made by the Labor Party. Did you direct your ministerial or Premier's office staff to make changes to those election commitments before providing the public service with the final list?
When you say direct changes, what do you mean?
So there are changes from the initial list that has been provided through the House and some of the payments that have gone out. We talked about the Sydney electorate previously. There's a few other examples. I'm asking, did you direct your staff to make changes to the election commitments and the list that was provided to the public service?
I mean, so I don't have any recollection of doing it post-election. The only reticence I have, or I guess reluctance I have, is that it may well have been the case during the election campaign that a candidate or a mayor or somebody said, I think this would be a good initiative in Muswellbrook or Tweed, and I might have said, well, that'd be perfect for the local small commitment.
But post-March, post the election,
no, I don't
can't recall
no,
giving any direction.
No.
Did you or your staff change the funding allocations after involvement of lower house independent MPs?
Change the allocations.
Yes.
I'd have to take it on notice. I can't remember.
Did you direct your staff to misrepresent to the Premier's department that projects suggested by independents after the election were election commitments?
No, I mean, clearly not, no.
So we know that there have been changes, as I said, to the list. We also know that we heard evidence from Cherie Burton, who works in your office. She told the Parliamentary Accountability and Works Committee that these were all absolutely election commitments. We now know that that's not true, so her evidence directly conflicts the documents provided to the House.
Why is that untrue?
Because she told us that the election commitments were absolute. We now know that that's not the case. So are you concerned that one of your senior staff has misled a committee?
I mean, I just want to get to the bottom of it. What did she say? Have you got the
So
quote?
she said to us, I asked her when we had the committee in March, that she said all of the projects were election commitments. I said they were nominated from Labor candidates. Her direct quote was, absolutely as election commitments. Right. We now have an initial list or an earlier list from March which we've had provided finally through a call for papers after many, many iterations, and there's a discrepancy. The figures don't add up and the projects aren't correct. So
According
my
to
question
who?
to you is, according to the documents, Premier, that have been provided.
Referencing what in particular?
So there are a number of seats where
I mean,
the
you'd appreciate
pre-election
I can't just
commitments.
take it face
Well, with
value
respect,
that it doesn't
Premier,
add
there
up.
are a number of seats where the pre-election commitments do not match up with the funding that has gone out
According
the
to
door.
who? What seat?
According to the documents, Premier. I'll give
would
you an
you-
example, okay?
Yeah,
the
please.
seat of Wallandilly, pre-election, March 2023, the documents that we've had provided, says New South Wales Labor will deliver up to $400,000 to local councils across the electorate towards upgrades to playgrounds and parks. That was in March 2023. You've said there was no intervention from you or your office. You can then now go on the list of the money that's gone out in the seat of Wallandilly, Thirlmere Tennis Club, Friends of the Hill, Top War Memorial Hall, the Fire Brigade, a
Well, that's
soccer
a good
club.
thing, isn't it?
But that's not what the election commitments were. So my point to you,
The
Premier,
War
is...
Memorial? Why
your
can't we- why shouldn't we be
Premier,
giving money to the
Premier,
War Memorial?
My question to you is, your senior staff member, Cherie Burton, has lied to the committee
Oh, well,
under
that's an
oath.
outrageous
Well, it's
allegation.
true because the
Will you
documents
say
speak
that
for
outside this
themselves.
committee
The
meeting?
documents speak for
Order,
themselves, Premier. Were they lying at your request?
Mrs. Mitchell, order. I
You know, I
remind
think that's
the
a- I think
member.
that's a
I
pretty
remind the
outrageous
order,
statement.
Premier. Order. I'd remind the member, Mrs. Mitchell, of adverse mention of people who are not here.
Say
to
that
defend-
outside the chamber.
Yeah, order.
Well, the documents
you
speak for
don't.
themselves,
I bet
Premier.
you don't.
Documents
Premier,
speak for
order.
themselves.
Call the Premier to order for the first time and Mrs. Mitchell for the first time. While I appreciate the members' efforts to, interrogate this
Why
issue,
would you appreciate that?
the member should avoid adverse mention of people who are not here
Chair,
to
why
answer
should that
the
be
questions
appreciated?
or defend themselves.
Well, the truth comes out.
Oh, you
So,
won't say
what
it
happens.
order,
outside this chamber,
order.
which I
So
think
rather
I
than
speaks
don't
to
need
comment,
to. The
integrity on this
documents speak
issue.
for themselves,
Order.
Premier. They're there.
Could you
Sorry,
please
Chair. I
proceed,
apologise.
Mrs. Mitchell, by asking some questions?
Thank you, Chair. So just to be clear, Premier, did your office advise the Special Minister of State about the role of any lower house MPs, particularly
I don't
independent
know.
MPs,
I mean, if
in
someone
nominating
came and
projects
said,
and funding
should we
amounts?
give money to a local war memorial
That's not the
or a
question,
swimming
Premier.
club or a
My
tennis club? I
question
think that'd be a good
is,
idea.
you've
And I also
changed
think
Order,
if you
Mrs.
really-
Mitchell.
after the
Order.
election. You can't
Order.
hide
If you were
Mrs.
genuine
Mitchell, you've
about
asked
this
a question.
and you were going to defame
Premier-
private... No, Mr Chair,
Yeah.
please. I'm
Yeah,
entitled
well,
to
I'm
give
just
an
trying to
answer.
regain some decorum and order here. There's constant interjections from Mrs. Mitchell. It's impossible for me to hear what's going on, and for Hansard to record what's going on. So please, let's have questions and answers
you.
rather than...
No, I'm in the middle of an answer.
Yes,
mate.
I
Yeah,
understand,
thank you.
Premier. So
Mr.
please proceed.
Mr. Chair, I think in the circumstances, someone saying that money for a tennis club or a war memorial is a good idea. I'm struggling to find out why.
So,
And
Premier,
as far as calling someone a liar, I think that's pretty outrageous.
Well, the
I mean,
documents speak
we're
for
all
themselves.
politicians. We've got a microphone. We've got an ability to defend ourselves. I think this is a pretty new low.
So
But
can
anyway.
I just ask, Premier, the guidelines to this program made it clear that these projects needed to be an election commitment. There is now evidence through documents provided to the House that that is not the case. For
Well,
a
that's
number
what
of
you say. I
seats.
don't know whether that's
well,
the
it's
case.
true. Did your office play a role? Did you advise the Special Minister of State to change these commitments based on requests from independent members of Parliament?
Look, if I have to take the specifics on notice, but if someone came to us, whether it came through the Premier's discretionary fund or the local small commitments fund for a jazz festival or a war memorial for a tennis club for the... I mean, why are we picking on the men's shed?
I'm not picking on, but I'm
That's a good-
picking on
that's a
your
good
office
initiative.
and you
Well, you are picking on my
ignoring
office. I think
grant
that's- I think you've
guidelines.
belled the
if
cat
you
there.
feel like it, well, you've ignored grant guidelines post-election.
I don't think we have,
curiously
no.
in independent seats that you need to help form government. Like, it's not a coincidence, Premier. Can you sit here today and say that nothing was changed after the election? There were no political favours done. You delivered, or your government has delivered, everything that was in your pre-election commitments under this fund as per the guidelines.
I think we're working hard to deliver on all of our election commitments. As for political favours, I mean, it's just another wild conspiracy theory.
Well,
But
documents
I
are
think
pretty
ultimately
clear,
the
Premier.
local small commitments allocation was about, for lay people that don't know the background, when we were really faced with a situation where there'd been a persistent almost machine-level industrial effort to funnel taxpayer funds to National Party seats.
Premier, I'm
And
asking
Mr.
about
Chair,
a
I'm
program.
sorry,
Order,
I'm really
Mrs. Mitchell.
entitled to get
Yeah,
an answer.
no, I
This isn't
understand.
what I asked about.
It doesn't, well, it
You
is.
asked the question, the Premier's answering the question. Premier, please proceed.
And Mr. Chair, in those circumstances, we were faced with a situation where I think 22 out of 23 bushfire grants went to coalition seats, and I thought that was the most shocking of all. I
Have a
would have
look at
thought
these
that,
documents, Premier.
Mr.
You
Chair,
might be
can I-
pretty,
is there a
pretty
chance I could
shocked
get
by
an
what your
answer
own
out?
lot's
Yeah.
doing.
No, 30
Order,
seconds to
remind
get an answer
Mrs.
out.
Mitchell she is on one call to order. Please allow the Premier to answer the question.
I mean, we're faced with a situation where 22 out of 23 bushfire grants went to coalition seats. And I remember speaking to the member for Blue Mountains who had an enormous destruction in her community during the Black Summer bushfires. And she was faced with a situation where small businesses were trying to get back on their feet. She desperately went to the government of the day and said, well, I understand that you've allocated an enormous amount of money for bushfire recovery, which is a laudable purpose. Can we have some of that for our bushfire affected community? And the answer was no. And whether it was something as simple as bushfire grants or school renewable energy grants, or the most obvious one was the repurposing of local government grants for communities that were meant to have merged councils but never got them. So the theory here was to get $400,000 into 93 electorates so that it couldn't be effectively funneled into seats that the government or the opposition, we were in opposition at the time, had to win.
No, you just did that
And-
after the election.
Well, I mean,
Chair, can we just move
ultimately, I
on?
think
Because
that the
I've
money
given the
going into
Premier
those
time.
communities is a good thing.
Point
And
of order,
I
Chair.
don't think it should
Point of
be
order,
just
Chair.
ripped
A
apart.
point
I
of
did
order has
give
been
the Premier quite a bit of latitude. We're ready to move on. He's answered a lot of things that are not relevant to this year's budget papers, but if we could move on. We've got limited time, to be fair, Chair, so I think we've been pretty generous.
To the point of order.
A number of assertions were made, a series of assertions were made by Mrs. Mitchell in her line of questioning. The Premier is rightly addressing each of those and providing some context to the program which Mrs. Mitchell is being critical of.
Yes, I don't uphold the point of order. The Premier is answering, fully the series of assertions and questions you made. So, if the Premier has concluded, is there another question?
Yeah,
Mrs.
hand
Mitchell.
over to my colleague.
Mr. Tudor.
Just in that same line, Premier, did members of your staff receive ex gratia payments in relation to covering their legal costs for the purposes of appearing before the Dural Caravan inquiry?
I don't know if it was ex gratia payments, but I understand they got legal support, but I don't know what form it took.
Ms. Boyd, did they?
Yes.
It was an ex gratia payment.
Yeah, they're entitled to that under the...
So what was the criteria for the making of that ex gratia payment?
Oh, it's set out in a Premier's memorandum, which I can give you the details of on notice, if you like. But all public officials that are called to inquiries and other...
Inquiries or legal proceedings?
Both, in their capacity as officials, are entitled to make an ex gratia request.
Isn't it the case that to be entitled you need to, in fact, be involved in legal proceedings or legal proceedings?
Weren't you threatening to throw them in jail? Wasn't that the story? I would have thought a lawyer in those circumstances is reasonable.
Legal proceedings, Premier.
I could have sworn at the time you said you're going to throw them in jail if I don't.
It might be
if I don't
something
attend.
it might be something which avoid it, but then an inquiry is not legal proceedings. It is an inquiry.
Well, sorry,
It covers
Kate.
inquiries as well.
I think in the circumstances, I don't have automatic recall, but I could have sworn that at the time you or your colleagues were saying that they'd go to jail unless they appeared at the inquiry. I would have thought that's a reasonable basis for a lawyer.
Well, I didn't.
Are you a lawyer?
Order.
No, I'm genuinely. I'm shocked.
Order.
Who signed
Premier.
off on those payments?
The
okay.
attorney has the function under the relevant Premier's memorandum. So the Department of Communities and Justice sort of administer that ex gratia
But
scheme.
in relation to that, the government has access to the Crown Solicitor, do they not?
That's correct.
Have access to the Solicitor General.
Yes.
Why was it necessary to go to a private firm of solicitors to
You'll-
obtain that advice?
The Crown law officers are primarily there to act for the Crown, and in this case, the individuals had individual rights and issues that may have conflicted with the Crown, so the decision was taken to provide to obtain independent legal advice for those witnesses.
Had the Crown Solicitor provided any advice in relation to their obligation to attend before the inquiry?
I'm not at liberty to disclose that publicly. It's privileged. Yeah.
Premier,
I mean, bloody hell, you know, at the time, in
Premier,
all fairness, just in relation to the last question.
Order, Premier, you could be arrested for saying that.
Premier,
Can I just say in
No,
relation to
it's
that?
under
I
the
think
Summary
it's
Offences Act.
I think it's
I'll
really-
remind you.
He's got privilege.
Yeah, you do have privilege actually. So.
Mr. Chair, just in relation to that last line of question, because I think this is important. I mean, the context is important here. Regardless of whether people believe that staff should be pulled before this upper house inquiry or not, or that inquiry or not, it was unprecedented. There was a threat
No, it
throwing
wasn't.
them in jail.
No, it wasn't.
The circumstances were that
what
my
the Act
staff were
says.
grilled for hour upon hour upon hour. And now we're hearing they shouldn't have even got access to a lawyer. I think
No,
that's a bit
I-
over the
I'm
top,
just-
Damien.
I'm
And if we
just-
want young people in particular to join ministerial
Everyone has access
staffing
to a
ranks
lawyer.
or the public service, then the minimum should be applied.
Premier-
the minimum level of fairness. And I think if you're going to
Premier,
press that point, I think it's a real mistake from you,
Thanks
Damien.
for your
Yep.
thanks for your advice.
Some unsolicited but
So
I think
just
necessary advice.
Premier, do you post on TikTok regularly?
I understand that I do, yes.
You
but I don't personally.
Do you have an app on your device?
No.
You don't have it on your device.
No,
but
I don't.
you-
I actually don't have. I don't have any social media apps on my phone. I find it distracting.
Do you have messaging apps?
Yes, I do.
Yeah, which ones?
I'd have to take it on notice.
Well, do you have Signal?
Check your phone.
Well, I'm not going to check my phone now,
can
but I think I've got all of them. Yes.
So you got Signal, you got WhatsApp.
I'll take it on notice.
Well, Telegram, of course, you wouldn't have, would you?
No, I don't think I've got Telegram. What's Telegram?
Well, it's another one of those. I don't have it either, but I understand.
Have you got Signal?
Huh?
Have you
I've
got Signal?
I've got Signal. I've got Signal. In fact, you've sent me messages on Signal. So,
Oh, there you go. Well, you know then.
So in relation to WhatsApp, do your ministerial staff use Signal and WhatsApp?
You'd have to ask them. I think so, but I'm not sure.
Do you ever send messages to ministers or ministerial staff using Signal or WhatsApp?
From time to time.
Do you retain records of those conversations with ministers, which are conducted over Signal or WhatsApp?
Oftentimes, in relation to a chat, someone will put a expiry time on it. So sometimes yes, sometimes no. I don't know.
Well, have you ever taken a screenshot of a conversation which you've had with someone over WhatsApp or Signal?
I might have. Like if my wife says, "You can you bring home the milk?"
You take
and
a
I say to
screenshot
her-
of that?
Well, and then I don't bring home the milk, and then she says, "I asked you to do it," and then I say, "Well, I don't have any record of that." Then I might screenshot it and then text it to her to prove.
Well,
that
you
it
might be
wasn't.
trivialising it by that, but I want to ask you.
Trivialising
Ms.
what?
Boyd-
What questions are you
Boyd-
asking?
Ms. Boyd, what are the obligations of ministers to retain records pursuant to the State Records Act in relation to their correspondence with each other?
Look, those obligations are set out in the State Records Act. You've obviously got an obligation to keep full and accurate records of the activities of the office, but you're not required to keep ephemeral messages.
Not required to,
To keep ephemeral messages.
and that includes messages over messaging apps, does it?
Yeah, it includes messages that aren't of continuing public value. So if
And
you,
how do ministers decide that?
well, I suppose if our advice, which is on the record to ministers, is that when they make a decision or take any official action, they should be confident that there's a written record of the reasons for that decision or action or instruction or advice. But if you're just having a chat with someone on Signal, there's no obligation not to dispose of those ephemeral records.
So have you ever had a conversation with a minister over WhatsApp which in fact is a direction or a decision made between you and a minister or Signal?
Not to my recollection, no.
Do you have ministers as part of WhatsApp or Signal chat groups?
Ministers?
Ministers or
Yeah, perhaps.
or
Yeah.
Or staff
Yeah, perhaps.
Or-
yeah.
bureaucrats?
I don't know about bureaucrats, but I'd have to check.
Well, in respect of those apps, do you have disappearing messages activated in relation to that messaging content?
So, like in some instances, yes, because that's the terms in which the moderator might have sent an app. But that would be the case for work colleagues, family, friends. I think everybody that's got a Signal app or a WhatsApp app or a text message app or a
Well, given that these are conversations between
Samsung
ministers,
app. But we're also cognizant of our responsibilities to hold on to information where decisions are made.
Well,
Generally
would
speaking,
it
sorry,
surprise
Mr.
you
Chair,
to
can
know?
I get an answer out?
Sure.
I mean,
Yeah.
generally speaking, those decisions are made in formal meetings in Cabinet. That's when we make
Premier,
those
would it
calls.
surprise you to know that in respect of documents to be produced pursuant to Standing Order 52 for various issues which have risen and provided to the House, I have never, and to the best of my knowledge, never seen a shot of a conversation on WhatsApp or Signal as complying with that order to produce
You know,
documents.
that doesn't surprise me because I remember SO 52s that applied to your time in office, and I never saw a Signal message from you either.
No, I probably never saw one from me ever.
Well,
because-
you disclosed earlier on Signal.
Yeah, but that was so I could get
Oh,
messages from you,
right,
Premier.
I see. There you go. So it doesn't surprise me, no.
All right, thank you, Premier. Thank you, Mr. Tudor. Mr. Borzak.
Thank you, Chair. I'm going to go to something a bit more vexing, Premier, and that's housing. I'm sure you're all over this particular topic. You would note that concerns from the New South Wales Productivity Commissioner, who has warned that if we don't act, we could become a city with no grandchildren. In other words, between 2016 and 2021, Sydney lost twice as many people aged 30 to 40 as it gained. 35,000 came to Sydney and 70,000 left. What key measures are you implementing to try to fix this?
Yeah, I think it's the problem of our age, and I think it's a massive challenge for Sydney in particular, but not just Sydney. Kiama, the south coast, the north coast. If we can't provide housing for young people in particular, they will vote with their feet and they will leave. And you know, I've looked very closely at the statistics here. The Baird government, for a period of 2 or 3 years, became nation leaders when it came to building, and it was hugely important in the run-up to the COVID period that we met those targets. We were producing sort of 65 to 72,000 houses a year, completions a year. We need to get back to that number.
Well, is it true to say that our current planning laws stand in the way of getting a lot of that stuff done?
I really believe that they do. Yes, I really believe that they do. And I want to give a shout out to Mark Speakman in particular, who said recently that and we've had constructive discussions with the opposition about major changes to the Planning Act in New South Wales. I think he deserves credit for engaging with us on those questions. The best thing to do, in addition to the Housing Delivery Authority, to the transport-oriented developments, to the changes to R2, R3 zoning changes, to pattern book housing, and all of the major reforms that the Minister for Planning has implemented over the last 18 months, to embed it and go even further in a bipartisan or multi-partisan Planning Act would be hugely beneficial for New South Wales, and it would do a number of things. Firstly, it would give young people an opportunity to have a house and a place to live in an expensive city like Sydney. And secondly, it would mean that you're bedding down into the foundations of the state, the planning system, and that means more capital will come into the housing system, more capital will be deployed to build multi-unit units and apartments and more housing, because everybody knows the rules of the road. You'll know that it's not going to change if it's a multi-partisan effort. So I'm really hopeful we can get a key breakthrough here, depoliticise it and actually give people an opportunity to live in Sydney.
I noticed that Mr. Speakman did offer support, but can you elucidate in terms of the planning system what you've got in mind?
I mean, in short, yes. I think that we should we should permanently put into law the Housing Delivery Authority, particularly for volume builds, particularly along public transport lines and major heavy civil infrastructure. I think that we should have more deemed approved housing in Sydney. You've got a situation where John's been a leading figure in relation to this. He's spoken about it passionately in the past, but we've got, what happens is when a builder goes to deploy capital to build a new apartment or a townhouse or a villa, they have to run through the gauntlet of local government, state government, and about 1 billion different planning acts to get an outcome. And if we can move through that and get a common sense approach, then I think that we'll build more for Sydney. And I mean, the consequences of not doing it are terrible, terrible.
Yeah, Mr. Premier, I'm quite aware, for example, of what Nathan Moran is trying to do with the CEO of the Sydney Local Land Council. He's got major developments he's trying to get across the line in the northern suburbs and all over New South Wales, really, and he's having major problems trying to get things done. Can you and this is on Aboriginal land that they own. They just simply cannot get these things through the planning process.
Yeah. I'm at a little bit of a disadvantage in relation to a couple of, or one in particular, because it's right in the middle of assessment by, I'm getting ahead of myself. There is a major initiative that's being pursued by the Metropolitan Aboriginal Land Council on previously Crown land, that is Aboriginal land, and there is a proposal for new housing on that site that's been assessed for bushfire risk by the New South Wales government. And I don't have an announcement or a breakthrough in relation to that. We're looking at it incredibly closely. The Secretary of the Premier's Department has just indicated to me that he's meeting Nathan and I think the leadership of the Metropolitan Aboriginal Land Council. But we're at a pointy end of the decision there, and I'm not
asking you for a solution now. I'm just raising it as an example that one's been around since 2022, and it doesn't seem to be moving anywhere. That's all. No,
you're right. I don't have an excuse. It isn't moving. It's a problem.
What other initiatives have you announced in the recent budget that would cover the drive of increasing the supply of housing?
Well, the government announced. Kate's helping me with this. Thank you. Look, in addition to rolling out the $5 billion of social housing and the $1.2 billion for maintenance and repair of the existing social housing stock, we anticipate that we'll build 8,400 new social housing dwellings in New South Wales. Urgently needed, and probably we need to go even further and do more. But when you've got the second most expensive city on earth, and your deployment of social housing has in fact dropped over the last decade. So while the population's increased by, say, 30%, our social housing stock's actually declined, not in real terms, in actual terms. So we're doing two things at the same time, trying to make up for a decade's underinvestment in social housing and then add to the stock beyond that. We've allocated, say, $6 billion, more than $6 billion to that effort, but Robert, I reckon we need to go even further. There's other more bespoke initiatives. We've put $1 billion aside for a pre-sale finance guarantee where we would effectively step in if off the plan housing just doesn't get to the final number to allow the financing to roll to get the building constructed. That's in its early stages. Patent book, I think, is an exciting initiative. I mean, if you are in a zoned area where, and this, I think it covers 60-70% of metropolitan Sydney, and you grab one of the patent book designs, then you can get construction approval inside 7 days. And that's just getting off the ground. We've bought the designs, the government's bought the designs. So an individual, a member of the public, can go and buy it for $1.
I was going to come to the scheme, Premier, a bit later in the questioning, but I mean, why would the New South Wales taxpayer underwrite these this sort of scheme privately guaranteeing these developments?
Mainly because, a mixture of things. I think high interest rates, high inflation, and the stack. And what I mean by the stack is the financing that major builders need to press go on a development. We're just falling the wrong side of. Now, we don't believe the $1 billion that the government's allocating will be self-perpetuating. It's not going to come off the budget. I mean, we anticipate that we'll continue to reinvest it into new homes, and the government owns an asset too. If we decide to go as the guarantor of, effectively, not for the entire building, but for one or two, that's enough to tip the developer into going ahead with construction. We anticipate more capital coming into the system. It's part of the innovation that we have to look at, because I would argue that we have to pull every lever at the same time. That we're now in a situation where it's not just going to be local government, it's not just going to be the state government, it's not just going to be state government planning decisions through our various agencies like the EPA, Heritage, Environment, the RFS, the SES, flooding. We have to do everything at once, and we don't have a minute to lose.
Yeah, so what are you? I suppose you're saying that the market wasn't working.
The market was shy about investing in New South Wales because the cost of time was so extreme. I mean, you've got a situation where New South Wales, or Sydney in particular, has the highest house prices, the highest rents, the highest increase in rents, the highest increase to house prices, the largest number of young people fleeing the jurisdiction.
And the longest period for approval.
The longest period of approval, and yet we're producing 6 houses per 1,000 people every 12 months. In Victoria, they produce 8, and in Victoria, it's 9 houses per 1,000 people every 12 months. So notwithstanding the fact that we've got the steepest and most difficult housing challenges, we're also producing the lowest number of houses.
Thank you, Premier. We'll now turn to questions from the crossbench, and just to remind crossbench members, I'm going to go through in series, one each, as you came. So I'll start with Mr. Ruddick.
Thank you, Chair. Good morning, Mr. Premier. I'd like to raise what I suspect is one of your least favourite subjects, which is compensation for the new coal shareholders. So before your time in Parliament, a mining licence was withdrawn from new coal, and the Parliament then passed a law forbidding that the government would ever pay them compensation. A couple of years after that, ICAC looked into it. Justice Rothman said ultimately the Commission came to the view that the plaintiff, New Coal, as an entity, was not involved in any wrongdoing, and he said that they were wholly innocent. In 2019, the Legislative Council had an inquiry, and that came to the view that, yes, the New Coal shareholders are innocent people who have had their property taken off them by this Parliament. Now, what has recently come out, when I'd like to table this, Mr. Chair, is the 2025 National Trade Estimate Report, which is from the US Trade Representative, presented to the President of the United States, talking about investment barriers in Australia. And it says, this official report says, to date, the New South Wales Government has not acted on the Parliamentary Committee's recommendations to private shareholders to provide shareholders, including US investors, with recourse to seek compensation. Now, at some point, Mr. Premier, you and I know that our Prime Minister, your friend, Mr. Albanese, and President Trump are going to sit down and have a discussion about tariffs. Media reports suggest that this issue of New Coal, which was blatant theft, I know it was not your fault, sir, but it is now your problem. And the media reports say that this is going to be a stumbling block. The Commonwealth has said that this is a New South Wales problem, and New South Wales has got to fix it. We have in the past paid $110 million and $220 million to mining licences that were cancelled, and they got compensation. So, Mr. Premier, I believe that compensation payment is inevitable. I believe it's going to harm Australia the longer this drags out. So my question is, when will you pay fair compensation to the long-suffering shareholders of New Coal?
Well, look, I take as read the evidence that you've indicated in your question. I don't have plans to do that. I realise that that's disappointing to New Coal investors and those that are interested in Justice Rothman's determination, as well as the ICAC finding. And there's a reason for it, and that is the estimate in terms of the compensation is approaching $500 million. At least that's the evidence that I've got.
Yes, I agree. But Mr. Premier, we can't deprive these people of fair compensation just because it's a high bill. Because what it's going to do is it sends a very bad message to investing in New South Wales. We become a sovereign risk. It's going to cost us more money by not paying that.
Well, I think that there's strong evidence to indicate that we're not a sovereign risk. I mean, if you look at our stable democracy, our property rights, our independent judiciary, the fact that notwithstanding this environment, largely we've got a stable political environment, we're increasingly becoming an incredibly attractive place for foreign investment and capital deployment in Australia. And I don't think, given the longevity of this issue and how often it's been prevalent in the media, it would indicate that it is a threat to the status of New South Wales as an investment location. You know, speak to Damien, speak to the previous government. People want to invest in this state. The circumstances relating to the original legislation that was passed, I wasn't a member of Parliament, John. I wasn't here at the time. And maybe, you know, if accept the evidence that you've presented in relation to it, but my problem today is finding $500 million when I've got major challenges for Western Sydney health departments, and I've got a police force that we need to fund, and I've got a rail system that we need to upgrade and ensure works. It's an enormous amount of money.
Thank you, Premier. Thank you, Mr. Ruddock. Dr. Con.
Thank you, Chair. Good morning, Premier.
Morning.
In response to a question from the opposition this morning, you said if we were going to have a parliamentary inquiry in healthcare, it should be into the privatisation of hospitals. Northern Beaches Hospital isn't the only public-private partnership in New South Wales Health, and the government is dealing with Northern Beaches Hospital. The Greens have strongly supported your action there. Does that mean you'll support a parliamentary inquiry into public-private partnerships at New South Wales Health other than the Northern Beaches Hospital, because there are many?
Look, I wouldn't automatically support a parliamentary inquiry. I mean, I think that sometimes they've got value. Sometimes they can be sidetracked by, internal political divisions and grandstanding. I am interested in solutions, though, and I think we have been heartened by the Greens' advocacy. I want to acknowledge your position in relation to Northern Beaches Hospital, as well as the Greens' position in relation to the privatisation of hospitals more generally over the previous decade. I'm not wiping that away. In terms of parliamentary inquiries, they're not really up to me. I mean, ultimately they're established usually by the upper house, whether the government wants it or not. My job, however, isn't to establish parliamentary committees, it's to get on and try and solve these issues. And I just made the point earlier, Dr. Con, that we believe we're doing that, and I think we've got support from the Greens in relation to this, investing in Western Sydney hospitals, particularly Rouse Hill, removing the wages cap, again, an issue that the Greens have been supportive of, removal for a long time, and stopping privatising government hospitals.
Thank you, Premier. Ms. Boyd.
Thank you very much, Chair, and good morning, Premier. New South Wales is still in a domestic violence crisis. Last year, New South Wales recorded the highest number of gender-based murders in the country, and Boxar statistics continue to show an alarming rise year after year in reported domestic and family violence-related incidents. We know that victim survivors are waiting an average of 2 months to receive support, with many across the state having wait lists much longer than that. As you know, the domestic and family violence sector has been calling for a 50% uplift in the core baseline funding for specialised frontline domestic and family violence services, because they haven't seen an increase in their funding for many, many years. It would have equated to a mere $163.1 million in your budget of $127 billion. Yet in the latest budget, this government once again did not fund those services to the level required. They make the difference between life and death. Will you fund those services?
We're looking at it very closely. I met with Domestic Violence New South Wales recently in the last few weeks. I think you'd acknowledge that the government has allocated nearly $300 million extra in domestic violence prevention programs across New South Wales in the last 2 years, admittedly not to the NGOs and organisations that run those services, but there's a big need for it. I don't dismiss that, and we're actively engaged in talking with them now.
Thank you. Ms. Higginson.
Thank you. Premier, on the 6th of May, you accepted the award from the President of Israel. And at that time, on the 20th of September 2024, the UN had made it very clear. The Special Committee found that Israel's warfare methods in Gaza are genocidal, including using starvation as a weapon. Can you see that your actions on the 6th of May, which then followed your own op-ed being published, can you see that that was, for many people, a threat here to the social cohesion of our communities across New South Wales and Australia?
Look, I didn't accept any award. I don't know what you're talking about.
So no presentation that you're a great friend to Israel and...
I think did you say I accepted an award? I don't think I've got any awards, certainly not since I've become Premier.
An accolade, some kind of presentation to you as a friend of Israel at that time.
My
on the 6th of
understanding is
May.
that I have to take it on notice, but my understanding is that the President of Israel wrote to me and the New South Wales government. But that, I think, in fairness, Sue, that's very different than accepting an award, and presenting it like that is a bit of a misrepresentation.
So you think then the letter presented in a frame by the Israeli ambassador is, and the question is, Premier, it's about, do you see that many people in New South Wales saw that as a threat to social cohesion here in New South Wales, given what had happened in relation to the UN's clear declaration that Israel's actions are genocidal actions, including using starvation?
Well, I think in the circumstance, there's a few things I'd say. If there's an aspect of my speech to that forum that you disagree with, I think that'd be reasonable. I don't know if you've got it on you.
I've got the speech. It's about, the question is, Premier, do you understand that many people...
I think you're asking me to put myself in the body or the minds of other people. I can't do that. I mean, ultimately, that's a decision or a judgment for them to make. Is there something...
Do you regret doing that at this point?
Is there something in the speech that you disagree with or was wrong or incorrect? I mean, I think that would be reasonable criticism.
Thank you, Premier. We've now got a couple of minutes left, so we'll go to the opposition, Mr. Tudor-Hope.
Thank you, Chair. Premier, who did you consult before directing the Statutory and Other Officer Remuneration Tribunal to award a 10.2% pay rise to 6
Sorry,
secretaries?
I can't hear this talking.
Yeah.
I'm sorry.
Can we repeat the question, please? Sorry. And
louder, Mr. Tudor-Hope.
well, it would help if there was
sorry.
weren't conversations running.
Premier, who did you consult before you directed sought to award a 10.2% pay rise to 6 secretaries?
I think I had a conversation with Simon and senior public servants in New South Wales.
Did you have any discussion about KPIs or performance reviews relating to that increase?
No. I mean, in terms of performance pay or a bonus or things like that, I don't think that we didn't agree with any of those things. I think there was previously secretaries were given, we were talking about this the other day, previous secretaries were given a bonus if they met certain thresholds or performed in a particular way, and I just think that's a silly way to run a public service. So I think we had a discussion about that, but no, we're not going down that road.
Thank you, Premier. Premier, as a self-confessed AC/DC fan, can you finish these lines?
Okay.
It's a long way to the top if you want to...
Rock and roll.
Correct. For those about to rock...
We salute you.
Correct. A whoa, 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 whoa.
That one, you got me.
I don't know that one.
The answer is thunder.
Oh,
see
mate.
me right
Come
out
on.
of
You've got
the...
to sing it, Jez. We missed
See
the
me
context.
right out of the sunset.
Oh, that's a Bon Scott song.
Sorry. 2 out of 4. Have you got your tickets to the AC/DC concerts?
I don't, no.
No, 0. And where is the public memorial that you've promised to the greatest rock and roll band in the history of the universe? Where is it? Where is the public recognition of ACDC that you've promised?
Did I promise it?
I think you did.
Right.
You said watch this space.
Okay. Well,
And there's a lot of space and there's a lot of watching.
well, I don't have imminent plans for an ACDC memorial, Mr. Chair.
We've got a fountain court out there. We could stick.
Yes. There's one in Burwood, isn't there? Oh,
No.
We've talked about you. Where is it? Ashfield.
No, Burwood's got a proposal.
Oh, okay. Burwood's got a proposal for one.
Simon's an ACD.
Oh,
He might know.
Burwood has a proposal for it. Well, that's news. All right. Well, thank you very much. There's no questions from the government. Well, in the absence of questions from the government, we are going to have a 15-minute recess. We will
30 minutes.
Huh?
30 minutes.
30 minutes.
30-minute recess. Really?
Butters will
The
be
shop
up.
stewards have intervened. It's we will be back at 11:15.
That's
Thank
why
you,
you're
everyone.
here, Butters.
12:15. You'll just have to put the signal away there, Premier. Hold on. Oh, thank you.
Put the signal away.
The time being 11:15, we'll now recommence the hearing with questions from the opposition.
Thank you, Chair. Premier, are you concerned that your government's Regional Roads Fund is being investigated by the Auditor General?
I mean, it's the role of the Auditor General. I think it's important that the Auditor General is able to do that. There's periodic investigations. Well, there's an annual investigation into all areas of government expenditure. So when you consider how much money goes into the roads budget, I think it's reasonable to believe that there'd be an Auditor General inquiry or investigation.
Sure. So successful projects weren't required to submit business cases to be eligible for funding. Is that a normal process for your government?
Can you repeat the question, sorry?
So successful projects weren't required to submit business cases to be eligible for funding. And I'm asking, is that a normal process for funding allocations under your government?
Look, it depends. I've been concerned for a long time, and I know members of the previous government were concerned about it too, because I spoke to them, about the huge costs associated with business cases. And I was amazed that what would ordinarily be a rudimentary piece of civic infrastructure or social infrastructure would have to be accompanied by a 6-month detailed investigation. And I think the Auditor General has actually spoken to the government about ensuring that if there's going to be a decision, or there's a policy decision of government, or there's a need for a particular road or project, does it really require a $50 million or $100 million business case, or even in some cases unnecessary engineering works to go ahead? I'll give you an example. I mean, some of the big rail projects are accompanied by, you'd remember this, Damien, $50 or $75 million business cases, and you think, geez, we could do a lot of good with that kind of money when there's actual no appreciable outcomes associated with the kind of money that you spend. I mean, sometimes governments, which they're entitled to do, discontinue the project, but the costs for the business case are allocated to the government. And I mean, it's not. I think that there needs to be a real look, particularly in relation to third-party contractors, often personal service firms, and their role in business cases, because it's a big spend on the budget.
Thanks, Premier. I just want to take you to one specific project under that fund, which is allocated up to $50 million, the Thornton Road Rail Bridge. There were questions put to the Minister about that yesterday. It's the single biggest funding allocation for any project in this fund. It is in her own electorate. It has not had a BCR completed. There was no business case. It's not due for completion until 2026. Does that concern you, the optics of that looking like the Minister is spending this money for her own electoral advantage?
No, I think it would be cynical to say that, particularly for a regional MP, a road project of that scale would be necessary, and that would be happening right across New South Wales.
But you're not concerned in her own electorate? No disclosures of conflicts of interest. It's literally around the corner from her place, $50 million worth of taxpayer money, no business case, no BCR. You're completely comfortable with that?
Yeah, I mean, I think if you look at the scale of road spend across New South Wales, particularly for a regional electorate, that'd be about right. I also think it'd be a big call to say, geez, the member for Maitland, who's the Minister for Roads, couldn't have that kind of spend.
I'm not saying that, but you would expect that there would be some probity around that process.
I'll just finish, Mr. Chair. I think I'm here for 3 hours. I'm entitled to 20 seconds, really. I think in the circumstances, she's the member for Maitland. It's pretty obvious who the local MP is, and that's the circumstances for road funding and projects right across New South Wales. Unless we allocate it to an upper house MP, there'll always be that general conflict when you spend money in your own seat. I'm the member for Cogra. My constituents deserve their fair share. It's understood that I live in that community and I'm also the local MP, but they shouldn't be denied it either.
But you would appreciate, Premier, given that there could be a perception of a conflict of interest, and I appreciate what you're saying, a local member who is a minister can still have oversight of funding in their areas. But wouldn't you think that there should, in that instance, for the abundance of caution, be probity around that decision, a business case, something that makes it clear that it has been allocated properly when you're talking about $50 million worth of taxpayer money?
Yeah, but the road budget's billions.
But there's
There's
Premier,
93.
that doesn't
sorry,
mean
Mr.
you don't
Chair.
have probity.
Honestly.
Order.
I think it's a bit outrageous not to give me 10 seconds to answer it. The road budget's billions, and a lot of that is allocated in regional communities. So $50 million for a road project in Cessnock, I mean, we've got 93 seats. Let's say a third of them are outside Sydney. $50 million in $1 billion project. Yeah, I'd say that's about right.
So just because the roads budget is massive, it's fine to have a $50 million project with no probity around it. That's
I mean,
the
I'll
standard
use my
that
own
you
words.
set.
I think that a reasonable person would say, yeah, I think if you're going to spend billions of dollars, $50 million allocated to a regional community is about right.
Can I ask you, Ms Boyd, what should be the process for a minister disclosing a conflict of interest in that situation?
It's not a conflict. So the ministerial code defines the conflict of interest as arising where there is a clash between a public duty and a private interest, and you're taken to have a conflict if you make a decision that confers a private benefit on yourself or your family, and private benefit is defined to exclude projects that are really there for the whole community. And members, of course, live in their electorates. That's a fundamental part of our system. So where a member benefits from a decision as a member of the community and they share that benefit equally with the community, that can never give rise to a conflict. So the code, recognises that this situation will happen and has made provision for that. So I don't believe there's a conflict.
Okay, and even when there's been no business case, nothing, or that still doesn't matter?
I think that's a separate question, and I think I just refer you to Minister Acheson's evidence yesterday before her portfolio.
I have to say, it's
Thank
pretty unprecedented, Mr. Chair, to have a National Party MP complaining about spending on regional roads. I've
I'm
never heard that
asking
before.
about
This is the first
probity
time.
around a specific project.
Well, you haven't
Premier, and I'm
established
allowed to
that there's
do
a lack
I'm
of
allowed to
probity.
do that. I'm asking you
But you
about
haven't
whether you were
established that there's a
comfortable with
lack
no
of
business
probity.
case, and you said you're fine with that because the roads budget has so much money in it. I'll move on. The Great Koala National Park, Premier, you were up in the Mid-North Coast recently to meet with stakeholders in relation to that project, is that correct?
I was.
Who organised that visit?
I think my staff, my office.
Okay. Was the Minister for Agriculture and Regional New South Wales involved with that trip at all?
I think so.
Did she travel with you then?
No, I think that she had a conflict. She was otherwise disposed somewhere else.
Okay, but normally on those sort of matters you would like her to be with you when it's to do with the Great Koala National Park?
What do you mean?
Well, given the interest in that area, particularly from the forestry industry, she's got responsibility in that space.
She does have responsibility.
So is she involved in the work that's happening with the Great Koala National Park, I guess is my question.
Absolutely,
Okay.
as is her department.
Sure. Could you provide any guarantees around the size of the park?
I'm not going to do that today, no.
When will you do that?
Well, soon. It's a election commitment from the government. We went to the 2023 election campaign promising a Great Koala National Park. We believe it's very important in terms of saving the koala population, and also I also note that a lot of the community up there and in Sydney and other parts of New South Wales, but particularly up there, are supportive of a park as well. Okay. And I also note that I saw in recent dispatches that the member for Manly and the member for Vaucluse were demanding it of the government as well. So it's an important one for us. We've got to make a decision about what it will look like, how it will operate, and I'm not ready to announce it today.
Okay. And no indication of time.
But I also just want to make the point that we did go to Coffs Harbour and other places in the Great Koala National Park catchment, and we did speak to First Nations groups, we did speak to National Parks senior officials. We also spoke to hardwood operators and small businesses, family firms that have been there for generations. And we spoke to union delegates from the forestry mills, and we spoke to Forestry Corp representatives. It was a comprehensive visit.
Okay, but we just have to wait a bit longer for the details.
Well, I'm not announcing it today.
That's fine. Yep, I just wanted to be clear. I want to take you to the issue of flood recovery now, and staying on the Mid-North Coast. Sure. Have you had any briefings recently or any updates in terms of the support, whether or not it's reaching people who need it?
I do get regular updates. And the latest information I had was that there'd been, certainly for category C numbers, there'd been, actually I've got the figures here. I saw it last night. Just give me a second.
Sure.
As of the 31st of July, 53,000 applications have been received for personal hardship. 44,560 have been paid. 112 have been approved but not yet paid, which totals a reasonably small amount of $30,000. And 4,900 applications are progressing but haven't been completed. And 4,000 have been declined or not approved. So we've got about, say, 5,000 where a decision hasn't been made, 45,000 where it's been approved, and 4,000 that have been rejected.
And that's the personal hardships. Do you have the figures for primary producers or small businesses? And you can take it on notice if you don't have it here.
I do. I wanted to look it up on my own note. I swear I'd seen it. Oh, yeah. So category D, primary producer assistance, there's been 852 applications, and I don't have a number on how many have been approved.
Okay.
But the number of applications, the cost is approaching $10 million.
Sure. I just want to take you to that issue of them not being approved, because there's a number of primary producers who have been in touch with us. Some of the examples, Wade, who's a dairy farmer just outside of Kempsey, he's spending $1,200 a day for hay. He's been waiting 6 weeks for a response. Jack, a beef farmer from Kempsey, has got about 1,000 head of cattle. He applied for a grant as soon as they opened, still waiting. Matt from Brighton Oystons, who I believe you visited his lease, again, they're still waiting. It's been 13 weeks. Are you confident that people are getting the support that they needed, given there are multiple examples of people who are still waiting weeks and weeks after the most devastating floods they've ever experienced?
Look, I was confident based on the number of applications that have been progressed, the amount of money that the government has allocated to the flood assistance package. But I'd also take it at face value if you're telling me that Wade and Matt and others haven't received assistance. I'm just going to see if I can get a breakdown of the nearly 900 people who've applied. What percentage of them have been approved? I'd be interested to know of the number approved. Sorry, just in relation to Wade and Matt, and there was another farmer, Jack. Was their application assessed and rejected?
No, they're still waiting. That's the point.
So it's
but the
no,
point
I'm just
is
trying to get.
But it's been weeks and weeks.
No, I understand that.
I understand
but in order to
there's
get you
money
an accurate
available,
answer,
but if it's not hitting the
I'm not trying
ground,
to be tricky here. I'm
Neither
just
am I.
genuinely trying to find out. So these are applications that have been put in, but there hasn't been a determination.
That's right. So things are just taking a very long time within the RAA, and I think people on the ground are getting very frustrated because they're not getting that money flowing. And you saw it for yourself, and I'll acknowledge that you were up there. But the concern comes when that money that's allocated doesn't end up flowing to these communities as quickly as they need it.
I don't dismiss what you're saying.
Sure. Well, if you can come back with some details, particularly around the numbers that have been approved, that would be great, and I'm happy for you to do that.
I mean,
on
I
notice.
think it's important to know, and this isn't just an issue that has affected our government since March of 2023, but we've allocated the New South Wales government, and this spans the Perrottet administration and my administration, have allocated over $5 billion in 4 years to flood recovery and emergency assistance. That's about my understanding is that's a 1,000% income increase in the 4 years prior to that. It's the largest or the biggest spending item or the largest increase in spending item of any part of the New South Wales
governments
government.
have to support communities when they go through disaster.
It's very
You
strange.
would appreciate that.
Mr. Chair, the context is important, and I'm entitled, given I'm responsible for the government, to just put some statistics on the table. None of this money is being paid in umbrage. All of it is necessary. I'm not suggesting that the money shouldn't go out the door. What I'm saying is that we need better assistance and more integrated, faster approvals from the Commonwealth Government so that we can get money out the door as soon as possible. Second point I'd make is that Queensland historically, because they've got a longer history of natural disasters and we've had natural disasters here too, but because of the tropical climate, they're more efficient at both assessing and distributing urgent financial hardship support, and have been like that for decades. And we have to basically get to the Queensland model where it's quicker. We recoup that money from the Commonwealth faster. I mean, part of the remittance here and part of the problem...
I'm reluctant, but you have had a few minutes.
No,
and
I'm
I
sorry.
just would like to.
I
would like to ask another question.
The Premier's entitled
if I'm talking about flood resistance and inquiries,
but I actually have some more
wasting
questions
time.
about flood on behalf of the community.
Order. The Premier's being relevant, directly relevant to the question you've asked. You've got to give him the opportunity to answer in full.
Yeah, I mean, I think if I'm here for 3 hours, a minute on flood recovery is reasonable, I think.
Fair enough.
And the second point here is the remittance from the Commonwealth Government is slow. It's slow for government agencies in New South Wales, and I think partly that's because we haven't had the experience of, well, like the Queenslanders have, of distributing the funds, getting matching funds from the Commonwealth and effectively sending their half of the bill to Canberra. And as a result, we're holding... This goes all the way back to the Lismore floods, and Damien would remember this from his time in the Cabinet. We're still waiting on money from the Commonwealth Government for urgent flood assistance from the Lismore floods. So, look, the short answer is take it on notice what you're saying.
That would be great.
I appreciate that it's hugely important for Matt and Wade and other farmers in the mid-North Coast, and we want to make sure that they get their funds and back on their feet as soon as possible.
Thank you. Just one more on this is in relation to other support for business owners. Obviously, they're only getting $25,000, which is not enough, and you would have to acknowledge that's not enough for some of these businesses who've literally lost hundreds of thousands of stock. But when you were up there in the Pulteney Street Arcade, you did speak to John, who is the owner, and said that you would look at things like rate reductions for those businesses. Is that happening?
So what are you referring to?
When you were in Taree and you visited, you might not remember, but the Pulteney Street Arcade, and you spoke with John, who is the owner, and you said to him that you might look at things like rate reductions or other short-term support.
If that was a
happening?
conversation between... Were you in that meeting?
No, but I've been asked to ask you, are you looking at things like
rate reduction for
reductions for those impacted businesses?
Rate reductions from who? Local councils?
Giving them more
what?
support, for their local rates.
Well,
and they're only getting 25,000. So you stood there and looked that gentleman in the eye and said, these are the sort of things we can look at to help you, but that's now not going to be the case.
I think you're repeating a third-party conversation that you weren't available for. I mean, I haven't approached any of the flood recovery and assistance in a cynical manner. We've tried, in line with what we would regard as best practice, in many cases established by the Perrottet government, to get these assistance out the door as soon as possible. I'm not making the claim that if you're unable to get flood insurance and your supplies have been completely destroyed, as well as serious impacts on the physical structure, the $25,000 will cover it. But I mean, if this is all leading up to some kind of haranguing of the government, I mean, I just think it's counterproductive. I mean, of course we want to be there for the local community. There's limits to what we can do in terms of flood assistance and recovery, and I wouldn't intentionally let anybody down.
Thanks, Premier. Just in relation to the Moree bail accommodation, you told this hearing earlier in the year that hopefully it's up and running by June. Is it?
It's not.
Why not?
We've found it hard to get a lease in Moree, and I can report to the committee that the local member has acknowledged that and has been very helpful in assisting us to try and get a location, but it's proven difficult. The primary reason for that is that the sites that the government have and JJs have identified as what we would regard as ideal, if I'm going to be frank with you, have met with resistance in the local community. And I'm not criticising them for that. I can understand this is about, I guess, balancing what would be an important change with a town that's got to run like normal. I would have loved to have had a site. We've identified, I think, 3 or 4, but the offer of a lease has been withdrawn, or it's not acceptable to the local council.
Okay, thanks, Premier.
I don't want to knock. I don't actually want to knock the council or the mayor. I think they've been excellent, and
No, thank you for
we've
the
just got to
update.
try and find the right spot.
Sure. And just quickly, the Dubbo Sports Hub, again, we raised that last time, and you said that you would commit to working with the mayor and the local member about how you can get a facility like that up and running. Will you commit to meet with the member for Dubbo in relation to this project?
Yes,
Excellent. Can you do it in the next sitting week?
sure.
Fabulous.
He
I will
can
let
ask
him
me,
know.
though. He's
I
got my
believe
number.
he has. I believe he has. He's still waiting, so it's great to have that confirmed.
Thank you very much, Mrs Mitchell. Mr Borzak.
Thank you, Chair. Premier, I'm going to ask you some questions about Kathleen Folbig. Premier, I'd like to address the compensation payment offered to Kathleen Folbig. The $2 million ex gratia payout has been blasted as a disgrace and a national shame. Ms Folbig herself called it insulting and a slap in the face, while her lawyer denounced it as woefully inadequate and ethically indefensible. Far from justice, many people see it as proof the state still refuses to own up to the full scale of its failure. Premier, who actually made the decision to pay $2 million?
The Attorney General made the decision in relation to the ex gratia payment. I've read the commentary and heard. I've heard Kathleen Folbig's description of it. I understand there's criticism of it, but the Attorney General made the decision, and the decision was made in the context of the maximum amount that we believed we could allocate as part of an ex gratia payment without taking it from other government programs, which, on the basis of this hearing and others, there's a huge need for in every other part of government spending.
You say that the Attorney General went through that process and made the assessment, but how was it actually done?
How did he? Well, he applied.
Did he tell you about it?
Yeah, we did have a conversation about it. Yes.
So how did he actually do it?
Again, made a decision about the maximum amount that could be paid without adversely affecting other government areas or spending areas, which there are many and continuing.
So do you agree that $2 million is satisfactory?
Look, I accept that. If you look at some historical cases that may be analogous to Kathleen Folbig, the number's been far higher. I made the point previously that that's usually off the back of litigation or a out-of-court settlement between the government or the jurisdiction of the day and the person involved. This wasn't that. This was an ex gratia payment, and I just make the point, Robert. It's not my money, and it's not the Attorney General's money. So if we're parsimonious with it, it's because it's not us. It's taxpayer money, and we've got a huge call on our spend, and every day we have to make difficult decisions. This was one of them.
But Premier, you give her $2 million ex gratia payment. It's obviously open to her to sue the government for that. It would probably cost you a lot more than the $2 million plus to defend that action. Couldn't the government come to a better arrangement in terms of the amount of money?
Look, I don't believe so, but you're right. As I said, in similar analogous cases, there has been civil litigation. I don't know whether there will be or not.
Well, I don't know that either, but I believe she is saying that she can't afford to litigate. I think her lawyers are saying the same thing. The feedback coming from the public is that something like $20 million for 20 years is a fairer figure. Would you agree with that?
No, I don't have $20 million.
But you gave
if we did, you'd have to appreciate that the first 3 hours of this inquiry, Robert, were about hospitals in Western Sydney, about spending on domestic violence, on flood recovery victim communities, on each and every one of those, on social housing, on each and every one of those issues, there is an incredibly strong case to increase government funding on all of them. As a result of that, we have to make decisions, and I accept the criticism that in these contexts it might be that we're being parsimonious, but only because it's not our money, it's taxpayer money.
Well, it's been said, and it was put to me, that the government gave a $16 million sponsorship to the UFC. Why couldn't it even provide a similar figure to Ms. Folbig?
Well, that comes through Destinations New South Wales, and like a lot of spending, there's in particular when it comes to economic development, when you have a situation where so much of Sydney CBD and so many businesses and so much of the sporting infrastructure have suffered as a result of there being a lack of sport or a lack of opportunities, the government had to identify areas to lift economic activity. And I think that particular project has, if not a 20 to 1, so for every dollar the government puts in, $20 of economic... Well, the point I'm trying to make is it delivers a massive economic return for the state. And it's not just money that's being burned in a bonfire at the back of the domain. It generates tens of millions of dollars worth of economic activity, which we need. We're desperate for it. We're desperate for content. We're desperate for new initiatives in Sydney.
Well, I'll turn now to workers' compensation reform, which is obviously an area that you're having some difficulty with at the moment.
We are.
And you warn that the current system's unsustainable and that the private sector faces up to 36% increase in premiums over the next 3 years. The Treasury Managed Fund is deteriorating at the rate of $6 million per day, and I know the Treasurer has spoken to me about that. How do these figures translate into economic pressure on small to medium enterprises?
Well, massive. There's 6 times as many businesses pay into the compulsory workers' comp scheme in New South Wales compared to payroll tax, and a 36% increase in the liabilities that they'll pay is more than any of them can meet, or most can meet. It's been identified that nearly all of them will pull back on economic activity, not take on staff, or even worse, cut staff or close their doors. The impact on small and medium-sized enterprises, particularly if you consider the interest rate rises and the inflation crisis that we've had in Australia over the last 18 months, and prior to that, COVID, to be met with a 36% liability increase would be astronomical for those firms. I also make the point that that's if you don't have a workers' comp liability on your books. It's 36% if you've got a clean sheet. If there is a psychosocial injury on the work for a business, you can expect it to be even greater than that. And that's one of the reasons why. I mean, it's not just small business firms; it's also the government. I can understand people are going to be less sympathetic to the government, although I do have to worry about it. It's also NGOs, and basically every major NGO in New South Wales has said, we do not know how to meet these liabilities. We've had a 90% increase in our liability fees over a very short space of time. And I'm worried about St Vincent de Paul, Mission Australia, Red Cross. I mean, it's a huge, huge problem.
Well, look, your reform's gone to an upper house committee, we know that. But you reintroduced a new bill in the last sitting week. What are your prospects of getting this done in the end?
Well, I think good through the, I should ask Damien. I think good in the Legislative Assembly. We were able to get the support of all crossbenchers and all parties other than the Coalition and the Greens. But look, we don't have the numbers in the lower house. We don't have the numbers in the upper house. This is a question for Parliament. The government's presented its ideas and initiatives to try and reform the scheme, but this is a question for Parliament.
Have you raised it with the Commonwealth Government?
Not directly, but I imagine that business groups, not-for-profits, would be speaking to them about costs for businesses in the days ahead. It's I think there's a general acceptance that it's more than the business and NGOs can cover. Added to which the New South Wales government has put in $6 billion over the last 5 years into our part of the workers' comp fund in order to prop it up. And this should be a self-sustaining scheme. So that's $6 billion we would have loved to put into public transport, social housing, emergency departments in Western Sydney, or any other number of important initiatives for the state, but we can't. We're supposed to be putting it back into a scheme that is on its last legs.
Well, I see Treasurer Mookie's been invited to the Productivity Summit. Have you had any discussions about with him to raise it with the federal government?
In all candour, I haven't. I think he's got a full book down there. I was a bit jealous that he got invited. He's how many people are at the summit? There's only 12,
He looks
and
like
he's one of them.
fun.
So he, you know what? You should get him for 3 or 4 hours. He's
No, we will.
right
We'll
in
get
the-
him on
Oh, good,
Friday.
there you go. So he's in the thick of it. I don't know what he's raising, but he's got a big responsibility as the chair of the. What's he the chair of? Board of Treasurers or something?
He was
What's it called?
smiling.
Bots.
All right.
Thank you. Just on that theme, Premier, the budget has a line item in there that says that in the absence of an uplift in the absence of any breakthroughs in technology, productivity in New South Wales is due to remain stagnant. Yet I've asked Grok just in the break how New South Wales can uplift productivity, and it says there's a thing called AI coming, and that the New South Wales Productivity Commission, their inquiry says that AI could uplift productivity by 11.8% out to 2034, lift it from 1.2 to 2% per annum, and increase GSP by 3% per annum, and be worth over $100 billion to the New South Wales economy by 2035. How is New South Wales ensuring that we get that uplift in productivity out of AI? And isn't it time that we had a joint standing committee on technology in this state and a specialist minister for AI and technology to make sure that we get that uplift in productivity from AI? That was all written by Grok, by the way.
Is there a conflict of interest there, Chair? Sorry.
Well, there's a bit in that. I mean, if you had, you could maybe argue that if you had a minister for AI, you don't need a minister for AI. You just
We could have an AI as the minister.
you
for
could have AI as the
Very
minister for
cheap.
AI. No officers, no staff.
That's innovation.
There you go.
All right. Are you committing to that?
No, but I do think that we need. There's great promise there. There's real challenges as well, and I'd agree with you that I'm not sure the Parliament or the government or the global economy is quite grappled with where we sit in a developed world economy like ours that's sophisticated with low barriers to entry, that's integrated in the rest of the world, and we export with the rest of the world. Where does AI fit in terms of productivity growth, job protection, and also ensuring that we've got opportunities for people? There's the infrastructure question, whether it's data centres and whether we've got the ability to fund and run the escalating costs and infrastructure challenges associated with mass expansion into AI. But then we do have to look at the human level. And
Aren't they questions that would be best answered by a minister for technology and artificial intelligence and a joint standing committee? That was a recommendation of the AI inquiry that I chaired, to make sure that we're cognizant of the issues and aware of the risks and achieving those opportunities.
Well, my colleague Jihad Dib's Minister for Innovation, and he's really focused on these major issues. So I don't want to leave the impression that no one is looking at it. Obviously we are. But in all candour, Mr. Chair, I don't have great answers for it. I think that there's real opportunities in terms of economic growth and opportunity, productivity, which seems to be the buzzword at the moment. Everyone's talking about. There's also massive challenges too, and I'm not sure we're there yet. So I guess the short answer is yes. I'd love to hear what the Parliament had to say about it.
Great. Premier, the latest ACT health review found that since the homegrown cannabis laws commenced in 2020, cannabis use remained stable across all cohorts. Charges for offences fell markedly, and there were no increases in related health presentations, with stakeholders describing the reforms as, and I quote, positively received, including by the AFP, and noting no substantial unintended consequences. Is it time for New South Wales to look at a similar reform here?
Can you just explain to me what did you call it? The grow it at home?
The home grow cannabis reforms. In the ACT, each household can grow, each person...
I thought that was the case for decades in the ACT. Did you say it was from 2020?
Yeah, from 2020. I think they were just people just breaking the law.
Okay, right.
Barnaby Joyce and others, just a couple in the backyard. But look, it was 2 per person, 4 per household, adults, and you can share it amongst your friends and carry 50 grams on your person. But it's been well received by the AFP. No increase in use, no unintended consequences. It's essentially the model that they've implemented in Germany. Is it time to look at that in New South Wales?
Look, I'm not committing to that, Jeremy. I mean, I understand we wouldn't just dismiss other jurisdictions and try and learn from what's happened in their communities. We've moved, I think, a significant way on a range of drug law reform changes. We're open to further changes. I mean, we haven't responded to the conclusions from the drug summit yet, and we're not shutting the door on what more reform looks like. We're happy to engage with the Parliament about what that looks like, but I can't commit to it today. I got to approach this the right way. I've seen evidence from senior officials in some jurisdictions in America where they've been able to show persuasively that a liberal approach to particularly that class of drugs has had negative externalities and hasn't been well received. I've seen reports that the mass commercialisation of the cannabis industries in big metropolises not like New York have been detrimental to business, commerce, not necessarily an increase in crime, but just a general malaise in the city. So I just want to make sure we make the right call.
Fair enough. Premier, a recent landmark decision in the New South Court of Appeal overturned an approval to double the size of the Mount Pleasant coal mine and made it clear that the impacts of climate change on local communities need to be fully assessed for coal and gas project expansions. We've seen a lot of terrible climate-fueled disasters and how they have an impact on local communities. You've spoken up for places like Lismore and vowed to stand with them. Can you assure us that this judgment will be followed by your departments and that all current proposals will now complete full assessments and consult with the community on them as required by the law?
Well, I mean, obviously we'd comply with court judgments. I understand the proponents seeking an appeal. It's difficult for me to comment about it, but I do understand the point, and obviously the judgment was received by the government, and we comply with it.
Thank you, Premier. Since your government came to office, Forestry Corporation, a state-owned company, has had cumulative losses from its native forest hardwood logging divisions of $5.59 million. It has been prosecuted multiple times, including having a senior judge describe the corporation as having, and I quote, a significant history of unlawfully carrying out forestry operations, end quote. It has also been fined $1 million for environmental breaches, and as of today, the EPA has 10 open investigations into potential breaches of logging and environmental rules. Are these ongoing financial losses and history of illegal logging and a history of illegal logging operations acceptable to you?
Well, no. I mean, breaches of EPA guidelines or the laws are not acceptable, and we need to make sure that when it comes to government agencies in particular, that they follow the law. And I accept those judgments. And
who's accountable for those, ultimately?
Well, ultimately, I am. The government is. a lot of the judgments and a lot of the activism involves places on the mid-north coast and just higher than that. The government's, in the not too distant future, about to make a major decision in relation to the Great Koala National Park, and we believe that will address in some respects the significant challenges associated with hardwood plantation production in the state.
Thank you. Well, now, do you have
Can I,
another-
I'm prepared to hang around, but do you mind if we have a brief break? Do you mind?
Yeah, sure, absolutely.
Thank you. I'll come.
While the Premier is...
Yeah, just to respond to Ms Mitchell's earlier question about the primary producer grants. As of Monday, there were 1,036 applications. There were 333 still in assessment, 450 awaiting assessment, and 239 approved. And there's been $58,348,495 is the value of the applications. And the value of the approvals is $14,315,000. It should be. It's worth sort of distinguishing between the grants to households and individuals that the Premier was referring to earlier, and the primary producers. As you know, with these grants, the applicants are required to provide levels of evidence, and they get sort of incremental payments as they provide more and more evidence of their eligibility and the damage that they've incurred. So I don't know the circumstances of those three individuals you mentioned. They may well have done everything that's necessary, but it usually takes a little bit longer with primary producers.
Thank you. Thanks for that, Mr. Draper.
Yeah, we might as well go back up there until... Yeah. Thank you, Hansard. Well, that concluded my questions. We'll now go back to questions from the opposition.
Damien? What is
Damien.
Thank you. Premier, you've got a history as a firefighter.
Yes.
Will you commit to working on a bipartisan way with the opposition on my bill relating to the expansion of coverage for presumptive cancers for firefighters in New South Wales?
I mean, look, I would commit to working in a bipartisan way with anyone in relation to emergency services. We've got to make sure that we can roll out the program and that it works. But I wouldn't dismiss your interest or any bipartisan initiative. I mean, I can't in a blithe way just endorse the bill that you've introduced. I'm aware of its contents, although not the details of it. But of course, we'll enter a discussion with you.
Good. Can I now take you to the Harbour Bridge?
Yes.
I wasn't there. You'd be pleased to know. I wasn't there. Well, perhaps no. You made fairly strong observations in relation to your views in relation to the protest which was foreshadowed to take place. And it was your view that it should not have taken place. Has that remained the case?
Well, I mean, I think just for context, a few things I said. Firstly, I understand the very widespread community worry, concern and outrage about the circumstances in Gaza, the loss of innocent Palestinians, particularly children, the takeover of aid and humanitarian assistance in recent months, and that a large number of Australians wanted to publicly demonstrate in opposition to that. And I share many of those concerns. I'm worried about it as a lot of other people. I'm sure you as well. You can't watch the images on television and feel anything other than that. My concern wasn't that the protests take place. I appreciate that a city like Sydney, a big city like Sydney, must protect and allow big demonstrations, particularly ones like this, to take place. The government, the police, everybody in senior levels of the New South Wales government was prepared to work with the organisers. My concern was on a 6 or I think it was a 5-day turnaround, to have a critical piece of infrastructure knocked over was dangerous and hugely disruptive, and that remains my concern. That's right, that is still my concern. But I just wanted to be clear, I'm not opposing the protest.
I wasn't querying the content of the protest, but your concern related to
it's still the case. I haven't changed.
It's still
my
the
mind.
case that you have reservations about. You could, in fact, amend the Protest Laws Act to, in fact, specifically. I know Ms. Higginson is shaking her head in relation to...
It was an involuntary motion, I apologise.
Let's say, to, in fact, include the Harbour Bridge as a prohibited place where demonstrations could take place, could you not?
Well, I mean, the advice that's been given to me is that it does go close to breaching the implied freedom of political communication and association in the Australian Constitution. And you'd be aware, Damien, that the changes that the government's made, and I stand by all of them, and we've got advice that they should succeed in a constitutional challenge, but every one of them is currently being litigated in the High Court as we speak. And I didn't want to have a situation, given the volatility of the circumstances, where I committed to introducing legislation that then gets knocked over in the High Court and we're back to square one. There's another protest on the bridge. Just make the point that I'll make the point that I don't believe that therefore the government is, completely hamstrung. I think that the circumstances relating to the protest on the Harbour Bridge are still troubling. There's been huge major civic and recognised protests that have taken place in Sydney that didn't happen on the Harbour Bridge. Probably the largest one, 1 million people, was in Australia's, the Australian government, the protest was in opposition to the Australian government joining the Iraq War, and I was at that protest, but that didn't occur on the Harbour Bridge. So I reserve the right to effectively look at actions that balance competing rights, the right to protest alongside the right to enjoy a big city like Sydney and not have it interrupted. And I know everybody's got a different view here, but can I just make the point? Everyone would have one group that they don't want protesting on the Harbour Bridge. You don't know where you sit on the political spectrum, there'd be one group, whether it's Advance Australia or Critical Mass or Extinction Rebellion or the Palestinian groups. Everyone would know one group that they don't want protesting on the bridge, and that's the dilemma the government's got.
So, just in that, and given that view, and that you recognise that people do have competing views, though, it would have been your preference that government ministers did not take part in that protest. For example, the leader of the government of the Legislative Council, she took part in that protest in circumstances where you had expressed a very strong view about whether that protest should take place at all.
Oh, sorry, a point of order has been taken.
Chair, even allowing for wide latitude and budget estimates, I don't see how that question goes to the estimated expenditure of funds from the consolidated fund or related budget papers.
Look, apologies, I was distracted. Could you repeat the question, please, Mr. Trudeau?
It goes to well, for your benefit,
apologies.
Chair, in the circumstances where you had expressed very strong views in relation to that protest taking place, it would have been your view, would it not, that government ministers should not have been taking part in that protest, notwithstanding you recognise that they may have legitimate views in relation to the subject matter
And I'll
Oh,
take my
it's
point of
okay.
order again, Chair.
Yeah, well, I won't uphold the point of order. I'll allow it.
I think you just got the nod from the Premier, Bob, so that's all right.
Well, look, certainly if the protest was, let's use the vernacular, illegal. I mean, if the police, having refused the Form 1 and the Supreme Court agreeing with the police's assessment, I mean, it would be, it's not technically the case, but an illegal assembly or an illegal march, that couldn't have worked. But having it effectively approved and the government's position being knocked over in the Supreme Court, and I just have to admit that we lost in the court. The advocates won. I think the circumstances changed, and I also have to acknowledge that I've got colleagues that have got very firm, deeply held views, and they wanted to be part of the demonstrations, and so I understood the circumstances, and I had conversations with colleagues in relation to it for some of them, and I get the circumstances.
Well, one of those colleagues, of course, was the Minister for Emergency Services. Now, in the course of the application to the Supreme Court, his agency gave evidence about the dangers relating to the taking part or the actual occurrence of that protest. Surely it would have been inappropriate for the minister, whose own agency was giving evidence about the dangers associated with that protest, not to take part in that protest.
Which of his departments gave evidence?
The Department of Emergency Services.
I don't think they did. The police did.
Police and Emergency Services.
Well, I'll take your word for it.
Yep.
Look,
There's no department.
yeah.
Fire and rescue.
There's a minister
Fire
for
and
Fire and Rescue.
But it was made.
Yeah. Look, I understand what you're saying, but in the circumstances, I understand his view too, and I accepted it. It's deeply held for him. We did have a conversation about it. I didn't regard it as a personal umbrage, and I think having had a clear judgment from the Supreme Court allowing the protest to go ahead, I didn't see it as a breach of cabinet solidarity. I understood the human element and the human decision.
But it's not necessarily.
I mean, I was
solidarity.
surprised. I have to say, look, people know my point of view in relation to this, but there's not unanimity inside the government on it. I mean, there's widely held views, and I have to respect that as the political leader of the Labor Party. I also have to make decisions about how to run a big city like Sydney in difficult circumstances when almost every other week we have one group or another who's protesting on public land. But no, I understood the reasons for it, and I didn't regard it as a breach of cabinet or ministerial responsibility.
I'll move on to Business Connect. In the Legislative Assembly on the 7th of August, you defended the defunding of Business Connect on the basis that the workers' compensation reforms had not passed. Is that correct?
No.
Well, I'll put it this way.
Okay.
Is it your position that funding of Business Connect is contingent upon your getting away with workers' compensation?
No, it's not.
Okay, well, what is your position in relation to the funding of Business Connect?
Look, I think anyone who has been watching this committee hearing for the last couple of hours and presumably for the next few weeks would anticipate that pretty much every question, and it's completely understandable, when the Labor Party was on the other side of the table, we had the same questions, but every question is, will you commit extra funds? Will you commit more funding? Will you allocate more resources? And I understand that. I mean,
I'm asking why you're taking it away.
governments are, well, that's the reason why. I mean, you'd appreciate that we were left with the largest debt ever handed from one government to another in the history of New South Wales, that we've got what we regard as urgent responsibilities for frontline healthcare workers and teachers and educators and police and public transport. And I hate doing it. It's a difficult part of the job, but we have to make a decision about priorities.
But you would have heard, and I get that entirely,
Sure.
but since the taking of that decision, there has been a significant amount of evidence being put before you and your colleagues relating to the tangible benefits that are provided to small businesses by Business Connect. Is it an opportunity in those circumstances to be able to say, well, on a cost-benefit basis, maybe it was a rush decision, and there is an opportunity to ensure that businesses are supported in the tangible way that they were supported by Business Connect?
Well, I'm sure I'm not criticising the program. I mean, I think that there's a lot of good programs the government's responsible for, or partly funds, or is in some way connected with. But you know, the number of businesses that do you have it off the top of your head? How many businesses?
I think it was over 10,000 businesses had, and that's again off the top of my head.
My understanding was about 10,000. Yeah. That's a laudable goal, and I'm not criticising the people that roll out the project. There's 900,000 businesses or thereabouts in New South Wales, and I guess you're asking me in terms of competing government priorities, where should we be putting the money? We've decided to put the money into, when it comes to businesses, the enabling infrastructure to allow the economy to grow and to have people get to businesses quicker. Housing, so that, and I haven't met any medium or small sized business that hasn't spoken to me about labour supply challenges in the economy, in particular in relation to their business. And lastly, in relation to workers' comp. Now, Damien, I promise you, I don't want to litigate the ins and outs of workers' comp. Upper House has gone through it backwards and forwards, but you'd appreciate it.
I've avoided doing it with you.
No, fair enough. But you'd appreciate, you know, we're faced with this situation where we've got a 36% increase in liability for small, medium and big size firms. I've got 10,000 businesses that undoubtedly benefited from this program. I've got 900,000 businesses that are about to get whacked with the workers' comp premium. And absent reform, we have to provide the funding for that programs, for that.
Just accept our amendments and you'll get your reform.
Well, it won't deliver the savings we need.
Sorry.
I mean, I'm not trying to be smart here, but didn't you say that you're not progressing them anymore?
I don't know.
The Latham Tudor Hope amendments, they're off. I thought that you said that they weren't part of the negotiation. No, we could have a live negotiation here.
Feel free.
Well, anytime you like, Premier.
Okay,
anytime you like.
Sort it out.
Premier, currently, while we're talking about workers' compensation, because it is something which has been a live issue for you. Currently, a victim of workplace sexual assault, where an employer has been negligent, can see a work injury damages claim assesses where the person has a 15% whole of person impairment. So they have a benefit of being able to bring a common law claim against the employer at a 15% whole of person injury. Under the bill, that same person, in circumstances where there has been a negligent employer, will have the rights to pursue a common law negligence claim against the employer removed unless they have a whole of person impairment of 31%. Do you accept that that is fair to people who are the subject of sexual assaults?
Well, look, I think there's a couple of things that we need to work out here, particularly in relation, I thought you said a sexual harassment.
No, sexual assault.
Sexual assault. Well, look, the rights for individuals in relation to sexual assault in common law or through the criminal justice system are unimpeded. In relation to compensation from the scheme, that continues.
No, it doesn't.
Well, it does.
The
idea. Sorry, Mr. Chair, I need to get an answer.
The Act removes.
There's a couple of things that are really important here.
Please, Mr. Chair, allow the Premier to answer in full, please.
There's been a canard that's been repeatedly expressed in the Legislative Assembly.
I beg your pardon?
A canard. A lie.
A canard.
Yes.
Yeah. Say that outside, Premier.
Say that out. You get arrested
There's been
for
a
saying that
mistruth.
if you step outside.
There's been a mistruth that funding will end in relation to psychosocial claims via iCare. That's not the case. Both income support and medical support will continue for successful claims under the proposed changes. Our objection to the Coalition's amendments are that the individual would have to, who's been accused of those offences in the workplace, would effectively have to say that he or she knew that that was the case, not that the individual is objectively been subject to it.
I think you're confusing the two things, Premier, because the legislation is absolutely clear that common law damages are not able to be pursued unless there is a 31% whole of person impairment. Now that is being removed for a victim of sexual assault.
Look,
is that your intention?
No, it's not our intention. And
well,
the bill
if it isn't,
sorry, I'll get an answer out. It's not our intention, and the bill does not deprive victims of sexual assaults in their rights. It's not the case.
Well, Premier, I suggest you review the Act because, in fact, it says.
Well, we've
exactly
reviewed
that.
the Act, and we've also reviewed the proposed amendments moved by the opposition, and they would effectively extinguish sexual harassment as a claimable payment in the workers' comp scheme in New South Wales. I think that would be a huge mistake and one we would vigorously
oppose. Well, the Bar
oppose.
Association doesn't agree with you on that, but that's fine. In relation to Moore Park Golf Course, have you been lobbied in relation to that by Bob Carr?
I can't remember. Bob Carr's view is that that it should be open space. But in all candour, I can't remember whether I read that in the newspaper or he told me directly. So I just don't want to. I think I might have read it. I can't remember whether he told me directly, but I'm not disputing it. That's his view.
Yeah. Did you consult Linda Volz in relation to our Carnarvon Golf Course?
Well, no, I haven't, but there is a major consultation taking place at the moment in relation to Carnarvon, and judging by my trip to the Parliament this morning on Macquarie Street, she's active in that consultation.
Well, in relation to that...
She had a T-shirt on this morning.
In relation to that, who did you consult with in relation to that?
The consultation's continuing, so I presume it's still happening. There hasn't been a decision about it.
Finally, in the short time available, can I just ask you about cashless gaming trials?
Sure.
That's been a failure, hasn't it?
Well, I mean, it's a big challenge. I'm not sure the technology's there, and if you look at the committee report back, rolling it out at scale would be...
So have you got any other proposals to address problem gambling?
We do.
Tell us about them.
Given its I understand it's a major issue and of keen interest for the Parliament, but we're not ready to roll out our reform plans on that.
Well, you've currently provided additional support for Star Casino, have you not, in relation to continuing cashless gaming? To continuing their gaming machine without limitation on the amount of cash that can be spent in those poker machines?
My understanding is that was, in part, the opposition was demanding support for Star Casino. Is that your recollection?
But no.
I think you'll find if you speak to the Shadow Minister.
But it is an opportunity to further launder cash, is it not, through poker machines at the casino?
I don't believe so, no.
The Crime
I'm not
Commission
saying
doesn't
that
agree with
doesn't
you.
happen.
The Crime Commission doesn't agree with you.
Can I get an answer out? I'm not saying that doesn't happen, but the changes or their licence conditions are in place, and obviously there's an independent regulator that's monitoring that. Can I just make a point a little earlier, which I want to come back to just in terms of fullness for the committee? And Damien, you were mentioning earlier the IRC decision in relation to fire and rescue, which I've got in front of me, and if you don't mind, I wouldn't mind reading part of the judgment.
I don't want to need you to elucidate.
Would you mind if I just,
Please,
for
go ahead,
completeness sake?
Premier.
The judgment says, and this speaks about the previous government's decision to award a zero-wage increase.
Point of order, this is not responsive to a question which was asked to him. In the circumstance, sorry?
You asked me
If he wants
did
to
20
table
minutes
the
into it.
judgment, I'm happy for the judgment to be tabled.
It's crossbench time.
Well, he's to the point of order. The Premier's not seeking to table; he's seeking to give a response to a question you asked. And
Well, what was the question, Chair?
It was in relation to the IRC decision for
determination
fire
to
rescue.
the FBE.
And I accused you, Damien, of selectively
well, I
quoting.
think you were answering. You are now answering your own
No,
question as opposed to my
I'm
question.
not. I accused you.
I
of
don't uphold the point of order.
Thank you, Mr.
Please
Chair.
proceed.
At the time,
Quickly.
earlier
Premier.
today, I
Well, you're
accused.
just taking up time from everyone else here.
well,
Premier.
let me get
If you
through
want
it
to
and
table-
I'll-
If you want to refer to,
I'll
a
hang around.
paragraph.
Order, Mr. Buttigieg on a point of order. Yes.
Ability of the Premier to clarify a question I was asking.
But he's going to read selectively from a
Quibbling with
judge.
your
I'll ask you to call him to order.
Yeah, I will. I do call you to order, Mr. Tudor-Hope.
Mr.
Please
Chair,
proceed, Premier, but
Happy to
do
have
so.
more
Thank you.
questions, Sue.
quickly.
Mr. Chair, I accused Damien of selectively quoting from the IRC judgment of last week, and I just want to make
I'd
it
like
clear
to
that
table the whole judgment.
I'm happy to do that.
Okay, good. Table.
Table the whole
Um,
judgment.
Can I finish, Mr. Chair?
Please go ahead.
It's important to note, and this is what the IRC president said, and this is of the workers who were affected by the zero wage increase from the previous government. Quote, those sacrifices from workers appear to have had the intended effect, which is budget management, or the position that's been put forward by Mr. Tudor.
I think it was the
Then he goes on to
Commission's
say,
decision.
Sue, don't you have questions?
then he goes on to say, with the
Okay.
benefit of hindsight, however,
Just gonna read
those
the public
wage
document
increases
instead.
were wholly inadequate to maintain the real value of wages. He then goes
That
on
was
to
the
say,
Commission's
the
decision.
government agreed to a 4% increase in 2023, which resulted in a gain in real wages in that year. However, that change was not sufficient to offset the fall in real wages that occurred between 2021 and 2022.
And the Commission
That's the full
the
statement.
Commission
Happy
accepted
to-
responsibility.
happy to
Order,
The Commission
order,
accepted
order.
responsibility for
Mr.
making
Tudor-Hope,
that decision.
Order. Stay
order,
there, mate.
order,
Clip that.
order,
You got
The
stung
Commission
there.
order,
accepted
Mr. Tudor-Hope.
responsibility.
Please come to order.
That's
Thank you,
ridiculous.
Mr. Tudor-Hope. Mr.
This is what
Borsak.
happens when you selectively quote,
That is
Damien.
ridiculous.
You get a pie in the face.
No. The Commission, that was
Order.
the Commission's decision, and you know it.
Order. Mr.
I'm
Borsak,
just
your
reading from the
You
document.
know it.
order. Mr. Borsak.
Robert, sorry.
Do you know it, Premier?
Order.
Selectively quoting?
Look,
I'll
you're
join in
the
as
last
Deputy
person
Chair.
defending the wages cap in New
I'm
South
not.
Wales,
Just ask
Damien.
a
You
question,
genuinely
please,
are.
Mr. Borsak.
I'm not.
Quickly
Mr.
before the vote.
Premier,
Point of order's been taken. Mr. Nandver on a point of order.
Sorry, Chair. Again, for the sake of Hansard,
wasting
just
time.
there just
Burning
needs to
my
be
time
a
up.
decorum restored, and I just ask that you
Yes,
call.
I uphold the
You've got
point of
government
order.
time. You should have
Mr.
done
Tudor-Hope and Mrs. Mitchell, please desist from interjecting over me and the witness, the Premier, while he's giving an answer that I've ruled is relevant and appropriate to the hearing. Mr. Borsak.
thank you, Chair. I'm just going to come back to housing, Premier, because it's really, it's a vexed question, but also very worrying. I mean, I'm thinking about my children, for example, my children's children, my grandchildren.
Yeah.
Where the hell are they going to live? Your plan A for housing was Race Hill Racecourse. That didn't work out. And you talked about a plan B to deliver more housing. What is plan B?
Yeah, that's a very fair question. Well, firstly, in relation to Rose Hill, I'm disappointed it didn't get up. I thought that would have been not the whole solution to Sydney's housing problems, but a piece of the jigsaw puzzle. To put it in perspective, if we really get motoring in terms of capital investment and start hitting 50,000 completions a year in the years ahead, we'll still be 25,000 houses short in terms of New South Wales' aggregate responsibility for the National Housing Accord, which is 75,000. So if we start beating Victoria, we're still, say, 20,000 short. The entire Rose Hill proposal was for about 25,000 houses, Robert. So what I'm trying to say is we need a Rose Hill every year.
Yeah, no, that would have been a nice jump, but of course...
Would have
it's
been a
not
nice
gonna
jump, but nowhere near enough. And so when it comes to alternative plans, we were able to get a real breakthrough by working with, I've got to give credit to the Mayor of Burwood and the Mayor of Canada Bay, who understands a card-carrying member of the Liberal Party, both of whom worked together for state significant-led rezoning for the new
You're
Burwood
talking about
North Station.
Burwood North
Burwood
Metro
North
Precinct?
Station. Yeah, exactly. We anticipate thousands of new homes going into that community, but it's well located. I mean, it's sort of 8 minutes to the city, 6 minutes, 7 minutes out to Parramatta, the two biggest employment zones in the state. That community will be located directly between them, which means that there's less of an impact on cars, there's less of an impact on the surrounding streets, and you'll literally be able to get in an elevator, get down to the floor, get on a metro. I mean, that's how big cities around the world operate. They build with existing infrastructure. It means that you don't have to stretch social infrastructure over such a great plain. If we don't have that kind of
Can't you do something with the planning laws in those special precincts to really shift this along?
We are. I mean, we are doing that. What I'm also saying is that in addition to major projects like Canada Bay and Burwood, there are discrete, geographically specific projects that we are pursuing for extra housing, which we'll announce soon.
Glebe Island?
Well, the Bays precinct, it's not just sort of Glebe Island is something we're looking at, but I don't have an announcement on that today, and I'm not trying to be glib with the committee. It's sort of highly commercially sensitive, and it needs to be released at the same time because there's a lot of players involved.
Well, what about the home of the Greenies, Wallara?
Is it? I don't think so. Whether the mayor's a Liberal.
Again, I'm at a disadvantage. I'm just not in a position to announce it, but we'll have more to say very soon.
Are you going to put a train station into Wallara on the existing tracks?
Well, everything's on the table. I'm not going to rule anything out.
Oh, come on. Give us an answer. I live in Ashfield. I mean, I cop it all.
Yeah. We're looking at it, but the problem is, the government's got to, when we make the announcement, because there's a lot of independent owners of property, that we just have to do it at the one time on a particular date if we were to make an announcement in relation to those sites. So, look, we'll have more to say soon.
Put some Opal machines in there to get started and give everybody a hint what's going to happen.
Yeah, well, unfortunately, the train just flies past at the moment, so you'd really have to tap your Opal on and then try and grab a guardrail to get on the train.
Yeah. The UDIA, the Urban Development Institute of Australia, third progress report released in July, notes Greater Sydney remains about 30,777 dwellings behind what it should have had by the 30th of June 2025 under the National Housing Accord, 322,000. Premier, how does the government explain maintaining a substantial shortfall when the Accord is well underway?
Well, I mean, look, the Accord is important because it sort of, for the first time, sets some maybe arbitrary but certainly stretch goals for not just us but the other states to meet. But I think in some respects people have lost sight of what the Accord was for. The Accord is that if you meet these certain way stations along the way to producing new homes, the federal government will make available, I think it's $1 billion, is that right? $3 billion, but we get a pro-rata bit of it. So let's just say roughly $1 billion, but in 5 years' time. Now, the enabling costs that we need for new infrastructure are gigantic, like massive compared to $1 billion from the federal government. Like, it doesn't even come close to meeting the needs for social infrastructure and enabling infrastructure to build new homes in Sydney and in New South Wales. So that kind of makes me think, and by the way, Robert, we get it at the end of the Accord, not even at the beginning. I mean, it would be one thing if you got the money up front, here's some money from the Commonwealth Government to get you going with housing. It's meant to be that if you meet all these stations in a 5-year period, we'll give you your share of $3 billion. But frankly, that's nowhere near enough. I'm grateful that it's there, though, because it keeps everybody honest, and it means that we've got to keep pushing on the housing idea and the distribution, the 75,000, I think's the right goal for New South Wales. What I can also say is that housing approvals are up, and I think that this is the beginning. This is the benefits of detailed reform in the New South Wales economy, which have been difficult and resisted by some people but accepted by others. And The 12 months to June 2025, 48,588 new homes were approved, and that's about 14% higher than at the same time in the previous year. Last month, for the first time in relation to completions, we beat Victoria for the first time. Now, those monthly numbers do bounce around a bit, and the cost of capital and the cost of labour is more expensive for Sydney than in Melbourne. But they're encouraging signs, and I think it means that the focus of the government and in many ways the partnership that we've been able to strike up with a lot of local councils is starting to work.
Well, it's starting to work, but I mean, the same report also talks about basically the failure of your flagship reforms, transport-orientated development, mid-rise housing, new development activity. It described as minimal, only 3,500 dwellings so far.
Yeah, look, I like the UDIA. I think they've been a really important stakeholder in belling the cat about the need for housing, but they haven't included in that data SSD, State Significant Development Applications, and really the HDA, which Simon's a member of, has been, in its short period of time, has been responsible for the approval of 70,000 new homes, and the UDIA's numbers don't take that into consideration. So, look, partly this is about the churn in local councils, partly this is about state significant development decisions from the state government. You put it together and we believe we're making progress.
Just got one more, just a bit further on the UDIA report and others. They suggest that record state taxes, charges and housing and productivity contribution are undermining project viability. What's your response to that?
Yeah, I mean, I'm not surprised. If I was running an industry association for builders, and we need builders, but I'd be saying the same thing. I appreciate that. You also have to appreciate from our perspective, we need infrastructure for fast-growing suburbs. And the worst thing we could do is pursue approvals, liberalise the planning system, grant state significant development for new homes, and put, bugger all infrastructure into a community. And that's been the pattern in the past, and it's been horrific for those new communities. And we still cover most of the enabling infrastructure and the social infrastructure, but there's got to be a contribution from them as well.
Well, there's plenty of infrastructure in Willara.
Thank you, Mr. Borzak. We'll now turn to questions from the Greens. Ms. Fairman.
Thank you, Chair. Premier, in June, you said that the cashless gaming trial was ineffective and hadn't driven down problem gambling. What did you base that on?
Well, my recollection is I based it on the report back from the independent committee.
So the report itself, the cashless gaming trial evaluation, specifically found that because the cashless gaming trial wasn't mandatory, that players could use both cash and card, that not many people chose to use the card. And that was what happened after the Newcastle West's trial. So, in fact, it found that the digital technology worked well, as it was intuitive, simple, easy to use, with straightforward menu navigation, and industry personnel and gambling support stakeholders saw a lot of potential benefit for users, particularly in harm minimisation features, once the technology is normalised and users have more time to adopt.
Sure.
So what was it about that report that, in your words, said that the cashless gaming trial was ineffective? Because that's what you told media.
It didn't work.
What do you mean it didn't work?
Well,
it didn't work because it was set up to fail, though, wasn't it,
Well, that's
Premier?
your interpretation, but it's not as if I've got a report back. I accept that there may be...
The whole point is that
Sorry,
to
Mr.
be
Chair,
a
I'm
cashless
trying to get an answer out.
a mandatory cashless
Order.
trial,
What
that
ca-
if you have cash with
But
it,
you accept from-
nobody's going to use the card.
All right, thank
Nobody's
you.
going to use the card, are they, Premier?
Can I just get an answer out?
Sure.
A mandatory cashless gaming environment in a trial form is not possible. I mean, how would I do that?
But you kicked this off down the road for 2 years in
No, but
terms of acting
is that not an
on
unreasonable
this issue,
question?
saying you'd trial it, but the trial wasn't actually a trial.
Well, it was a trial and it didn't work.
No, because it was set up to fail.
Well, that's your argument, but think about it from my perspective. The alternative, in order to, in your words, prove the trial, would require mandatory, universal, cashless gaming. How do I do that
Why
in
did
a
you
trial?
do the trial then?
Well, to understand whether the technology would work and it could be
The
rolled out.
technology does work.
I'm not so sure about that.
That's what the trial found.
Yeah, it works in the context of ease of use, but one of the aspects that I don't think you're giving due credence to is the rollout of this technology in every gaming facility in New South Wales, which is billions of dollars that I'm not paying for.
So speaking of billions of dollars, last question. So in the first quarter of this year, the people of New South Wales lost $2.17 billion to pokies. The people of New South Wales are gambling, losing $1 million every hour, $24 million a day. Austrac says that a quarter of the state's 65,000 poker machines in clubs could be vulnerable to money laundering and terrorism financing. So what are you going to do to stand up to clubs and actually introduce cashless gambling? Have you just given up entirely, Premier?
No, we've pursued a whole bunch of changes in
hard?
relation to New South Wales, whether it's signage out the front of venues, the reduction in the head count.
People are gambling more.
Order.
They're gambling more. It's
Order.
not working.
Order.
It's not working.
Ms.
You speak
Fairman.
for 5 seconds and then it's
Well,
ridiculous.
we
You know what? I'll just take it on notice.
All right. Okay. Thank you, Premier. Ms. Con, Dr. Con.
Thank you, Chair. Premier, whenever you're asked about wages for healthcare workers, you talk about lifting the wages cap, and you had the enthusiastic support of the Greens to do that.
Yep.
But at the moment, midwives, nurses and doctors who work for New South Wales Health are having to make really tough decisions. We're in a cost of living crisis. These workers are making decisions about whether to stay in New South Wales or whether to leave to other states without a meaningful offer. And by a meaningful offer, you know, the ANMF in Victoria won 28.4% over 4 years. South Australian doctors have just won between 13.5% and 19% over 3 years. What does lifting the wages cap actually tangibly mean for these people?
Oh, well, that's an easy one. In the first year of the Labor government, we lifted wages by 4%, which was the largest increase in a decade. Just last week, the government initiated penalty rates from 15% to 20% for all nurses in the New South Wales hospital system. We're currently in the Industrial Relations Commission, where an independent judge will make a decision about wages with the nurses presenting evidence in relation to gender pay disparity, as well as the previous government's devastating impact on a zero wage increase during a period when inflation was running at 8%. So for all of those reasons, and I urge you not to dismiss the Independent Industrial Relations Commission as a key valve in determining wage determinations in the state. These guys oppose it. We're supportive of it. It's been in place in New South Wales for decades, and it's resulted in effectively real wage increases for public servants across the state with a fair judiciary in the event that the two sides can't get agreement. So look, I'd reject that we've done nothing. If you look at the statistics in relation to the retaining of healthcare workers in New South Wales, we're at 93%, which is the highest we've been since before COVID. And the only reason that's happened is because we've agreed to employ the COVID nurses that were temporarily put on by the previous government. We've lifted the wages cap, which meant 4% in the first year plus an interim 3%, while the remainder is arbitrated in the Industrial Relations Commission, so nurses aren't waiting. And then lastly, an agreement between the Nurses Association and the government to lift penalty rates to 20%. I'm really sorry, but that is not nothing.
Yeah. Premier, I'm certainly no defender of the previous
But you
Liberal
don't
National
have to
government.
to dismiss the hundreds of millions of dollars that we've put into the healthcare workforce, I think it's silly, and it gives credence to the coalition who say
Premier, I'm not
changed.
dismissing any of that, but do you accept that even under your latest offer to nurses and midwives for their night shift penalties, they would still earn substantially less than any other state and territory, including on that very issue of night duty?
Well, there's a couple of things that I think that are important here. There's a coalition government in Queensland that's in dispute with the Nurses Association over a 3-year deal today. That's happening right now. In New South Wales, we've made those decisions as an interim agreement with the Nurses Association while they pursue their claim in the Industrial Relations Commission.
And after we suggested it.
Now, that seems to me to be not only a reasonable pathway through the impasse, but a fair one too.
Thank you, Premier.
Thank
Ms.
you,
Higginson.
Chair. Thank you. Premier, on the deadly serious issue of climate change and climate breakdown, the Chair earlier made reference to the very important Court of Appeal decision around Mount Pleasant and Mac Energy. It overturned the New South Wales Government approval for the extension of that mine on the basis that the local impacts of climate change must be considered based on the emissions generated from those high-emitting developments. But also, at a similar time, the International Court of Justice found that nations are responsible for reducing emissions and that neighbouring countries and other countries will be able to apportion liability for damage as a result of not reducing emissions and climate change. Essentially, Premier, we have now hit the point of the acceptance of attribution science. Here in New South Wales, we are in serious danger of not meeting our legislated 2030 target. Your minister has made that clear. But we absolutely could with more effort. You've got ministers across your cabinet trying really hard right now. But Premier, from where I sit, from where everyone sits,
Ms. Higginson, could you ask a question?
There is
please?
no harmony.
We're getting there.
No, we're there.
We're getting.
There
Can you
is-
ask a question?
Premier,
I'm sorry, Sue.
Premier, there is no harmony. Would you consider issuing a Premier's directive that we go further and faster to achieve emissions reductions in line with our 2030 target?
Well, it's legislated.
No, would you consider issuing a Premier's directive? It's an important thing
I
because
think-
you have ministers
sorry,
trying.
I'm going to get an answer, surely.
Order.
Just-
Ms. Higginson, there was an
fine.
enormous preamble there. You've got to give the Premier...
The Premier took every bit of it. I
Sue,
saw him.
honestly,
Yes,
if you
and
give
then
me
you
half a
interjected over
second
the
to
top
answer,
of
it
him
doesn't
while
seem
he was
reasonable to me.
answering. So, Premier, please continue.
Look, I think that the legislation, the legislated climate change targets are a hugely important step, and a Premier's directive would seem almost a diminution from that.
Can I just ask
Nothing's
you,
more important than the law.
Premier,
and
can I just
Parliament's
point one
passed
thing
that.
out to you?
Sure.
The 2030 target, I work very hard with your government to get those targets in place. The 2030 target is not a binding target, the 2050 is. Would you please, Premier, consider a directive to assist your cabinet ministers to meet the harmonisation to drive us to get to that 2030 target?
I have to think about the context of the... Let me take it on notice.
Thank you, Premier.
Thank you, Premier. Mr. Tudorhope.
Thank you, Chair.
Just for people's information, we're going to run to 12:47 due to the intermission.
You're a mean chair.
Premier,
well,
how do you respond to,
we get every...
an allegation by your colleague Anthony D'Adam that he was bullied in caucus and bullied by you?
Point of order.
A point of order has been taken. Mr. Nanver on point of order.
It goes to relevance. I don't know that the deliberations of the State Parliamentary Labor Party are relevant to the
part of the
estimates of
administration
expenditure
of the-
from the Consolidated Fund and related
The
budget
administration of
papers.
the
I just ask that you rule it
Yeah,
out
I
of order.
think I will uphold it. I think you'd
Well,
have
the
to
Premier
expand...
doesn't want to answer it. Do you want to answer
Well, no, I'm
I
ruling on the
respect
point
the
of
upper
order.
house, I
There was there was
No, you
nothing...
don't. No, you
Order, Mr. Tudorhope. There was nothing in that question that was remotely relevant to the budget estimates of 25, 26. So maybe you'd like to expand the question, but I do agree with Mr. Nanver that was about internal deliberations of a political party and nothing other.
Well, in relation to discussions in relation to potential protests in respect of the Harbour Bridge you were asked previously,
Yep.
one of your caucus colleagues said that he was bullied in relation to his views in respect of those protests in caucus. How do you respond to an allegation that he was bullied by you in caucus?
Well, look, I reject it. I reject it.
You say that he was wrong?
I mean, if the allegation is directed at me, yeah. I mean, I'm not going to tap dance around it.
Thank you.
Thanks, Chair. Yeah, just a quick one. Just back to the Great Koala National Park, Premier. The pre-election commitment, my understanding is the budget allocation was $80 million. Is that intended to be the final budget allocation for that project?
No.
So you will need to add more money to it, is what you're saying?
Yes.
Yeah, thank you. And then just a very quick one in relation to whether or not you've received any correspondence from the Commonwealth about DECU's operations at Terrell Station in relation to water flows. I realise it's quite a specific question, but have you had any correspondence in relation to that?
Can I take it on notice?
Yeah, that'd be great. That's all I have. I don't
Just
know.
in relation to Glebe Island Port, Premier, have you made a decision in relation to the future of Glebe Island Port?
No.
When will you make a decision?
Soon.
Soon being what time frame?
I don't know. There's a few questions that we haven't satisfied ourselves on, and I don't know, but I acknowledge that we've got to make a call one way or the other.
There is a review taking place at the moment. Where is that up to?
I don't know, actually. I mean, look, it's a decision for Cabinet. It'll be a big one. We're building I think the latest estimates are a $1.5 or $2 billion metro station on the site. We've got to make a decision about the best use of the land.
Thank you, Premier. Premier, one of the greatest contributors in New South Wales to meeting our net zero targets is land use change. How can we have confidence that those targets are being met in New South Wales when we don't currently map, record and report on revegetation in this state?
Don't we?
No.
I don't know. How do I have confidence that we don't report on revegetation?
How do we have confidence if land use change is the one of, if not the most significant contributor to us meeting our net zero targets?
Yep.
How can we have confidence in that we're meeting those targets if we're not mapping revegetation and reporting on revegetation in this state?
Well, perhaps we should be. What's the best way of bringing that about?
Using slats that maps land clearing to map revegetation.
I saw an
No, we
episode
don't.
of Clarkson's Farm recently, and he had rewilded several of his farms.
Yes, he has.
And all he had to do was to mow it once a year.
Oh, come on, guys. Be careful.
Well, that's
Be careful.
Well,
it's not me. It's not my farm. I'm just watching a television.
We're not going to mow ourselves out of the climate crisis.
Order. Miss Higginson, you might not like my question, but it's a good one.
It's a good
and
one.
it was answered well by the Premier. Now, the other question I have is the largest land use land zoning class in the state is RU1, agricultural land. Farmers are allowed to put a second dwelling on their property, but invariably don't because of minimum lot size requirements that mean that they cannot then subdivide. Subdivide. Is that something that we should look at to get more housing in regional, rural and remote New South Wales to make sure that we get more housing in those areas?
It is something we should look at, provided it doesn't result in the net reduction of farmable primary producing land. And I've got to make sure that when we're looking at these questions, housing is obviously a major issue, particularly in regional communities. It's not just a Sydney thing anymore. I mean, I've been, if you go down the south coast, particularly Kiama, they'll tell you this is a major issue for those communities. And I think that is part of the answer, but it just can't then become track housing or a Trojan horse because, as I mentioned earlier, this is going to have to be a big part of the mix of economic expansion and productivity for the state.
Thank you, Premier. Thank you very much. Well, that concludes the questions. Thank you for attending this hearing. We are finished with the questions. There was a few matters taken on notice. Thanks very much, everyone. The government had no questions.
Well, Premier, is there anything further you'd like to add to
Oh,
that?
apologies.
Thank you.
Apologies. There is.
You don't
Is
need
there
that much
anything
time.
further?
No. I mean, look, the only thing I'd say is thank you. I look forward to the next time, and deep respect for the upper house, and appreciate the questions in
can't mislead
the
us.
way in which the questions were asked.
Thank you for the sincerity. Thank you, colleagues.
Thank you
We
for
will
all
return
to the
at
contrary.
2
Got any
p.m.
proposals to abolish?
2 p.m. we will recommence the hearing into Portfolio Committee Number 1's inquiry into budget estimates for 2025-2026. Welcome again, and thank you for making the time to give evidence. Just before we swear any witnesses, I note there are witnesses in the overflow seating area. I would like to remind you that if you come forward, and when you do come forward to answer questions, to please bring your nameplate with you and place it in front of you at the table at my right there. This will assist Hansard in ensuring the correct witness is identified in the hearing's transcript. That said, thank you again for all attending. All witnesses will be sworn prior to giving evidence, and beginning on my left with Ms. Lowe. Could you please state your name and position title and swear either the oath or affirmation, please?
Katharina Lowe, New South Wales Public Service Commissioner. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr. Ontonji.
Bola Isunji, Auditor General for New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you.
John Hatzister, Chief Commissioner, ICAC, New South Wales. I swear the evidence about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. Commissioner, if you could just pull that mic a little bit closer, it's a directional one, just so we can hear you properly. Thank you. Ms. McCullum.
Rachel McCullum, Electoral Commissioner for New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr. Johnson, thank you.
Yes, thank you. My name is Peter Johnson. I'm the Chief Commissioner of the Law Enforcement Conduct Commission. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. So help me God.
Thank you. Mr. Clayton?
Chris Clayton, Acting New South Wales Ombudsman. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. We swear the rest of the witnesses. Yeah, if you could just come forward. We'll start with Miss Mijotto.
I'm Claudia Magotta. I'm the Deputy Auditor General for New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr. Colagiorgio.
Peter Colagiorgio, Executive Director, Quality Improvement and Performance, the Audit Office. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Mr. Bergeron.
My name is Hugo Bergeron, Acting Executive Director, Funding, Disclosure and Compliance with the New South Wales Electoral Commission. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Ms. Ward.
I'm Michelle Ward, CEO of New South Wales ICAC. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. Ms. Summerell.
My name is Andrea Summerall, Executive Director Elections, New South Wales Electoral Commission. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr. Catchpole.
Doug Catchpole, Chief Financial Officer, New South Wales Electoral Commission. I swear the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. So help me God.
Thank you. Ms. Anderson. Is that it now?
Christina Anderson, CEO of the Law Enforcement Conduct Commission. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And Miss Jaschke?
I'm Tiana Jeske, Director of Policy and Programs from the Office of the Public Service Commissioner. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. Thank you for doing that. We'll now begin with questions from the opposition.
Thank you. Thank you to each of you for appearing today and for the very important work that you all do for New South Wales. I might just start with the Electoral Commission. The Commission received an appropriation of around $118 million in the 25-26 budget. How does that compare to the total level of funding you sought?
Thank you. Yes, it was slightly lower than what we did seek in the budget. The main difference was in relation to a bid that we made for a higher labour expense cap for ongoing staff. So our submission was for approximately 70 additional positions to be funded within the labour expense cap, and we were provided with sufficient additional funding for 53 more positions.
And what impact would that have on, say, the 2027 state election? Because I know you use a lot of contractors as well, but what impact would that have in the next big upcoming election, our state election?
We do receive a separate appropriation for the event. Part of the reason that the Commission has for several years sought a higher level of ongoing funding is so that we can retain expertise, retain knowledge in between elections to a greater extent than we've been able to in the past, and also to hopefully to lessen our reliance on contractors. So we do, in our event budget, which is a temporary budget for a 3-year program for each whole of state election, we are reliant on temporary contractors for those for the event to run smoothly. So what we got is a welcome injection of funding, which will help us to reduce to some extent that reliance on contractors, and also to have retain knowledge and experience in staff that have only previously been able to be employed on a temporary basis due to the temporary nature of the funding source. So there is, I feel that we are in a slightly better position than we were before the budget in relation to the 2027 election. It is still not the case that our legacy IT systems are in any way assisted by the staffing injection that we have had. So we are still, we were not successful, as you know, the year before in relation to a digital modernisation program. So we have been given some additional funding, which was welcome towards some critical systems maintenance for the 27 election. To the tune of about 8.4 million additional funding for IT systems, but they are funding that is more in the nature of band-aid solutions rather than longer term. So we need to look ahead not just to the 27 election, but to the 28 local government elections and the 2031 state election as well. And so whilst we're in a slightly better position than we were before the budget, we still have, it is still likely that I will need to come back for next year's budget and the year after it is. There's always a big election only a couple of years ahead, and so we will probably be back seeking more funding for ICT and staffing.
With the outdated legacy systems, is there still the possibility that because of that it could undermine the delivery of the 2027 state election? I think that was some of the evidence that your predecessor gave.
I think...
Yeah.
Sorry. Yes, I think there is still a risk that with very old legacy systems, there is always a risk that due to the evolving security environment, the evolving technology environment generally, that our ability to maintain those systems running smoothly in a large election event is compromised. So there is a risk, and as we have said in previous submissions, it's a risk that's difficult. You can't mitigate that risk by more time, giving ourselves more time to fix it. The election date is fixed. Well, almost. It's perhaps not for the next election, but generally there is a hard deadline. So it is the case that we perceive that we have a risk where we have some very a significant reliance on some very valuable key staff who know about our old systems and are doing their very best to maintain them so they're in a workable way for them.
What about, is the level of appropriation you're currently getting adequate to combat things like cybersecurity threats, misinformation, other logistical failures? Like, are they some of the risks that we could face at the 27 election?
Yes, we did receive some additional funding for cyber security measures, and we are appreciative of receiving that additional funding. There is always a risk, and we're very mindful of that, about cyber security threats, especially in the electoral environment. We will. And in relation to non-cyber related matters such as you mentioned disinformation, misinformation, yes, there is more work that we could do and we would hope to be able to do to participate in community education sessions about, activities about how the voters, our voters and our election participants can inform themselves about the information environment in which they must operate during an election. So there's always more we could do. We're cognisant of recommendations that the Parliament has made in relation to participation by the community in relation to elections. We will probably need to come back to seek more fundings for staff to be able to do that on an ongoing basis. We haven't traditionally had that. We don't traditionally fund out of those temporary election budgets that I mentioned an ongoing community education and civics function. That is something we are keen to enhance, and we may be coming back as part of the next budget to seek some of those types of additional funding for those types of activities.
Why did you put in a request for a much lower appropriation this year compared to last year? I know last year was more ambitious in terms of the appropriation that you're seeking, and this year was sort of pared back a bit, but so a lot of the issues still remain in terms of these legacy systems and temporary contracts and that. What was the rationale behind that?
Yes, to some extent it was pragmatism.
Yeah, I assumed, yeah.
Yes, so I was appointed in December and the general budget cycle requires bids to be ready by January. I decided, and I was also aware that the sort of financial environment which the government is operating in is tight. So I determined that it was more pragmatic to seek a more modest funding injection to deal with the immediate issues that we faced in relation to staffing, rather than a more ambitious rebaselining where we could factor in the things that we can't do at all now because we're not funded to do it. So we were informed, I suppose, by the impacts that had occurred by not being funded the year before. So there was significant loss of staffing in that last half of last year. So that is the reason for the more modest. I did not make an assessment when I was appointed that what was put in before was not what was required. This was more what is required right now to be able to have the best chances of success at the 27 election and all of the by-elections that we must run in between. So that is the reason it was a more modest. And we did ask, as I said at the start, we asked for more than we received. But we are in the middle of that, implementing that new, using that new funding. So we will be making some changes to our structures to make the best use of that in the lead up to the election.
And I think you've said that the former funding allocation for the 2027 state general election was significantly lower than what is required.
Oh, yes.
And that you based your revised bid on more recent election costs. Could you outline
Yes.
how large that gap was, and what drove that?
Yes, I think it probably the gap was double. So what generally happens with events, as I said, we know when they're on, fortunately in New South Wales. So the Electoral Commission does receive amounts in its budget foreshadowing those future events. And it isn't uncommon for the Commission to come back to government and closer to the time and ask for supplementation. This time it was a significant gap, so we did seek almost double. So we're at the moment we're estimating that the 27 election will cost in the vicinity of about 220 million to run. So we came back and asked for about half of that, so that we had the full amount in our budget, so that we could, as I said, we run these events as a program, so a 3-year program. And that is
So you'll be back asking for more next year?
Oh, not in relation to that event budget.
Right.
Sorry, I should say. No, in fact,
for the 27
I've said.
election.
I beg your pardon.
For the 2027 election, you'll be.
No, for the 27 election, that's the additional that's the amount that we say will cost in addition to what our ordinary funding is. Sorry, so that we won't. I think it is.
It's one-off.
I'm
funding.
optimistic that it is. We're not coming back for more funding for that election. I can't absolutely guarantee it. The environment may change dramatically, I suppose. But what I have actually said to our our oversight committee is that we're actually going to work quite hard to see within that amount whether there is more efficiencies that we could find, so that we're not actually spending that amount of money for the event. The additional funding appropriations that we received are outside of that event, that 3-year program event budget. So the staffing matter that I talked about, the cyber, that is outside and in addition to that amount of money.
Thank you for that. I might come back later, but that's very helpful. Thank you for that evidence. I might go to you, Mr. Hasistogos, on a few matters. I wanted to talk about, ask some questions on Operation Aspen, which has brought to my attention that that Mr. Saravinovsky's been served notices of court attendance, and that he the matters listed in the Downing Centre local court on the 25th of September this year. Are you able to provide any information to us about why this matter didn't proceed to a public inquiry or public report?
We didn't conduct a public inquiry on it.
Yes. What were the reasons behind that, or behind why it was sent to Office of Local Government and to the DPP rather than going to a...
The Act requires us to focus our attention on serious and or systemic corrupt conduct. And it requires us to focus on the public interest as opposed to the private interest. The issues that were raised in this matter were largely conflict of interest matters which related to breaches of the Code of Conduct. I can't remember precisely it was a long time ago since the decision was taken, but it sometimes is the case in these matters where the underlying conduct is more in relation to Code of Conduct matters, that they go to the department particularly in local council case. Not always the case. If it involves a potential for criminal conduct and a likelihood of a finding of a serious corrupt conduct, that would be a different situation. But bearing in mind all factors in this case, the nature of the matter and the nature of the issues that were raised, the view was taken that it should be referred to the Office of Local Government, which did its own investigation.
Right, and so it didn't meet the threshold of serious or
in the view of the
systemic
commissioners.
Corruption. Did the commission outline any action that the Office of Local Government should undertake?
Look, I don't want to go into the details of this matter. I will give you some information, however, to assist you. I do understand your interest in it, and there may be a time when we can provide you with more information. But at this point in time, you'd be aware that there are criminal proceedings on foot, which the Director of Public Prosecutions has authorised, and I need to be circumspect about what I say.
Yeah.
So let me just say this to you. First of all, can I thank you, particularly, but also your colleagues on the Legislative Council, for the terms in which you adopted on the 7th of May, 2025, the resolution which exempted Commission material from the call for papers that you made. That was following, as I understand it, a letter that was sent to you by the principal lawyer for the Commission. We were asked by the Cabinet Office to correspond directly with the clerk, and that's what we did. Now, we have updated our website to indicate the prosecution proceedings. I refer to you to what's on that website. It's not appropriate for me to disclose the nature of the Commission's ongoing involvement concerning matters of this nature beyond what's been placed on the website. I understand, however, that there was some evidence given by Mr Honig to the Portfolio Committee, number 8, on the 28th of February, that there were some separate matters that the OLG was considering. There was some consultation with the Commission about that. However, I want to make it quite clear that they're matters for the Office of Local Government. They're not matters for the Commission. It is not unusual for the Commission to refer matters to agencies such as OLG for investigation or other action under Section 53 of the ICAC Act. The Commission, when doing so, can request a report under Section 54 of the Act. The Commission must consult with the agency under Section 53(5) when it makes its referral, and it can recommend what action is to be taken and the time frame over which it is to occur. The Commission can also communicate any information which the Commission has obtained during its investigation of conduct connected with the matter. Such information would ordinarily be submitted subject to secrecy provisions of Sections 111 and 112 of the ICAC Act. When a referral is ultimately made, the Commission is ordinarily consulted about the investigation plan and who will conduct the investigation. Under Section 55 of the ICAC Act, it's a requirement that the relevant authority to which the matter has been referred comply with any requirement or direction of the Commission under Part 5 of the Act. If the Commission is not satisfied with the action taken by the relevant agency, it can, after informing the agency and considering its comments, submit a report to the Minister, and if still not satisfied, it can report to the Parliament under Section 77. The Commission ordinarily, when making a referral, would not be involved in any disciplinary process that follows. That would be a matter for the agency, although it could recommend that consideration be given to any such action. The conduct of disciplinary proceedings that may be brought is a matter for the agency concerned. The circumstances in which a referral could be made are generally where it no longer requires the use of the Commission's resources, and the matter could more appropriately be dealt with by the agency at an agency level, bearing in mind the specific provisions of Section 12A of the ICAC Act. The Commission's referral in this case was first made on the 14th of December 2022. The information was supplied to the Office of Local Government following a Section 112 variation on the same day. And following a further request, the Commission made another variation on the 19th of January of 2023. Made another variation on the 24th of January of 2024 that enabled material supplied to the office to be annexed to the OLG's report to be used in disciplinary proceedings. Whilst material supplied by the Commission may be the subject of the secrecy provisions, the fact that an investigation is a matter for the agency to disclose to its minister should it determine it's appropriate. There are a number of issues that arise as to the process of using sections 53 and 54 of the ICAC Act in Office of Local Government matters, particularly in matters involving councillors. Do I finish? Or?
Yep.
Although it wasn't an issue in this case, the OLG uses the provisions of Chapter 14 of the Local Government Act, in particular the powers that it has under Section 440 H subsection 2 of that Act, to investigate. The interaction between these provisions is something that we have raised previously in the context of an ongoing review of what can be broadly described as councillor accountability. The terms of Section 440 H subsection 2A refer to the Commission referring a matter being satisfied that the councillor has or may have engaged in misconduct, which in the context of the ACAC Act is meaningless because our findings are as to serious corrupt conduct, and at that point it is unlikely that we would be referring a matter to the OLG for investigation. The review process has had a lengthy history. It commenced, this is for the provisions of councillor accountability, it commenced in 2021 under the previous minister, changed course with the change of the government. We've made our submissions to various reviews. I understand the OLG intends to release these at some point. I've reported on the Parliamentary Joint Committee on these matters. I'm just urging those responsible to finalise it because it needs attention. The framework is just not functional.
Thank you, Commissioner. Mr. Latham, you have 10 minutes.
Yeah, thank you, Chair. And just to follow up with the Commissioner, John Hasistagost, you just said then that the matter changed course with the change of government. How could that be?
Well, there was a review being done by the previous minister. That was
Tuckerman.
Wendy Tuckerman, the Minister for Local Government, and she did a number of reviews, including she used external consultants. I think it was Mr. Keller, who did a review. In any event, there was a review done. We made submissions to that. The new minister came in. He thought that the matter should be dealt with afresh, and he put a new discussion paper out. He invited submissions. We made a submission. We've asked for our submission to be made public. I told the Parliamentary Committee that I'm going to take a different approach in future with these submissions, that if they're not going to be released in a timely manner, we may be inclined to just release them ourselves. I don't know where the matter's up to. It's been a long time. I know there were a large number of submissions, but the matter needs to be progressed, and those of you who are in positions of responsibility, I'd encourage you to look at this issue. I know one of your colleagues in the Legislative Council, Ms Milat, raised it following the PJC meeting where I addressed this issue.
Right, so you asked Office of Local Government in your submission to the Honig discussion paper to make your material public, but they didn't do that.
I understand there's been some parliamentary questions. And the latest response has been that they intend to make them public, but there's a large number of them. If the PJC asks me for it, I'm going to provide it. I'm accountable to the Parliamentary Joint Committee. If the Parliamentary Joint Committee asks me to produce it, I will provide my submission.
Right.
And I'll provide the previous one. I have nothing to hide about this. We raised concerns about the process. We raised it with the previous minister. We thought it was going in a direction. The new government wanted to go in a different direction. That's fair enough. That's their prerogative. We put a submission into that process. I don't know where it's up to. I can't answer that question.
In terms of the new government wanted a new direction, Does it go any further than Minister Honey issuing a discussion paper and calling for submissions, like to start afresh from the Tuckerman?
They got a large number of submissions. I know that much from the answer that we got to the parliamentary website. They put out a proposal.
This is just about Bill Saravanowski. They got a large number of submissions.
No, not about this. Is about the process for councillor misconduct. There's nothing to do with Mr. Saravanowski.
Oh, okay, sorry.
I raised this in the context of the relationship between us referring a matter to OLG and OLG investigating. That's the issue that I'm raising.
Okay, so your reference to a change of direction is not in reference to the Saravanowski matter. It's more the public handling of these complaints about
It's the way these matters are processed through OLG.
Okay. You said earlier that it's not unusual for ICAC to refer matters that don't meet the criteria of serious corruption onto the agencies. We were told at budget estimates this is the first time ICAC's ever referred anything to Office of Local Government. Is that right?
I'd be surprised if that was the case. It's certainly not the first time we've referred these kinds of matters to agencies. I'd have to take on notice whether it was to OLG, but I can tell you something. There's a number of them that have been referred to OLG. They may not involve councillors. They may involve other local government personnel.
That's what we were told.
I don't know what the context in which it was raised, but I'll take that on notice.
Yeah, if you could just check, was it the first time a councillor?
There certainly have been other actions. There are certainly other actions which have been taken by. There's certainly action that's been taken by the Office of Local Government in relation to council misconduct in the past. They're on their website.
Right.
What I think they might be referring to is a circumstance where we provided information to them of the nature that we provided in this instance to the Office of Local Government to progress their investigation. That may be what they're referring to. I don't know whether that's the first time or not. But we provided information to them. It's protected information, so I can't disclose it, so that they could proceed with their investigation.
This was on the 19th of January 2024.
It's the date I indicated.
Right. Okay. You provided protected information at that stage.
No, incorrect. But information was. 19th of January 2023 was when they requested a variation. And that variation was made on the 24th of January 2024. So there was a 112 direction made in relation to that material, which is our secrecy provision. So they couldn't use the information that was provided to them except in circumstances which the direction permitted. They sought a couple of variations of that to be able to use that information for limited purposes, and we granted those variations. Right. And one of those variation requests was on the 19th of January. I need to be very careful.
Yeah, sure.
Apart from the criminal matters that are forward, there are other issues of some sensitivity that I don't want to go into.
Mm-hmm.
And there may be an appropriate time where the situation may change, but I need to be very careful. I do understand you're interested in this matter, but I think you need to just take a pause on this and just let the process take its course.
Well, we're all keen for letting the process take its course, but we've also established a parliamentary inquiry through the Public Accounts Committee into matters relating to the interaction between the Minister and the head of the Office of Local Government, which is obviously within our remit, and we'll pursue those with the sensitivity that you've mentioned. But in terms of what the Office of Local Government did with the material you referred to them, and we go here on the evidence given at budget estimates by Minister Honig, there's an element of surprise that they were so minor. By the time they got to NCAT, Saravanowski got a tap on the wrist with no action taken against him, no prohibition on running again for Bayside Council. There were two matters of knocking over a bottle of water and losing his temper with staff, and a partial declaration of interest on a developer matter where he left the chamber and didn't vote or participate in the debate. And NCAT, in the end, with the Office of Local Government, they sort of did a plea bargain about these things. So is that an accurate description of what was referred by ICAC to Office of Local Government, or have they embellished that?
Look, I'm not going to go into that detail at the moment. The issues, as you'd be aware, have now progressed since then somewhat in the way that I've described, and I would prefer to be cautious and not go into that detail.
Was ICAC confident that the staff complaints had been made through the proper channels? Because the Local Government Act requires the staff to make their complaints about the mayor through the general manager, and there's one suggestion that didn't happen.
I'm not aware of that.
Could you take that on notice, because it's important?
Don't know if I can answer that, but I'll certainly
If you
take
can
it
try
on
on
notice.
notice, that'd be
All right.
appreciated. To the the Commissioner of the LEC, if I could, thanks. What's the LEC policy on non-publication orders?
We have some guidelines which we use in that respect.
Are they published?
There are some published guidelines about the use of public and private hearings and also the use of pseudonyms. You'll find them on our website. Our Act, of course, involves broadly two types of reports. The first are public reports under sections 132 or 138 of the Act. The second is a report which goes to the Minister for Police and Counter-Terrorism, the Commissioner of Police, the complainant, if known, under section 135 of the report. Those reports do not become public unless some step is taken to make them public. So I think the question can't be answered in the abstract because it's a question of a non-publication order in what context.
Well, in the context of the gin bottle scandal with Karen Webb, which in the material had no police surveillance or policing techniques that needed to remain secret, no national security. It's a simple matter of someone's relationship with the producers of the gin bottle, the Hopes, up in Pecolbin. I've got two questions. Why was there a non-publication order on something that had no sensitive material to it and was overwhelmingly in the public interest for people to know the truth about what the Commissioner had done? And why didn't LEC provide any reasons for the non-publication order, just a stamp on the front of the report?
In answering that question, I should indicate that Operation Aspen, which is the gin investigation, involved the Section 135 report, and there is a second phase of that which is ongoing. And I'll answer that question by reference to the first phase. The Commission undertook that investigation by exercising statutory powers. Notices issued, documents were obtained, accounts were obtained from the Commissioner of Police. Having regard to the conclusions reached, which I should indicate are in a media release dated 7 August, which the Commission put out, the Commission took the view that a non-publication order was appropriate because there are persons named in it who hadn't been approached for information directly.
So what?
Well, it goes... There are questions of privacy which were considered relevant.
You're kidding me.
Now, that was the foundation for the non-publication order in effect. It stood. There was no application to vary it. When the report was provided to Parliament under Standing Order 52, there was no application for it to be deprivileged. So that's where things stood.
But why no reason for giving the non-publication order? Why just the stamp? You're saying the privacy concerns of the people who benefited from the purchase of the gin bottles?
No. Persons who are mentioned.
Why is that a
public
consideration?
servants who wrote documents, other persons who were mentioned in passing, members of staff who were not the subject of questioning, but who were mentioned in passing. The persons who were mentioned in the end, and certainly in our press release of 7 August, which was the day after the report was provided to the Minister and the Commissioner of Police, were Commissioner Webb. She was named in our press release, as was the substance of the matters which were considered in the report. But other persons were not named in our press release, and it noted that there was a non-publication order that was made. The Commission takes the view, and you are wrong in asserting that non-publication orders would only arise if there was some operational information, police, practice, matters of that sort. Non-publication orders can be made for a range of reasons, and in this because of the restricted nature of the investigation, effectively a paper investigation, the view was taken that the names of incidental persons should not be published. And that's what
Can we
was...
get a copy of your policy on notice, please? Because it's very hard. I rang up, LEC, couldn't get a... no one came back to me to get a copy of
the
your policy.
guidelines which
Where are they?
which exist, we will provide.
Thank you, Chief Commissioner. Thank you. I will now turn to some questions from the Greens. Ms Boyd.
Thank you very much, Chair. I think I might just hop around between you if I can. I'll start with you, Mr Johnson.
Yes.
Last estimates you gave us some information about the work that LEC's undertaking in relation to domestic violence and police perpetration, and in particular coercive control, which was welcome news. Do you have any update on what that work is looking like?
I may have mentioned last time that we were introducing a strategic intelligence function, and we have dedicated staff working in that area. And they have undertaken work in this area which informs the work of the Commission generally. And that work is assisting in the approach which we take to looking out for complaints of that sort and matters which we need to consider by monitoring police investigations, if there are police investigations, and informing of the work of the Commission more generally. So the principal update, I suppose, is on the strategic intelligence side, which is developed.
I think last time the question I asked was based off of some constituents who had been coming to my office asking for help because they were victims of perpetration of coercive control by police officers, and they were saying that their requests to the LEC had gone unanswered or unfulfilled, and they were looking for a better understanding from the LEC as to what police perpetration and systems abuse in particular might look like. Has there been any change to the LEC's approach to complaints such as those? Is it worth me, saying to these people who are still looking for help that they should perhaps try again with the LEC?
I would not discourage anyone from coming to the Commission. There is a very significant number, in fact, an increasing number of complaints that are coming to our Commission. And in fact, integrity commissions throughout Australia are experiencing the same phenomenon. It's certainly the case with us. If someone has raised a matter with the Commission and is dissatisfied in some way, we certainly want to hear about it. And of course there is a pathway to the inspector of the Commission, which is available as well if people have issues they want to raise. We are conscious that our primary statutory charter is that the principal investigators with respect to alleged misconduct issues are the police, and thus referrals to the police are regular. But if that happens, we scrutinise what they do. We consider the triage at the end of the investigation. We can give certain directions of one sort or another if we do not share the view that the police took. And that process is of particular interest to us in areas of alleged coercive control or domestic violence where the alleged perpetrator is a police officer. We are conscious of the sensitivities in that area. We are conscious of the reluctance of people to actually come forward, in particular in regional and country areas, and of other aspects which make it particularly sensitive. We have had people approach the Commission, and we have, in circumstances where there is nervousness about what to do, taken steps to make sure that they speak to, for example, a female officer of the Commission with some investigatory experience to assist them to understand the possible ways forward. There have been some examples of that type. So I would ask you to encourage people to come to the Commission. We are, of course, a relatively small agency. There's only 120 or so people, and that covers a multitude of functions. But this is an area of great importance to the community and to our agency and to the police force, who I think have lifted their game in this area, but there are always areas for improvement.
Thank you. We'll continue to send referrals to you then. Can I just ask, one of the Disability Royal Commission recommendations was in relation to, they had identified that police did not necessarily have the skills required sometimes in dealing with people with disability, and that was leading to obstacles to getting justice. One of the recommendations the police haven't taken on board is that they have specialist disability liaison officers. Given that this was identified as an area of concern, though, has the LEC been doing any work in relation to those issues? Are you seeing an increase in complaints from people with disability around treatment from police?
I'd have to take that on notice as a specific question, and I'll seek some more specific information to respond to it. Generally, we are very anxious to extend the capacity of the Commission to receive complaints from people who do not have English as a first language, who have other disadvantages which affect them. I cannot at this stage indicate to you a particular aspect that affects persons with disability, but we are conscious of matters of this sort, and I will seek to answer that in a fuller way on notice if I can.
Thank you. I'll go to Ms. Lowe now. Another one that I ask about every time is in relation to the disability employment targets in the public sector. And we are continuing to sort of fail, if I may say so, in employing sufficient numbers of people with disability in the public sector. We spoke last time about getting disaggregated data so that we could look at what exactly the sort of percentage of people was with a cognitive disability versus a physical disability in particular. And my recollection is you said that work was being done on that. What is the progress of that?
Sure, and thank you for your continued interest in this very important area of disability employment and inclusion. And as you'd be aware, the Disability Royal Commission did make a couple of recommendations around disaggregated employment targets, as well as employment targets for new public service hires. So my office is progressing work in relation to a number of Disability Royal Commission recommendations in collaboration with other areas of the sector and with relevant people as well. So for example, we're working with the workforce planning area in the Premier's department. They are now responsible for data collection through the workforce profile and through the People Matter employee survey. So we're working with them to explore the options around data collection, measurement and definitions as well. The graduate program also now sits with the Premier's department, so we're engaging with them. There's always been a big focus in the graduate program in employing graduates with disability. We're also engaging with the Disability Steering Committee, which has representatives from all of the departments, including people with disability, to understand what agencies will need to do to support the implementation of the recommendations, not only changes to their systems, but programs and initiatives to help achieve any targets that are set. And finally, we're engaging with employees with disability, which is really important. So the work is progressing. I can't provide you with specific timeframes when we will land a target, but it's just really important that we engage with the right people, including people with disability, before we set those targets.
Yeah, my next question was going to be, when will we have that disability, the disaggregated data? Like, I understand that, in terms of, yes, of course we want a co-designed strategy for how we get more people into the public sector, but when we're talking about just getting hold of that data, what is the time frame we're looking at to?
So I'm not in a position to provide you with a time frame at this point in time. As I've said, we're working with the relevant area of the Premier's Department, which is now responsible for collecting data, whether that be through the workforce profile process, which is census data, and also through the People Matter employee survey.
Okay, thank you. I think we're out of time. It's going to ding in a minute, Chair.
Thank you. The opposition, Mr. Tudor, Mr. Rath.
Thank you. I might go to you, Auditor General, and to the Audit Office more generally. On the local small commitments program, the report that your office put out, and thank you for that very informative report, notes that key early steps of the grants process mandated by the Grants Administration Guide were overseen by New South Wales Labor while still in opposition, including project nomination and probity oversight for those nominations. How unusual is it for the administration of grants to be undertaken by a political party rather than by the public service?
Thanks, Mr. Rath. It's unique because it's not been done before, from my understanding, and that's why our recommendation focuses on what is unique and that is not captured by the Grants Administration guideline. What do we need to do to actually capture that? So that's part of the recommendation we put out there, and outside that report, I don't have any further comments on
Did
that.
you seek to request any documents from New South Wales Labor about their grant administration before the election, or was that it was just out of your remit and you weren't able to do that even if you wanted to?
Yeah, out of the remit, I don't have any mandate to do any work outside agencies under the GSF Act.
What risks are involved in the absence of documentation of these pre-election processes run by political parties in terms of accountability and transparency?
I will say limited in the sense that, and this is where the focus of the audit went to, even regardless of what was done before, when the grant administration then is handled by a Department of State, then they have to actually make sure that what is value for money, whatever is required by the guidelines, needs to have been complied with. So I think, and the guideline is robust, but what has not been envisaged, which we recommended, is when there's an election commitment, what do you do to make sure that's covered when it's not done? And especially when the documentation sometimes will not be available, even if the department wanted to go and ask for the information. So that's, I think,
yeah.
And the reason why when I decided to take on that audit was exactly that if there's any opportunity to improve the guideline, we're able to put it out there and to ensure that someone is working through our best to deal with that.
In the end, only 17 electorates or Labor candidates that did give election commitments that went on to be funded went through a conflict of interest check out of the 93 candidates that stood for election. Isn't it, wouldn't have been better practice if all 93 candidates undertook that conflict of interest process rather than just the 17 that ultimately did?
I will agree with that.
Yeah. And the probity surrounding the period prior to 25th of July 2023, that's when the probity advisor was engaged, has been covered only by verbal assurances that New South Wales Labor had undertaken it. Is that correct?
That's correct.
You've also said in your report that in 8 cases, grants were executed before conflict of interest checks were completed. What risks does that create for the integrity of the program?
A huge risk, because if you don't do the conflict of interest prior, if you've given out the grants and then there's a conflict of interest issue, to recall the funding, will be difficult usually. So that's why when you look at the integrity of the process, all those checks will be required to be done before the grants are released.
Thank you. And in your report, you've also highlighted that in some cases, only internal cost estimates were used rather than competitive quotes. How does this compare with standard procurement expectations in New South Wales?
It doesn't compare, but I also understand for the size of the allocation, which is $400,000, you can understand if you have the internal expertise to determine what the costing is, that is acceptable. However, for a best practice, in terms of procurement, you wouldn't be able to assess best value for money, if you don't have other, recipients or entities, allowing you to actually come to that conclusion. So the risks there is more of how do you then, within the guideline, conclude as value for money in the decision that is made.
And what's the audit officer's view generally when it comes to closed and non-competitive grants? There seems to be the ones generally that get the most interest when it comes to instances of pork barrelling. Is it the audit officer's view that a better way of doing it would be an open and competitive process, and that governments should try to not use closed and non-competitive grants where possible?
Open and competitive tender is the only way to guarantee value for money, except of course in certain instances where you have specific specialist skills, and the decision to do that, you can conclude on that. And the reason in my audit work program for the next 3 years, there's going to be a strong focus on procurement and major projects, and it has to do with the fact that whether even with good intentions, there's some wrong applications of what the expectation should be in a procurement process. So we're going to focus on that. I'm going to finalize the audit work program in a couple of days. Again, I've shared the draft with both the government, the opposition, and the committees that are relevant in terms of integrity agencies. So that focus will not only find what the problems are, but to start developing what the better practices, to start understanding why it is important to go for open tender, and to start also documenting, if you don't go for open tender, the reasons why not. Because again, there will be reasons why not, and that becomes quite important for the process to have the right accountability and transparency.
Thank you. Thanks. And the only other thing I'd ask is about the strengthening of the grants administration guide, which I think you recommended, to explicitly address, should it explicitly address election commitments to improve transparency and accountability in the future? Should that be the case, and any views you had on that?
The recommendation stands as it is. So what we normally do then is we'll follow through and through the Public Accounts Committee to ensure that within the time frame we've given, that's usually within 12 months, that recommendation has been implemented. And the reason why those things are quite important is that for those who don't know, for those who are new to government, Usually that's where you find some of the problems of not knowing, but now if you have a guideline, you know what to do, and then we have a framework to hold you accountable for it.
Do you want me to ask about the regional? While I'm on the...
Auditor General, in relation to a review which you're doing in relation to regional roads funding, you're doing that review?
That's correct.
What's the time frame for the completion of that review?
Currently, it's scheduled to be tabled sometime in December.
In
December this year. Yeah.
September, did you?
In December this year, yeah.
Was there any particular project or any particular issue which gave rise to you wanting to have a look at regional road funding?
No. So if you...
Is it just a normal course?
Just a normal course of environmental scan, and the focus that we have for the next 3 years. So it's grant administration, effective use of public money. We're looking at procurement and major projects, and then, of course...
Would you normally expect to see a business case relating to regional road funding grants?
Yes, you would.
Yeah.
It's... unless, of course, again, this is what doesn't usually happen, unless there's a documented reason why not.
Yep.
Some of the things we don't like seeing, which, again, is about wasting taxpayers' money, is where you now want to tick a box,
yep,
and then you get a consultant to do a business case from the information that is known by the department.
Yep.
So we would frown upon that, because again that becomes part of wasting taxpayers' money. But that would be a reason that you have to put the...
But if it was a $50 million road funding program, you'd generally expect to see a business case for that?
For that size, yes, you will expect to have a business case for that.
Yep.
So just on the regional roads work that you're undertaking, was that, I think you said that it's a routine review, or was this referred to you by a member of parliament or a department or someone to undertake this inquiry?
It's a routine review.
Routine review. Great, thank you. I might go back to you now, Mr. Hasistogos, on a different matter. On Operation Eclipse, what reasons have been given to the Commission on why the government is still yet to implement, or at least announce a timeline for implementation of the recommendations of Operation Eclipse?
Look, I gave a comprehensive statement on this subject when I appeared to give evidence to Parliament's Joint Committee on Electoral Matters on the 1st of March of 2025. Can I refer you to the evidence that I gave on that occasion? Also, on the 8th of April, I forwarded responses to supplementary questions on notice raised by the committee. I understand that correspondence has also been published on the Joint Committee for Electoral Matters website. Beyond that, I wrote again to the Premier and the Special Minister on the 7th of July of 2025, following up from previous correspondence by me on the 21st of January 2025, 29th of May 2025, and the 30th of October of 2023, although the last letter was just to the Premier, not to the Special Minister. Yesterday, I received a response to my letter of the 7th of July of 2025. Relevantly, the Special Minister informed me that the recommendations of the Commission's Operation Eclipse report raised complex issues requiring careful consideration. However, progressing the reform to the framework for lobbying in New South Wales was a high priority, and the government is aiming to implement reforms as soon as possible.
I mean, That just sounds like they're kicking it into the long grass.
Sorry?
That just sounds like they're kicking it into the long grass. I mean, this has been,
Well,
this has been, and it's obviously, I know you can't express your frustration, but this has been three plus years now, and
it's actually longer than that, but in any event.
I mean, has the...
Oh, it's 3 years, I suppose, for this government, but the matter was going on prior to them coming into office.
Yeah.
It was going on since Eclipse, but even before that, goes back to Operation Halifax.
And the previous government did make agree
Look,
to all
Mr. Rath,
of the recommendations.
I periodically get asked the same question that you've just asked me, other than doing what I'm doing, which is writing to the government, offering assistance if they require assistance. I've sent them the reports of other states, although that may complicate the process when you send them studies that have been done in Queensland and Victoria, I think, in South Australia.
Has the Minister requested to meet with you regarding the recommendations?
He asked to meet with me last year, I think. Yes, I met with him and the CEO, I think, in the end of last year, and I raised the subject, and I got a similar response at that time. So he didn't ask me to meet just about this. It's about general commission matters, including our budget, and I asked him the question, and that's the response I got. So I need to leave it to you good people to follow it up.
Yes. Thank you. I'm certain we will. I mean, it's bizarre that the day before you're required to be here as part of budget estimates, that you would receive a letter from the Minister finally responding to your letter of the 7th of July, basically with a non-response. It's saying, you know, that it's complex issues and it's under active consideration. Apart from the meeting that you had with the Minister last year, where you proactively raised the matter with him as part of a routine meeting that you have with the Minister, has the Minister ever sought your advice or the advice of anyone from the ICAC about how implementing the recommendations from Operation Eclipse might be undertaken?
Not that I'm aware of. Each of the letters, the earlier letters that were sent, were responded to, in fairness, but they didn't really supply me with any information as to matters that the Minister was completely... the matters that the Minister was concerned about. I do recall in an earlier letter he raised that he was also looking at the reports from the other states, apart from the Operation Eclipse report. In fairness, I should highlight that because the other jurisdictions took... they looked at our work, but they also looked at their own jurisdictions and followed a analogous but not identical course.
The government did make a submission to the Joint Standing Committee on Electoral Matters, and the only concrete recommendation that they endorsed was to extend existing disclosure requirements to shadow ministers. They weren't prepared to commit to any of the other recommendations from Operation Eclipse, even though the previous government did. I mean, does the ICAC endorse the view that the most important or pressing issue is that you know, that shadow ministers disclose their diaries when the recommendations are that it should be extended to parliamentary secretaries? Which
look, Mr. Rath, this issue is not going to go away.
Yeah,
and it needs attention. And I know it's difficult and it's complicated, but I think it's better done sooner rather than later. I can only give support and encouragement to the government to do it. I've corresponded with them on a number of occasions. If there's particular issues of complexity that they want to correspond with me about, I'm happy to look into those and provide them with assistance. But I've got a lot of work on at the moment at the Commission. We have a record number of investigations. We have a real pressing workload. We've already devoted significant resources to this issue. I'm not in a position, without a government response to the recommendations we've already made, to revisit the matters that we've discussed. To me, that's not a great use of our resources. If they don't want to do it, they need to say it. If they're going to do it,
the only reason they've given at the moment
well,
is
I can't.
complex.
They're matters
issues.
that you can. I'm not. Look, I'm not disagreeing that the issues have some complexity to. I accept that aspect of it, but it's also been some time since the recommendations came out, and an opportunity, not only whilst the people have been in government, but also, of course, prior to that when the Eclipse report came out. Acknowledging, however, that there's also been further reports that have been published in relation to the same subject, which I provided to the government.
Thank you.
Thank you. Just before I hand over to Mr. Latham, I've just got a couple of questions for the Chief Commissioner, Mr. Johnson.
Yes.
The predecessor of the LEC was the PIC.
Yep.
And the predecessor of the PIC was the Police Board. Is that
No.
No.
No, the Police Board was established in the 1980s. It sat as a limited board with the Police Commissioner exercising a function to do with senior appointments and such other functions as may have been given to it over the years. It was abolished as a result of a recommendation by the Woodrow Commission.
Yeah.
It was never a police oversight body in any real sense. It had limited staff. It sat within the police ministry. There was controversy about its role, and ultimately Justice Wood took the view that it was not an option, that effectively you had to have the buck stopping with the Police Commissioner internally, with the primary responsibility being with the Police Commissioner, but with an independent oversight body sitting off it, dealing with more serious matters, the Police Integrity Commission and the Ombudsman continuing to have a function which continued until LEC was established in 2016. The Ombudsman had a role as well with the less serious matters and some other areas until 2016. So the Police Board was really exercising a different function. That's a rather long answer. I have to tell you, I acted for the Police Board at the Royal Commission, so I know a bit about it.
The right person.
It was the only time that I've had a client abolished, I have to say. So.
Well, where would the Police Board's minutes, deliberations, reports, where would they sit in government now? Who would have responsibility for them? Would it be in Premier or would it be with the police?
I'm not really in a position to answer that. I suppose insofar as the Police Royal Commission records ended up with PIC and those records end up with LEC, the Police Board records are not held by LEC. I would have thought that they were, that the Police Board records would lie historically with the records of the Police Ministry. The Police Ministry during the 80s and the 90s would have been the first port of call, I would think, to find them. Certainly not LEC or PIC before it.
Okay. All right. Thank you, Chief Commissioner. I appreciate that. Thank you.
All right.
Thank you, Chair.
Mr. Latham.
Chief Commissioner Johnson, how come the second part of Operation Aspen is taking so long, given that the first part was so extensive and all of this started nearly a year ago?
Well, the first part was done effectively on the papers, as I said to you. The second part has involved evidence and hearings, and it is in a report preparation phase. It's not appropriate that I comment more than that, except that they were two different types of investigations. The first one,
Did
the
you-
Section 135 report is of its nature a private report, and thus, but there's been a further investigation, which has already been announced and has taken some time and is, as I say, at the report preparation phase.
And do you expect that report to be completed and published by the time that Karen Webb is leaving the New South Wales Police Force officially, having been parked over in domestic violence?
I don't think it's going to be completed by that time, Mr. Latham. It takes some time, and there is a process not only of preparation of the report, but a procedural fairness process affecting a number of persons.
Thank you. In terms of your comment that the first stage was a private report, what weight did you give to the public consequences, not just for citizens in New South Wales, but morale in the New South Wales Police Force, and the right to know that the Police Commissioner is a fundamentally dishonest person?
Well, that wasn't what the first report said. As the media release indicated, there were certain findings. There was no finding of serious misconduct. There was a finding that the purchase was in accordance with policies and procedures. There was a criticism because of an undeclared conflict of interest. I'm looking at the press release to draw those matters.
But to my question about the public interest, I've had police officers off duty come up to me and say, thank goodness we found out that when Karen Webb said she barely knew the Hopes, Michael and Karen Hope, she'd in fact been on a holiday to Bali with them, had another holiday planned overseas cancelled by COVID. Their husbands had been 10 years in business together, they'd been to parties together, and the two Hopes came to the swearing in of the Police Commissioner. I mean, don't you hold the Police Commissioner to a higher standard of honesty? And this level of dishonesty drove down morale in the police force, and they were massively relieved to hear that the truth had finally come out, no thanks to Lec.
There is a further report in preparation, Mr. Latham. I'd ask you to wait for that report.
Well, I'd ask you to answer my question.
Order.
Well, I've asked about
I
the
have,
weight
Mr.
they give,
Latham.
the weight you give to the public
the-
interest and
the-
police morale, and holding the Police Commissioner to the highest possible standard of honesty, which he obviously breached. Why don't you give weight to public interest?
For the purpose of the first report, the Commission had regard to the material before it and reached the view as to the form of report that should issue, and that's what issued. There is still on foot an investigation which will lead to a report.
On the second matter of Karen Webb against police guidelines and what everyone believes is an established, decent, moral standard in policing, that you can't disclose the death of a relative until the next of kin are notified, why in the investigation of Webb telling Ray Hadley that Dawn Singleton was a victim of the tragic knifing at the Bondi Westfields, why didn't you interview Hadley or Ash, the fiancé?
The Commission formed the view it had sufficient material to deal with that upon the material which it had.
How could you have sufficient material unless you spoke to the next of kin and also the person, Ray Hadley, who had enough information from Karen Webb and enough certainty to go tell John Singleton, the father, that his daughter had been killed? How thorough should you be when clearly Hadley and Ash would have informed you of things that are integral to the investigation?
The Commission had regard to the material which it obtained and was satisfied was sufficient to allow it to reach a view on that matter.
And what
Mr. Latham,
was your view? That she hadn't disclosed?
I won't go into the detail of what was actually found, Mr. Latham.
That's
This was not
private
the
too.
subject of a report as such.
When's that report coming out?
There isn't a report as such. There was an outcome with respect to the complaint.
And what action is the inspector of the LEC taking about it, given that the next of kin, the mother and the fiancé, are still in the dark about findings against Webb that by common sense should be made?
That's a matter for the inspector.
So what then did you do about the situation whereby clearly Ray Hadley's got information off Karen Webb before Julie Singleton or the fiancé Ash have known about confirmation of the death of Dawn Singleton, and Hadley's conveyed that to John Singleton? What finding did you make against Karen Webb for her breach of police guidelines?
What I'll indicate in relation to this topic is that I'll take on notice and consider giving you something further in writing dealing with this topic, which was not the subject of an investigation leading to a report. And I will
What was it
subject
to? Because there was a complaint.
There was an investigation within the Commission. Not every matter that's looked at within the Commission ends up in a report. There are preliminary inquiries, preliminary investigations and matters of that sort that don't necessarily end up in an investigation report.
And do you feel, Mr Johnson, the Lex credibility has been damaged by this? Because clearly in the gin bottles, the Commissioner was telling lies publicly about her extensive, or she said she hardly knew the Hope, she knew them extensively, and clearly she broke the guidelines regarding the death of Dawn Singleton, and Lex seemingly has run cover for an incompetent lying police commissioner.
I do not accept your characterisation of the matter, Mr Latham.
Okay. Thank you.
Thank you, Chair.
Ms Higginson.
Thank you. I'm also going to jump around. I'm just going to start with the Acting Ombudsman, if I can. Thank you. A little while ago, the Auditor General referred a matter to you in relation to the Forestry Corporation and a potential allegation of maladministration. Some correspondence has flowed. I'm just wondering if you are aware of that matter and if there is ongoing work and when we might expect some kind of outcome, or if there's anything you can disclose.
Yeah, thanks for the question, Ms Higginson. We are conducting preliminary inquiries into that matter, and where, as you can appreciate, we conduct our investigations in the absence of the public, so I probably can't speak too much about whilst we're in that process. We've received a range of information both from Forestry and also the EPA, and we're just working through that material now, and I don't have a particular date as to when that matter will be finalised, but it's being actively worked on.
Is there an opportunity for, I know you do it in the absence of the public, but if there are members of the public who may have particular information, would they be people that you might consider contacting to assist you in your inquiries?
Yeah, absolutely. I would encourage, if people do have information that would be relevant, that they're more than welcome to provide that to us in the course of our work.
Thank you very much. Now to the Auditor General, just back on the same state-owned corporation. It's recently been reported that the public, the state-owned corporation, the Forestry Corporation, has recorded half-yearly losses of 14.9 million, which is double what was predicted in losses. They anticipated they would lose 9 million. It's now around about $90 million of public money that has just been lost managing a really valuable public resource, namely our public forest estate, since 2020. A bunch of members of Parliament have raised concerns, written to the Premier, written to the Treasurer, consistently raising concerns, but nothing seems to be happening. Is that something that you might consider looking into? I'm just very concerned. I think that I can't recall ever seeing anything so wasteful, ludicrous, concerning and in the public interest in New South Wales with public money and might I add, the public resource, this incredible asset which is our children's future, our native forest estate.
So two parts of that. So we're currently finalising the financial audit for June 2025, so we'll have a look at that process in terms of the losses. And I also received a letter that you sent, and so in my forward program, I'll probably finalize that on Friday, publish on Monday. We've included a performance audit in a draft work program to then have the more deep dive into the key drivers, some of the losses that you described. Yeah, so when we scope that, we'll scope that in terms of your letter and in terms of any new emerging risks that we see in that environment.
Thank you. And can I just put on the public record, if you would, or I'm not sure whether this is in the scope of your works, but the reality is the Forestry Corporation is also facing significant liabilities in the context of Justices of New South Wales Courts of Superior Record have described the organisation as having a pattern of environmental offending with poor prospects of rehabilitation. There is a real concern in terms of the public interest and the reputation and the good governance of these public authorities that are, or state-owned corporations that are managing public resources. I almost think it might be a matter for you, Mr. Hatzistakos. Thank you.
Yeah, and the process too, just for you to be aware. So we include this in our fall program. When we scope it, we scope the expected outcome of the audit, and indeed, just like we referred to the ombudsman, because there's maladministration, so if there's any change of corrupt conduct, of course, we also refer to the Chief Commissioner.
Thank you. And now just to the Commissioner of the Law Enforcement Conduct Commission, if I could please ask you, Commissioner Johnson, the guidelines for a critical incident the statutory criteria and definition of a critical incident in relation to, and I know you know your Act inside out and back to front, so I'm going to refer to Section 110B6, where that provision says the death or serious injury and appears to be likely to have resulted from any police operation. That kind of broader head of consideration about a critical incident. I'm just wondering if you can elaborate, how broad is that? What does that involve in terms of a critical incident? How broad is that? Is it limited? Do you define that as limited to an operation, as in it has to be an operation, or is the term operation a broadly defined concept?
There is a definition of police operation in Section 108.
Yes.
Which means any activity engaged in by a police officer while exercising the functions of a police officer other than an activity for the purpose of a search and rescue operation. Beyond that, insofar as how one defines it, one has to start with this, that the police have the discretion about whether they declare a critical incident. If they decline to declare a critical incident, they decline to give us the reasons as to why they have declined to declare a critical incident. So there can be at times, and coroners have pointed this out as well, oddities in the approach taken, sometimes as to whether something is a police pursuit or not. There are other issues where there are apparently inconsistent practices depending upon who the Assistant Commissioner was, who did or did not make the declaration. But one would think that the term police operation, assisted by the definition, is a pretty broad one. And in particular when it's following a section which talks about other things which involve the police using a firearm, using defensive equipment, using physical force, use of a police vehicle, and where a person in custody. And then, so once you look at those specific ones, you've got the catch-all of what a police operation is. And I would have thought, from a legal point of view, it's a pretty broad concept. And there have, I think, been some examples of inconsistent application. If there is a refusal to declare a critical incident, we have, as I've said, gone to the police and asked them why and raised questions if there is an inconsistent approach that's apparent. But the response to that often is a senior police officer will say that they've examined the record for declining to declare a critical incident and they're satisfied that it was appropriate. Now, this is a recommendation that we made in our 5-year report in 2023, that we have access to the police document. The police have declined that on the basis that they hold effectively an absolute discretion. Our effort to say that we're entitled on behalf of the community to consider the reason why it was why a critical incident was not declared, to see if there is a reasonable explanation, is not accepted by the police. They take the view that it's their decision and their decision alone.
Chair, can I ask a yes or no question? It's so short. The police guidelines that relate to, as in the police special branch, professional branches guidelines that about critical incidents, do you ever have input into that document?
There is certainly consultation with the Commission. I'll try and keep that to a yes, but it's a yes with an asterisk, in the sense that we are consulted because we have a direct interest in the whole critical incident area, but at the same time it's the police who devise these things and ultimately settle them themselves.
Thank you very much.
Thank you very much,
Thank you,
Chief
Chair.
Commissioner. Thank you all for your attendance today. That concludes this section. The Secretariat will be in contact regarding any questions taken or matters taken on notice, or any supplementary questions. Everyone up the back got off scot-free. The committee will now break for afternoon tea and return at 3:45.
Mr. Chairman, can I just follow up a couple of matters?
Yep, certainly. Please do, Commissioner Hatzis.
Just a couple of things.
Is Hansard back on? Back on, yep.
The referral to the Office of Local Government in the Saravinovsky matter was made on the 14th of December of 2022, in the term of the previous government.
14th of December 2022.
I just wanted to clarify that.
I think you said that.
I did? Okay. The second thing I should just indicate is that the Parliamentary Joint Committee did raise with me this question of Section 5354 referrals at one of the meetings which I have attended, about the sorts of matters we refer under 5354. I followed up and reflected on that, and we will be publishing in our annual report this year the general nature of the Section 5354 referrals that the Commission undertakes, so that people have a better idea of the kinds of matters that are the subject of those two sections. And the third thing is that I will be on leave from this Friday, but Commissioner Morell, who'll be the Acting Chief Commissioner, can respond to questions on notice.
Well, have a good break.
Thank you.
Thank you very much. All right, thank you very much, everyone. Thank you. Being 3:45, we will recommence the hearing into budget estimates 2025-2026 with our new group of public officials. Thank you very much. Before we resume the questioning, I would like to remind Mr. Draper and Ms. Boyd that you do not need to be sworn, as we've already done so. But Ms. Dobbins, Ms. Marr, Ms. Walker, Mr. Ray and Ms. Hartas, you will need to be sworn. So we will start with Ms. Walker. If you could state your name and position title and swear either the oath or affirmation, please.
Thank you. My name is Simone Louise Walker and I am the Acting Deputy Secretary for Social Policy and Intergovernment Relations at the TCO. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Mr. Ray.
Chair, Marcus Ray. I'm the Deputy Secretary, Economic, Infrastructure and Housing at the Cabinet Office. I solemnly, sincerely and truly declare and affirm that the evidence now to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Ms. Dobbins.
Thank you, Chair. Samara Dobbins, Deputy Secretary, People and Workforce, Premier's Department. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you. Ms. Marr.
Thanks, Chair. Kate Marr, Deputy Secretary, Delivery and Engagement Group, Premier's Department. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Ms. Hartas.
Thank you, Lucy Hartis, Deputy Secretary, Energy, Environment and Evidence at the Cabinet Office. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. We will now recommence the questions with 20 minutes from the opposition. Mrs. Carter.
Thank you. Thank you all. Nice to see you. I wonder if I could start with you, Ms. Boyd. Thank you. Yeah. Just questions in relation to the appearance of witnesses before the Select Committee into the Dural Caravan. And I understand that a decision was made to provide ex gratia payment for legal assistance. Can you indicate under what criteria the witnesses were eligible for that ex gratia payment?
I can. There's a Premier's memo. It's 2022-11 that sets out the criteria for who is eligible for and how we assess ex gratia payments for legal assistance.
And of those categories, which one applied to those witnesses?
I believe because they were called to attend an inquiry in their capacity as officials.
Well, if we look at the criteria and who is eligible to make an application, the only inquiries are appearing before ICAC, the LEC, a Royal Commission or a Special Commission of Inquiry, or a coronial inquest. Now, none of those are relevant. The first category is where legal proceedings have commenced against them or are known to be imminent. That's not relevant either, is it?
No, I think those are examples. If memory serves me, the memo is not exhaustive. Ex gratia payments are very discretionary in nature, and those sorts of inquiries are listed as examples.
Well, Ms. Boyd, the way it's phrased, it isn't as a list, as an open-ended list. It's not indicative examples. It says an application for ex gratia legal assistance may be made by, and the closed list followed. So that is a closed list, is it not, Ms. Boyd?
I think I just refer you to the first paragraph, which really does.
Yes, and how is the first paragraph satisfied by witnesses appearing at an upper house committee to give evidence?
Well, they are required to appear before hearings conducted by the House, and so an ex gratia payment is highly discretionary in nature, and it is in the nature of an investigative inquiry. Sorry, the first criteria
doesn't say that. It says where legal proceedings have commenced against them or are known to be imminent. What were the legal proceedings?
Well, I know you're familiar with the matter, but a bench warrant was about to be issued for their arrest by a judge.
And is that legal proceedings?
Yes.
So, on what basis? Is it legal proceedings?
Legal proceedings are not, it's not a narrow term. I mean, if you've got a judge issuing a bench warrant for your arrest, I think that would satisfy the definition of legal proceedings.
If they didn't turn up, there may have been a warrant issued in the same way that if you steal a car, you may be arrested by the police and go to jail. But is stealing a car a legal proceeding?
I'm not sure I follow that analogy, but...
Well, the circumstances in which a warrant may have been issued is if they failed to attend on a lawful summons, and if you'll go to jail for stealing a car if you steal somebody else's property, but the failing to attend or the stealing the car is not a legal proceeding.
Look, I think just going back to the principles of ex gratia legal assistance for public officials, the principle really is that you shouldn't be personally disadvantaged financially because of formal proceedings that are brought because of your job and your work as a public official, and this really fits that description. So I would just go back to the principles of that.
And isn't the role of the Premier's memorandum to actually specify the criteria according to which that general proposition may be met? Because there'd be no need for this memorandum, would there, if the general principle was just said to apply?
Well, I mean, this doesn't in any way limit the common law discretion of ministers to make ex gratia payments. It really is just to provide guidance.
So your
to
argument
officials.
is that the ex gratia payment was not made under this memorandum, it was made according to a common law right of ministers to make ex gratia payments, is that right?
That's the case in all ex gratia decisions. The memo just provides guidance.
And which
to the
minister
Order. Let's just make sure that the witnesses have the opportunity to answer in full, please.
And which minister exercised this common law jurisdiction to make the ex gratia payments?
I believe that the Secretary of the Department of Communities and Justice made the decision under delegation from the Attorney.
And so then what's the point of this Premier's memorandum then?
It just provides guidelines, which is the name of the document for officials who are considering seeking ex gratia
So your argument is that these are entirely discretionary guidelines which don't need to be met at all?
No, I think that they're very useful for DCJ in assessing claims for ex gratia assistance.
Except in this circumstance where they clearly don't apply.
Well, I have a different view about that, but I'll let you draw your own conclusions about
Sorry,
that.
what is your different view, Ms Boyd?
I think this sort of situation, it is a novel one, but it certainly would appear to satisfy the policy intent of providing ex gratia legal assistance to public officials who, through no
So we don't care about the detail of the policy, it's all a question of intent, is it? Is that how it works?
No, I think that though we always try to achieve substance over form with these matters, and the administration of justice is a key part of the Attorney's portfolio, and the power to give an ex gratia payment is highly discretionary for that reason. So,
and who decided to seek external legal advice?
I think that decision was made, and I went into it earlier in the Premier's hearing. And the guidelines foreshadow this, that while it's often appropriate for the Crown Solicitor's Office to act for public officials, it is also open to people to have private representation where there might be a conflict of interest or where the Crown Solicitor doesn't have the necessary expertise depending on the subject matter.
And on how many occasions did the relevant staff members meet with the outside legal representation?
I'm not at liberty to disclose that. I don't know, and B, it's privileged. So
why is the number of appointments with a legal professional privileged?
I think all communications between lawyers and their clients are generally
the content of that communication, Ms Boyd, not the fact of that communication, surely.
Look, I won't get into a debate with you about legal professional privilege. I don't know how many times they met.
Okay, are you able to take that on notice?
I don't have that information available to me.
Who would have that information?
The lawyer and their client.
Okay. And the cost to the taxpayer, what was that, Ms Boyd?
I'd have to take that on notice.
Thank you. If you could, that'd be great. Thank you.
Can I ask you, I'm not picking on you, but what is a cabinet document?
What is a cabinet document? I just refer you to Schedule 1 of the GIPA Act, but if you're asking in the context of a Standing Order 52, it's I'd refer you to Egan and that line of cases.
Yeah. So the policy document, which is referred to in a letter from Sarah relating to cabinet documents, which is contained in the manual at 2.3, they're not cabinet, a schedule of cabinet documents, are they? They're things that should go to cabinet.
Oh, yes. You're talking about the Cabinet Practice Manual?
Yeah.
Yeah, so that the manual just provides a list of matters that ought to go to Cabinet.
Yeah. So you would have been aware of the orders for papers relating to the workers' compensation
Yes.
inquiry and the amendments to the Act.
Yes.
Part of that order related to presumptive cancers. You do recall that?
Yes.
And in respect to firefighters, we received no documents relating to presumptive cancers. Can you shed some light on why that was the case?
Look, I'm not familiar with the contents of all of the returns, but as you'll appreciate, significant policy reforms are required to go to Cabinet, so there would have been a range of materials that were, not produced to the House on the basis that they were Cabinet, but beyond that I couldn't go into the detail.
Egan decisions, they hadn't been to Cabinet, so policy proposals wouldn't necessarily be caught by a Cabinet in confidence definition, would they?
Not always, but depends on the particular document and whether it tends to reveal the position that an individual minister took on the matter in Cabinet, and so it can be difficult to make those assessments, and the agencies that hold the documents are probably in the best position.
So no modelling, no policy variations, nothing produced in relation to presumptive cancers at all?
I can take that on notice and go back to the relevant agency and check whether they have supplementary or further documents. I appreciate there's been a further order that the House has made, and perhaps there'll be further materials produced in response to that.
Did you inquire as to why those documents hadn't been produced on the first occasion?
Hadn't been? Yeah. No, I mean, I'm not aware of any particular documents not.
See, I just wonder what the process is. You probably think I should already know this, but is the process this, that you would receive the list, or at least an index of the list, and make some sort of or provide some sort of advice, or someone in your office, and probably not you now, provide some sort of advice about what is Cabinet in confidence and what is not?
Look, we do if we're asked, but as you'll appreciate, we're talking about thousands and thousands of pages of material. We've already produced over nearly 2,000 boxes to the House this year. It's not possible for my agency to audit or otherwise review all of that material. Usually the way that it works is we perform a sort of a function whereby the House only has to deal with one agency in government as to the status of returns. So really all we are is a sort of postbox for everyone to bring their returns back to us, and then we deliver them as a job lot to the House so that it eases the administrative burden for the clerk and his team. He only has to deal with one agency to find out where things are at. But we don't take responsibility for the quality or content of those returns. Those are matters for the agencies and the ministers that hold those documents, and they're really in the best position to assess the status of those documents as to their relevance or whether they're Cabinet. If they want to ask us for advice about whether a particular document is Cabinet, we can always provide that, but we don't assure every single document in relation to every return.
So it can't be, you correct me if I'm wrong, it can't be the position that a document which is an advice for a decision of the government are captured by a Cabinet in confidence definition.
No, it certainly can be the position if the document reveals the individual views of a minister.
Well, if it hasn't been to Cabinet though.
No, it doesn't necessarily have to be an official record of Cabinet.
So, government's considering a particular policy position about something which may never ever reach the light of day because it is a policy position, but it might fall within the 2.3 definition of documents that should go to Cabinet. Those documents are not in their embryonic stages, are they? Cabinet documents?
It's a bit difficult to answer in the abstract, but perhaps if you've got a question about a particular document, I'm more than happy to go back and have a look at that.
I'm putting to you a whole lacuna of documents, all missing. Not a single email, not a single briefing note, nothing. No updates, no correspondence with anyone. Nothing. Would you be surprised by that?
I think it depends. I'm not familiar with the terms of the order or the agency that you're talking about, so it's very difficult
Well, we're talking about
to
CIRA.
answer that. Right. I'm really not in a position to respond about that, but I'm more than happy to take it on notice and make inquiries as to whether or not there are more documents coming or whether there are plans to provide a supplementary return or whether there's been an oversight and something's been missed.
Well, let me just frame it another way. If a document is provided for the purpose of policy, no decision yet, just for the purposes of informing policy, does that fall within cabinet in confidence?
It's too hard to answer hypotheticals or in the abstract. I think, a document is a cabinet document for the purposes of a Standing Order 52 if it tends to reveal the position that a minister took on the matter in cabinet and therefore undermines collective ministerial responsibility. That's the
Okay, I accept that, but if it's merely working up a potential or variety of policy positions, potentially a policy position in relation to presumptive cancers, is that a cabinet in confidence if it does not if it is not for the purposes of providing advice for the taking of a decision in cabinet?
Oh, look, I'm reluctant to answer hypotheticals because I just don't. I don't want to do that in this forum. But I think if you have a specific
a witness to the workers' compensation inquiry provided us with this advice that if it is provided for the purposes of policy, that is now a cabinet document. That definition cannot possibly be right, can it?
Oh, look, I think to be fair, it's very hard for public officials to grapple with the nuances of some of these legal principles, and I think you would have to read that in the context of policy that is discussed and decided by cabinet. So I think that's how I would interpret that statement.
So, to the best of your knowledge, there is no difference in approach in terms of treating what is a cabinet document between this government and the former government.
No, I mean, that hasn't changed.
Well, Egan and Chadwick hasn't changed.
No, it hasn't.
And so the advice which you would be giving to agencies would be that is the test. Egan and Chadwick are the tests which are.
Yes, that's right.
Does in respect of the same sort of material, there is becoming a practice that documents are just never provided in accordance with the terms of their orders in terms of timeliness.
I'm not sure I would agree with that. The sector takes serious effort to get as much returned as soon as we can. I would just say that the requests that the House makes are, in our view, quite extraordinary and unreasonable, and the demands on agencies to comply with these orders in the time that we are given, having regard to the very real risk of inadvertent disclosure of confidential information and the need to thoroughly review the documents to ensure that no personal information is produced, that other sensitive information is protected. It is a huge burden, and my observation is that all best efforts are taken to produce these documents as in a timely way. I appreciate that they're not always done within the time that you would want them, but it is a significant effort, and a lot of time and cost goes into ensuring that we do.
Well, are steps taken to ensure that agencies comply with their obligations to comply with the order of the House in relation to timeliness?
Look, absolutely, and where we have an early advice back from agencies that they're going to struggle, we will always write to the House and try to exercise the mechanism for an amendment to vary the order, to delay or get a little bit more time. That's not always agreed to by members, and that's their prerogative. But yeah, it is really challenging, and I would just say that the vast majority of people that deal with these orders are doing their very best to comply fully and within the time frame specified by the House.
Well, does the Premier's office comply with this?
I mean, that's
in
a
relation to
question
timeliness?
for them, but all agencies take seriously their obligations to respond.
Well, consistently Premiers have the fewest documents to produce. They are the worst in terms of producing their documents in a timely manner. Do you take responsibility for that?
Look, I can't vouch for, I don't know whether that's true or not. I haven't done the analysis of who is late and who isn't. I would just say that, it's responding to Standing Order 52s is not the only job of the Premier's office or the Premier's department or the Cabinet Office. We have a lot on, and the responsibilities of those entities are very broad, and so to the extent that might explain some delay, I would just offer that. But I have not done that analysis as to whether or not they are late or not.
When did you decide that documents ordered by the Legislative Council from the Executive would become subject to the will of the Legislative Assembly?
Look, no one decided that. I think you're referring to the workers' comp order, yes. I assume. Look, that is a really difficult situation for the public service to find themselves in when you're in the middle of a dispute between the two houses as to their exclusive cognizance. It's not a position that we want to be in.
Did you give that advice?
No, it was not. I
don't remember you ever giving that advice to us.
I don't know that the issue arose, but I mean, it's a live issue, and the Speaker made clear his concerns around the scope of that order, and we, in an attempt to respond to it in a way that respects the powers of both houses to govern their affairs and to be independent of each other, we returned those documents to the Legislative Assembly.
Did the Speaker seek advice from you in relation to it?
No, I mean, it's not my role to advise the Speaker.
Where did he obtain his advice from? Are you aware?
No, you'd have to ask the Speaker that.
The clerk.
But in the history of SO52s, you'd be aware that on numerous occasions, correspondence from Legislative Assembly members has been included in papers which are produced to the Legislative Council.
I can't recall if that's come up before.
It's been a regular event that correspondence between a Legislative Assembly member and a minister relating to a particular matter.
I'd have to take that on notice and consider it, but certainly the Speaker's never raised the issue with us before, and that, I think, because there are a few of these types of issues arising, it's front of mind, and so in this case it did come to a head, and we did our best to comply.
I'll return to this in my next iteration.
Thank you, Mr. Tudor. Ms. Boyd, earlier today you gave an answer in relation to the advice that was given from the Executive Council to the Governor not to agree to a request of the House to provide Ivan Milat's police and criminal records. You said because there were ongoing investigations.
I don't know. I may have misspoken. I think the reasons were that they related to criminal investigations. I'd have to go back and check whether the term ongoing was appropriate.
Who did you consult with? Who does the Cabinet Office consult with? Do they consult with the police about that? Do they make a formal submission? How is that process?
Yeah, I'll take it on notice, but my expectation would be that the Cabinet Office would consult with the New South Wales Police as the holder or the custodian of the records as to the public interest in their disclosure.
Sorry, could you say that again?
Yes, it would be my expectation that the Cabinet Office would consult with the police about that matter.
And would they be required just to say generally there's a ongoing criminal investigation, or they relate to a criminal investigation without describing what the criminal investigations were?
Yeah, we would take their word for it. I don't think it would be our practice to delve too much into that, given the sensitive nature of the matters.
How is his criminal record not like? How would his criminal record be caught by that? Just a statement of matters that were that he was charged with and convicted of, or charged with and not convicted? How would that be subject to criminal investigation?
I'm not sure whether that was part of the suite of documents that even fell within the order, and I am aware that the Department of Communities and Justice has made some documents available for inspection in relation to this matter. So
That was corrective services.
Hmm.
Yeah, that was, I had to sign an NDA to see his prison records.
Hmm.
But the SA 55 did seek his criminal records.
I can take that on notice and check.
And why wouldn't those be provided to the House under privilege?
They do. I think the view was taken that they fall within Standing Order 55. It's not a view that that wasn't, I haven't been involved in that decision making, but the view was taken that they relate, the order itself relates to the administration of justice and therefore was done under Standing Order 55, not under Standing Order 52, which has the mechanism for personal information.
So there's no mechanism under Standing Order 55 for us to receive privileged documents?
I don't think so.
And who did do the decision making?
I think that the governor obviously, determined on the advice of the minister not to provide the documents.
Yes, but who did? So ultimately, when you say the minister, like the police minister on advice to the Executive Council, or is it someone within the Executive Council?
Oh no, I think all matters are brought by the portfolio minister to Exco. So I think in this case the responsible minister was the Minister for Police and Counter-Terrorism.
Okay, thank you.
Thank you, Chair. And if I could come to Mr Draper in your capacity as one of the triumvirate on the Housing Delivery Authority. You attended that inaugural panel of the authority at its meeting on the 7th of February earlier this year, is that right?
I believe I've attended all the meetings except for one that took place in, I think it was in June.
Right, and at first meeting on the 7th of February you reviewed 30 applications, is that right?
I don't have the records in front of me, but that sounds about right.
And the biggest application you received at that very first meeting was Bill Burge's Expressions of Interest 229650 for Leeds and Averell Street roads. Do you recall that one?
No, we've done over 200 that we've considered, or actually 200 that we've recommended. There's probably more than 400 that we've considered, so I don't remember that one in particular.
You don't remember approving that application?
I don't remember that individual application.
Were you aware at that meeting that the Bill Burge expression of interest covered a block on Leeds Street and a block on Averell Street roads, including 15 Leeds Street, a privately owned block of land that was not a co-applicant with Bill Burge, and that Bill Burge did not own or have an option over that land? Surely something as unusual as that would stick in your memory?
That doesn't stick in my memory,
No?
but as a general principle, where an applicant doesn't have a tenure over the land, that would be a consideration we'd obviously take into consideration.
Yeah, isn't there a guideline that the Minister's confirmed to me on the notice paper that requires a proponent to, and I quote, demonstrate ownership or an option to purchase for all land to which the proposal applies before the Housing Delivery Authority?
Yeah, that's
You're aware of that guideline?
That's consistent with what I just
How
said.
did this one go through, and how did you approve it, given that 15 Leeds Street was in private ownership? They had no idea Bill Burge was making this application, and moreover, there's another two blocks of privately owned land that had nothing to do with Bill Burge at 19 and 21 Leeds Street, again where they were oblivious to this even happening.
I've already said to you that I don't remember this one out of over 400 that we've considered. But if you like, I can take that on notice.
If you can, because it seems like it's starkly outside the guidelines for which you're responsible.
I mean, I don't know that what you're saying is right, but I'm more than happy to have a look at it.
Yeah, well, you check it,
and answer on notice.
and you can come back and you'll be assured that it is correct. I don't deal in falsehoods. And what due diligence did the Housing Delivery Authority perform to verify each of the expression of interest claims about their hold over the ownership or an option over the land before you would proceed as an authority?
Well, the way that we proceed is that the Department of Planning provides a service to the Housing Delivery Authority panel, which is 3 secretaries, or 2 secretaries and the head of Infrastructure New South Wales. They undertake due diligence over the EOIs that come in and provide a report to the authority, and the applicants are required to answer a number of questions about just those types of matters, and where we have questions, they refer them back to the applicants to get greater clarity.
In the 400 you've dealt with, have you got any memory of ones where the applicant is acting on private land for which they've got no approval, ownership or option to include it in their development proposal?
Yeah.
You have?
There've been applicants.
Was Bill Berger at Rhodes one of
There've been
those?
applicants who have made submissions, and I remember this generally, I don't remember the specific applications, but there's certainly been applications, I remember, where the issue was raised that we couldn't be confident that the applicant and the proposal that they had tenure over all the land that they were proposing to use for the application.
Okay, can you go back and check what happened with Bill Berger, and also the fact that one of the parcels of land they included in their application was owned by Canada Bay Council, and also another parcel of land was New South Wales Crown land at 2A Leeds Street.
Yeah, we'll take that on notice.
Yeah, and how could you have approved an application that had 5 parcels of land for which the proponent had no ownership, no option and no consent?
I think I've really responded to that already. I'll have to look at the details of that one. It's one of 400 that we've looked at. I don't know that what you're saying is right. You say it is. Happy to take that on its face value, but we'll answer the rest of it on notice.
Right, but you're saying the department would have given you an assurance that Bill Berger had some authority over the entire parcel of land for which they placed an application before your authority?
Generally speaking, the department provides a report on each application that refers to whether it meets the criteria of the HDA, and we operate off that information.
Okay, Mr Draper, you were on the 16th of July this year, 2 independent owners of 15, 19 and 21 Leeds Street wrote to the department after learning only from online media that 5 months earlier their land had been swept into a state significant development you'd recommended and the Minister had assented to. Are you aware of that correspondence where they're basically saying, how could this have happened to them?
I don't know that I am familiar with that correspondence. What date was it, sorry?
The 16th of July this year.
16th of July? No, I don't recall.
So some 5 months after you approved
This is the same, are you referring to the same blocks of land?
Yeah, but this is all about Bill Berger at Rhodes. What statutory or policy notification steps under the EP&A Act and your HDA guidelines or any ministerial direction were actually complied with before you advised the Minister to call it in a state significant development on the 18th of February?
I'm going to have to take that on notice as well. You've asked me for a lot of information about a very specific application. I don't recall the details of it.
Can you understand the distress that the owners of this land have, and they believe they're at a disadvantage in any future negotiation since the planning outcome appeared to them predetermined, and effectively for them they've got to sell or miss out on development as it's played out?
Well, the planning outcome is not predetermined because what the HDA does is refer or recommend or not recommend to the Minister for Planning that he declare a development state significant for assessment under that process. If we make that recommendation and he decides to make that declaration, it then goes through a whole merit assessment process. So all of that will be washed up in the merit assessment process for the application in any case.
No, that's not an excuse, is it?
Well, it's not an excuse, it's an answer to your question.
Thank you, Mr Draper. Dr Con.
Thanks, Chair. I think my question's for Mr Draper. I've got some questions about the interim offer for paying conditions that's been made to nurses and midwives. First of all, what's your understanding of how that offer impacts the current claim that's before the Industrial Relations Commission?
I'll get Ms Dobbins to help me, but I don't believe it does impact it. It's an offer that's confined to a certain number of other claims made by the nurses and midwives. Is that correct?
Thanks, Dr Cohn. It has a very limited impact on the arbitration. It does slightly narrow the arbitration because the Commission will now not have to deal... Well, it hasn't been accepted by the Nurses and Midwives Association, is my understanding, but if it were, the Commission would not need to deal with that year of pay, and also it addresses the part of the case in relation to the penalty rates. But the balance of the case will be heard in arbitration later this year.
Okay. So to clarify my understanding, if the association accepted the 20% night duty, that would prevent them from pursuing a higher claim through the Industrial Relations Commission?
Yes, it's to settle that portion of the claim.
Thank you. Did that interim offer originate from your office?
From the Premier's department? No, we work with the Department of Health and we provide advice and support to them, but no, we don't negotiate on behalf of the employer.
Okay. Did the interim offer, did it originate from New South Wales Health or from the Ministry of Health?
I wasn't involved in the inception of it, but I imagine so. But you'd need to ask the Minister for Health.
Okay. And that limitation created by the offer in terms of the ability of the association to negotiate further through the IRC, in your view, is that in keeping with the fair pay and bargaining policy that was released in March?
Yes, I believe so. So under the policy, it's an interest area that was identified. I believe it was subject to discussions between the association and health, and as we say, the association hasn't accepted the offer yet, but they would only accept it on the basis that it were in settlement of that part of the claim, and under the fair pay and bargaining policy, it has service improvements and productivity attached to it, so it would be a meeting in the middle, I guess, of what the nurses want and what the department's willing to offer, and that is completely compliant with the policy.
Does that then, sorry, just on that, does that then create an interim award, or is it effectively just a pay increase?
It's a very good question, Ms. Boyd. I'm not sure how the increase would be passed on, whether it's a determination of the Secretary of Health or whether it would be an agreed update to the current award. I'd have to take that on notice.
Presumably, if it's requiring a vote, then it is an interim
award. Yes,
so it creates
I imagine
a new
that
instrument.
they would agree to amend the award in that regard.
Right. Okay. Sorry, just one final question. My colleague. So, did that interim offer then require ERC approval?
Yes, it did.
Okay. Thank you.
Can I just ask, and I'm not sure who, perhaps you, Mr. Draper, but have you looked at the Jumbana independent review of the Closing the Gap? It was the independent Aboriginal Torres Strait Islander led review of Closing the Gap target and the targets achieved. Has anyone in Premier's Department had a look at that? It was released in June. Jumbana. So the institution housed in the University of Sydney, and I just assumed
it hasn't come across my.
Okay.
But I'm sure we've got the Department of Aboriginal, the Office of Aboriginal Affairs, which sits within the Premier's Department, may be able to help me provide you an answer on that.
Okay, if you could,
Yeah.
if you could just take on, it's University of Technology Sydney, not University of Sydney. Apologies to the amazing people at Jumbana. So one of the recommendations, though, of that review, it's a really important review about how to actually do the work that's not being done to close the gap and the targets. One of the recommendations is that the Premier's Department and New South Wales CAPO members build the genuine partnerships by agreeing on shared decision-making methods, such as governance charter and collaboration tools, and developing evidence-based sustainable funding models, and so on. And
that's very similar to the Auditor General's own recommendation. So yes, we're certainly acting on that.
Okay, and what I want, the reason I was raising it today is yesterday in budget estimates, when I was questioning the Secretary, Mr. Tidball, and we were looking at some of the significant barriers to improving the out-of-home care system for First Nations children and young people. It was just highlighted in big flashing lights that the biggest problem to being able to have proper co-design is the cabinet process. Co-design in systems, funding arrangements, resourcing, and the operations of the Aboriginal controlled organisations to deliver the out-of-home care services and systems that we know what they look like and what they need. And it was identified really clearly that the cabinet process is the problem and the barrier.
Who identified that?
Mr. O'Reilly
Yep.
who is driving the reform. I don't want to put words in her mouth, but I think Ms. Jarrett was, there was kind of fierce agreement that this is just a given. And I think what I'm trying to understand is, I'm sure there's work happening in Premier's department, but is it work that is happening at that so clearly significant, that's the barriers in the way, that the denial of self-determination of the Aboriginal peaks in driving one of the most important systems for young people, the most vulnerable young people in New South Wales, that this barrier, and I just assumed that this work was happening.
No, it is, and Ms. Boyd might want to talk about this a bit more as well, but it is definitely, what we're trying to do is mesh together a Westminster system of government, including the cabinet process, with shared decision making with Aboriginal people, in this case the coalition of peak organisations. Over the last year, and even before the Auditor General's report came out, we had tried to grapple with that, and the way that we've changed our arrangements, we've got some sector committees, so we do that jointly with Capo, so we've got a more defined structure for how those sort of different sectors, including people like families and communities, how they work. And when it comes to the closing the gap, for example, funding arrangements, the proposals that we considered as part of the state budget this year, that was done jointly with the Coalition of Aboriginal Peaks, and so the government brought proposals to the forum, to the floor. Capo brought proposals to the floor, different organisations who are constituents of Capo, and it was jointly decided which of those should be prioritised and what the prioritisation criteria were for those funding arrangements. So they go through there's a joint council that oversees all of those arrangements, including ministers and Capo. So I'd say that process has improved even over the last sort of eight months or 9 months. It was a much better process this year. So, but I don't disagree that trying to mesh the sort of Westminster system of government with a commitment to shared decision making takes a fair bit of work, and from time to time it's the case that while we're trying to share information and share decision making, some items that are going to Cabinet, for the reasons I'm sure Ms. Boyd will talk about, we can't just hand over to anybody because we've got to respect the role and the rights of ministers to sort of conduct themselves with their responsibilities. I don't know if you want to.
I know just that we're always innovating and looking at new ways to, as Simon said, sort of mesh the concepts of shared decision making with Westminster principles of ministerial accountability. And a good example of it, I think, was this year in the budget process in terms of the work that was done across government with Capo to bring a shared set of proposals to government for consideration as part of the budget process. Now, that decision around prioritisation will always have to happen as part of a cabinet process. It's essential to our system of government that ministers are accountable for the expenditure of public money and need to be responsible for those decisions. But there is a vast amount of work we can do informing those proposals with our Aboriginal partners to ensure that there is, autonomy, shared decision making and self-determination around that. So we're deeply committed to it, and I would just say always evolving and trying to innovate around those core Westminster principles.
And will you commit to looking at the
Ms. Boyd, the opposition.
Thank you, Ms. Boyd. Just returning, just within 30 seconds, I could bring up SO 52, which disclosed
Go for it.
multiple amounts of correspondence between ministers and ministerial officers relating to the subject matter of the SO 52. But let's just move on.
Yeah.
Have you provided any advice in relation to use of in relation to the Ministerial Code of Conduct, and whether it would be appropriate for ministers to use their ministerial entitlements to travel to the Kiama electorate for the purpose of electioneering?
No.
Would it be appropriate to use their ministerial drivers, for example, to take them down to Kiama for the purposes of electioneering?
It's hard to answer that question in the abstract, but what I would say is that ministers, there is an inevitable sort of fusion of ministerial and parliamentary duties. Ministers are always members, and there is, I think our system recognises that parliamentary and party duties are a sort of inevitable part of being a minister, and so there is often overlap
where it is just
there.
blatant campaigning, handing out leaflets, if they travel down and use their ministerial driver to take them to Kiama?
Look, I prefer not to express sort of blanket opinions about hypothetical scenarios in this forum, but
It's
all
not
I would
hypothetical, that's real.
look, all I would say is that you would need to assess the specific situation and just be satisfied that the travel was part of the minister's duties, I think, and
To be
that
fair
can
to
of course.
Ms. Boyd, Mr. Tudorhope, if it is real, what is the example?
If in fact they were making, if the government is making announcements for the Kiama by-election in terms of policy proposals for Kiama, is it appropriate to use ministerial letterhead?
Well, look, if they're government announcements, I think that's well established that you're able to, ministers are able to make those announcements even in the context of a by-election. It's government policy. I'm not sure there's anything untoward about that.
If it hasn't been to Cabinet and is not a Cabinet decision, but it is merely for the purposes of electioneering.
I'm not sure I can.
Mr. Tudorhope,
speak to that. It's
we
a bit-
can't invite the witnesses to give evidence on hypotheticals. We've got to have
Well, I can hand the witness three media releases. Kiama deserves a strong local voice in government. That's a ministerial release. Does that look like? Does that look like? Does that look like a ministerial responsibility?
Oh, look, if it refers to government commitments and expenditure, I think that's a common.
Kiama deserves a strong local voice in government.
Look, I don't think it's my role to give advice to the committee about specific media releases, but what I will say is that it's well established that ministers are also members. They are members of political parties. Those political party activities are an inherent sort of part of their role, and so there is some overlap between them. And provided that the resources are used to fulfil the minister's broad duties, then there can be no issue. So I will just leave it at that, I think.
Really? So what about ministerial staffers being involved in campaigning in Kiama? Is that appropriate?
I don't know that that's occurred, and I would not want to make broad statements about that in this forum.
But as a matter of principle, is it something which is acceptable?
Look, ministerial staff are employed to support the minister with their functions, and as I've said, their functions are very broad and involve travel and the making of announcements in a broad range of contexts. So,
but it's not. They're not to be engaged in party political campaigning, are they? Is that part of?
No, they're not required to be politically neutral as the public service is. It's recognised that ministerial staff will be engaged in political advice and matters. I don't think I'd say that.
I must say that that varies with my understanding of the Ministerial Code of Conduct, Ms. Boyd. But
look, happy to disagree.
But I'm sure that you're more versed in it than me. Can I ask you, Mr. Draper, about you heard the evidence this morning about the local small commitments allocation, didn't you?
In the session that I was in?
Yes.
Yes.
There was a suggestion, of course, that there is now a document of all truth relating to what the actual commitments which were made by Labor candidates for the purposes of the local small commitment allocation. Do you hear that suggestion?
I heard that assertion, yeah.
That primary document, which outlined all the commitments which had been made by the Labor candidates, was available. And that's now come to the attention of the committee examining those. It appears that that document, in terms of what has subsequently been, for example, submitted to Ms. Ma, in assessing those applications, was altered. Would you have approved of that alteration of the original document?
Look, that's a pretty complicated question, really, because it's not our document. It's not for the public service, whether it's myself or Ms. Ma or any of our staff to try and determine what the Labor Party election commitments were. That's a matter for the Labor Party and their candidates to provide us.
Hang on. There's a set of guidelines in place for the approval of these grants.
Yeah, that's a different question.
But there are a set of guidelines, and you would and Ms. Ma would have to satisfy herself that these grants were being made in accordance with those guidelines. Is that not the case?
We wrote guidelines after the election, obviously, to administer those grants. I think the section of those guidelines you're referring to in the eligibility section refers to the fact that they should have been election commitments.
So there's a document which sets out whether a particular election commitment had been made.
I haven't seen that document, but I did hear the evidence this morning. Not the evidence, sorry, the comments that were made by the opposition this morning. Yeah.
So, if in fact that had been changed in circumstances where it appears that in fact they weren't election commitments, that would be a breach of the guidelines. Would you accept that?
Well, first of all, that's an assertion that you're making. That's not something that I can confirm, or I haven't examined that question.
If it happened, would it be a breach of the guidelines?
Well, the guidelines provide that one of the eligibility elements is that the guidelines provide for a whole lot of probity and integrity issues. One of them, very, very many of those, is that the project, I think it uses the term project, should have been an election commitment made before March 2023.
So, if in fact they were changed to reflect a commitment which was made after that date, that would be a breach of the guidelines.
Well, that's a little bit hypothetical. I don't know that was the case.
On a point of order, Chair, the witness has been asked this 3 times. He's deliberately seeking to avoid a direct answer. And it's not a hypothetical.
No, it is a hypothetical, Mr. Latham.
It's a situation according to the guidelines.
Well,
the question was couched to me, if this happened, what about...
Order on the point of order. Mr. Saval on the
point of order.
The witness...
point of order before the witness interrupted me.
Please finish.
The witness 3 times now is refusing to answer a direct question as to what he knows about the guidelines.
Oh, I didn't.
No witness should be allowed to treat this committee with such contempt.
Order. That's not a point of order.
Well, yes, it is.
No, it's not. It's not a point of order at all.
Keep going.
The witness was being relevant. He was responding to a
political agent.
Order. The witness was being relevant. He was responding to a hypothetical because it was if the, and so and I think that the witness was doing his best to respond. And can respond the way he sees fit.
Just to the point of order, Chair.
To the point of order, sorry.
There have now been a series of hypothetical questions from the Honourable Damien Shooterhope. I'd perhaps encourage him to deal in actual realities and examples and case studies that perhaps the witnesses might be better able to answer as opposed to hypothetical questions.
Yes.
You were here this morning.
So I don't uphold the point of order.
I'm trying to answer your questions as directly as I can. Contrary to the assertions of Mr. Latham, I am answering your questions as honestly and directly as I can.
No, it is not one of the guidelines that the project finally approved was meritorious.
No,
it
absolutely.
May be objectively meritorious, like it may be a refurbishment of a war memorial. On its face, objectively meritorious.
No, that is one of the requirements. Certainly, there's a whole series of criteria that's evaluated against the merit of the program, whether it was something that was additional to what was already going to be planned to do. There's a number of criteria in the guidelines.
The primary criteria is that it was an election commitment.
That's not the primary criteria. It is one. It was one of the eligibility criteria. It's not the primary criteria.
What were the other eligibility criteria?
Well, I can grab the guidelines here.
This will be good.
You want to take that on notice, right?
If it saves the committee's time, I do have the guidelines with me somewhere here.
Ms. Ma, when you actually were assessing these, these grants, you were assessing them on the basis that they were election commitments made before the 23rd of March, were you not?
That's correct.
So if in fact you were you had documents submitted to you which which purported to be election commitments made before that date, which weren't made before that date, you were being misled, were you not?
I couldn't comment on whether I haven't seen the documents that you're referring to,
No,
so
but
I can't.
Just
I can't
answer
comment
my question. If in fact you were asked to approve a project which was not an election commitment, which represented itself as having been an election commitment, you were being misled, weren't you?
Order. That is again, Mr.
That is not hypothetical.
Yes, it is. It is the definite. You said if that happened. You're not giving an example of a particular case. You're saying generally if this happened, which is a hypothetical and which is out of order.
Can you provide a hypothetical answer to that question?
I can't provide a hypothetical answer to that question, I'm afraid.
You weren't being misled.
Mr. Tudhope, I've got the document in front of me, the guidelines. So the eligibility criteria include that a nominated organisation invited to submit a project identified as election commitment prior to the 25th of March election.
Yep.
A not-for-profit organisation, agency or group, including but not limited to, and I won't go through the full list, but they're basically not-for-profit organisations. A government-related organisation, including a New South Wales government agency, local council or joint organisation. Again, having been nominated, it has commenced after the election, be delivered an electorate from which the funding was allocated, and then there's all the standard criteria about the merit of the expenditure itself.
Okay. I'm going to go back to Ms Maher. In the Wollondilly electorate, and we heard this specific example in the evidence given this morning, there was a single commitment for $400,000 for parks and playgrounds. If that was in fact changed to a post-election series of commitments for different projects, you would have been misled, would you not?
It's really hard to judge without having seen the documentation. So we don't know if individual projects were sitting with a campaign or a candidate.
But you would have had to have assessed that.
And so what I was about to say, is so the 400K, for the purposes, I guess, of pulling together the spreadsheets, was the election commitment per electorate. My understanding, and as I said, I have not seen the documents that you're referring to. The document I have seen is the master list from the 28th of July. But it's difficult for me to be able to tell you whether that was just a lag in terms of filling in the detail or whether it was something else. I honestly cannot comment on that because I don't know if it was just, as I say, a lag gathering the information. I wasn't involved in those conversations.
The document provided to the inquiry is different than the one that you were working on provided by Alison Morgan in July.
I think Miss Morgan's evidence to previous inquiries has been that she was working with the Premier's office and waiting on details to confirm projects.
You just called it the master list.
The 28th of July list, that's correct.
The 28th of July list.
Yes.
If in fact the one which is the true list of the election commitments was made, you were working on a wrong assumption.
So I guess what I'm trying to say is I don't know if there's a true list, an earlier true list. What I'm trying to say is our understanding and the evidence that I have heard Miss Morgan has given, because she was intimately involved in this, was that she was waiting for details. So, for example, we didn't have contact details for the community organisations for whom we had to liaise to then commence the assessment. No. So there was. I'm not trying to overcomplicate things, but as I say, there was an iterative process in terms of providing that information back to the program office to allow us to start assessing. That's all I can. That's all the information I can provide the committee, because I haven't seen the list that you're calling. What did you call it? The true list. The real list. I don't know.
I think Miss Mars, they used the phrase iterative, and I think for our staff, including Ms Maher and Ms Morgan and others, we're increasingly getting information we could rely on. It wasn't all available when the work started. We don't even know if it was all available to the Premier's office, who was our source of information. They were collecting information after an election across the state. So I don't think it's at all surprising that there be a process of firming up what the contents of those election commitments that were eligible for the grants would be. I mean, that doesn't seem that surprising to me.
But if there were material differences, in what was nominated as the Labor election commitments, wouldn't that in fact give rise to a circumstance where you were being misled into what, in respect of what were Labor election commitments in terms of approving those projects?
I hate to use this term here, that's a bit hypothetical. If this happened, would you be misled?
Just on that, while not covering this committee completely, the rules for questions under Standing 65 from the House say that in G they should not deal with hypothetical matters, and that officers at these committees should only be giving evidence of a factual nature, and any other matter should be referred to the Minister. So that is the guidance I'm operating under, the Standing Order 65, which guides us, and also the LC practice, page 805. So
to that point of order,
it wasn't
Chair.
a point of order. It wasn't a point of order. I was just
giving me guidance.
I was just informing the committee of how I'm.
Thanks very much.
Proceeding. Thank you.
This wasn't a document which was just missing contact details. Different projects. That would indicate to you that there is a material difference between the first list and the second list. Different projects.
And I guess what I'm saying is whether it's contact details that are being updated or if it's projects.
It's not missing contact. Different projects.
Yeah, I know, I understand that, but I guess what I'm trying to say is I can't tell you whether that's the case, that they are being added later or if it's just being updated, because I haven't seen it. I wasn't involved in that process.
On the face of it, if they're different projects, they've been altered.
Well, I don't necessarily accept that. I mean, I can't necessarily comment on that.
Do you use communication applications like Signal or WhatsApp?
Yes.
With other people in your department?
I have for some time. We use them for things like trade missions. That's when we sort of started using channels like that. But yes, we do. As an authorised. Do you preserve the records relating to those WhatsApp messages? Where I'm required to preserve a record, yes, I would.
How do you do that?
Generally speaking, if it's ephemeral, no, I wouldn't, as per Ms Boyd's evidence this morning, I wouldn't record it. But if a decision is taken over a channel like that, then it would be captured via email, most likely. But generally speaking, messaging apps like that aren't used in my experience.
Do you have disappearing messages on your...
Yes, I do in some instances.
Are you able to provide a list of those groups that you have disappearing messages in relation to?
I can take it on notice.
Thank you. Mr Draper, do you use the same sort of apps in communicating with your staff?
I'm not as versatile as many people in using the apps, but I do have WhatsApp and I use Signal as well. Yes.
Do you use disappearing
and I use
messages?
text messages. Yes.
Do you use disappearing messages?
I wouldn't even know how to set that up myself, but some people they set up a group, they've set them up with disappearing messages.
So how
Thank you, Mr Tudor. The time for questions from opposition
considering
is
the
concluded.
amount of time I was interrupted,
Chair.
Chair.
There was a bit of interruption going on. Mr Latham.
Thank you, Chair. To Mr Draper, you said that you've dealt with and approved 400 of these applications through the housing...
Not approved, but I'm estimating, I think we've done over...
You've recommended them on for state significant development,
No,
yeah?
we've considered over 400. We haven't recommended all of those.
Right, and how many have you recommended?
The last number, I think, was the reliable one was 187. But we've had a meeting since that number, so there's probably another 20 or 30 or so.
Over 200?
I think so.
And how many of those over 200 have you found out retrospectively that the proponent didn't have authority over the land for which they were placing their application?
None.
You're not aware of this Bill Berger?
Well, I'm taking your word for it, and I've said I'll take that on notice and come back to you on that.
Okay, do you take the Minister's word for it that he had to amend the State Significant Development Declaration for this Bill Berger project with Ministerial Order number 11/2005 on the 23rd of July this year, 5 months after the fact?
I can't take the Minister's word for it because he's not here to give me his word, but I'm sure if he's done something, it's
was this notified back to your authority?
It doesn't need to be notified. We make recommendations to the Minister. The Minister then makes declarations. It's a matter for him then to watch declarations he makes. Once it leaves our consideration, it's entirely up to the Minister to make declarations.
Right, so you're telling me the process here is that Bill Berger put in an application including 5 parcels of land for which they had no authority, 3 private, 2 public. Somehow the Department of Planning must have just taken the say-so of the proponent that they did have authority. It's found out to be false. The Minister has to retrospectively amend the State Significant Development Declaration, obviously to the public embarrassment of your authority, but no one comes back to tell you?
No, I'm not saying that.
What are you saying?
I'm not saying anything. I'm just listening to you ask questions and trying to answer them.
Well, given that this State Significant Development Declaration was amended based on the false pretences and clearly some sort of error that was made in your authority passing it through, has anyone come back to you and told you this was a major error?
No, I don't believe so.
Do you think that's a problem in the process here?
No, because I was away for quite an extended period around that time and may have been discussed by those that were around at the time, but I wasn't there.
So you're one of 3 on this Housing Development Authority, you're the head of the Premier's Department, and you've got no knowledge of a circumstance where a major developer at Rhodes, Bill Burgess, lodged an application falsely and through the process without the authority over 5 parcels of land. The ministers had to retrospectively amend the State Significant Development Declaration, and you've got no knowledge of that.
It hasn't come back through.
What sort of job do you do?
It hasn't come back for further consideration at the Housing Delivery Authority.
Well, it's just unbelievable, isn't it? It's unbelievable.
Order.
It's unbelievable.
No, it is order, Mark Latham. Mr. Latham, I call you to order for the first time. You're to treat the witnesses with respect and civility at all times. You're not doing that, so I call you to order for the first time. And secondly, you are making imputations and against people who aren't here, third parties who aren't here.
Who?
Mr. Berger. We don't know
it's
what.
It's not Mr. Berger. It's a development company called Bill Berger.
Well,
you
okay.
Clown.
Well, you haven't made that clear. Bill
Yes,
Berger.
Yes, I have. It's their name.
Bill Berger sounds like a person.
Only for a fool.
I beg order. I call the Honourable Mark Latham to order for the second time.
Yeah. Well, what a joke. Bill Berger. Okay, so Mr. Draper, you've got no knowledge of this happening at all.
You keep asking the same question, I'm going to keep giving you the same answer.
You've got no knowledge of it.
It hasn't come back for reconsideration at the Housing Delivery Authority.
No, the Minister retrospectively had to
The
amend
Minister can act on the advice of his department separately. He doesn't rely on the from me or the Housing Delivery Authority to make such changes. He's got a department that advises him. There may be information that he's had available that wasn't available to us. I'm sure he's acted properly on that information.
To you, does it point to a faulty process that this could ever be allowed to happen?
No.
No? You're quite comfortable with this getting through the system?
It hasn't got through the system by the sound of it. If I take
Well,
everything you say as accurate, then it hasn't got through the system.
How could it be legal to retrospectively alter the State Significant Development Declaration without starting the process again?
Well, I mean, the Minister takes advice. He can make declarations on state significant developments.
You regard it as legal, do you?
I'm sure that the Minister acted with all good advice from the Department, including legal advice on his powers under the Act.
Right. Have you seen that legal advice?
I don't need to see it. I'm not the advisor to the Minister for Planning.
You just know nothing about it, do you?
Order.
That's a question. That's a question.
Here.
Why is that not a question?
Point of order,
Because
Chair.
that is not the evidence we've heard, and you're casting aspersions
saying
on
he knows
Mr. Draper. Order!
He says he knows nothing about it.
No, that's not what he said at all. So,
Chair,
to
just
the
a
point of order, Ms. Saval.
The Honourable Mark Latham has made a series of unsubstantiated claims that he's put towards Mr Draper and then basically tried to impugn his reputation. I'd ask you to call him to order again for the third time because he's just continuing to flout your previous rulings, in particular around adverse mention. And separately, I'd ask you to ask him to withdraw remarks that he made reflecting on a member of this committee.
To the point of order, Emily Savale's got no knowledge of whether this is substantiated or not. I'm referring to a legal. I'm referring to a legal instrument of the state government, State Significant Development Declaration, Ministerial Order Number 11 of 2025. There's nothing unsubstantiated about this.
Order.
This is real.
That's irrelevant. The point of order is to how you are conducting yourself and how you are treating the witnesses. And it's already been a matter I've had to rule on and call you to order for 3 times. I won't uphold the point of order, but remind you that if you are called to order for a 3rd time, then we will move into a deliberative to consider ejecting you from this hearing. So you're warned, Mr. Latham.
Yeah. Mr. Draper, on the 18th of February, when you recommended Bill Berger, that's a development company called Bill Berger, the Housing Development Authority in Leeds and Averil Streets, were you aware of the official roads place strategy finalised by the Department of Planning in September 2021 that locked into law in October 2021 planning rules dividing roads east into 4 sub-precinct characters separately under their own height, density and public benefit tests? Was that placed before you?
I've already given you evidence that I can't remember the details of all 400 applications that we've considered, but I do recall having conversations. I'm not sure if it was on that date or in relation to another application, but I certainly had conversations about the instruments governing the roads development.
Is it true at your inaugural meeting you reviewed 30 applications in the space of 2 hours, giving 4 minutes to each on average?
Well, we don't just give them that. We spend a lot of time before those meetings reading all the details. It's like any meeting. You don't come into a meeting and you have never looked at it before. We've probably spent at least 2 or 3 times that amount before we come to the meeting and sit reading through all the papers.
And how many times have you asked the planning department, are we certain that the applicant's got authority over all the land for which they're seeking to develop?
Oh, look, we ask a lot of questions of the officials who prepare the recommendations. Sometimes we have to defer matters to ask them to go back to applicants and get more information. That happens quite frequently, probably almost every meeting. I can't remember the specific questions we've asked them, but we ask them a lot of questions.
Did you ask any questions about this Bill Berger development?
I've told you that I don't remember going back over 400 applications considered in February. I don't remember the details of that one.
And no one's ever informed you of the problems I've identified today other than hearing that from me?
Well, no, and I think I told you the dates you were referring to earlier, that I wasn't even in Australia at the time when that came to light.
Would you expect when you came back to Australia they'd tell you that there'd been a major problem with this huge development at roads that effectively had to be retrospectively amended and restored by the Minister?
No, not necessarily, because it's not something that requires any administration or decisions by the Housing Delivery Authority.
Yeah. Can you confirm that at that meeting you reviewed the 30 applications in the space of 2 hours?
No, I can't confirm that, but it's quite possible that we'd normally spend between 2 hours up to 3 hours on most meetings, but we always make as much time as necessary to consider all the applications.
Right. What sort of review has there been so far of the processes of the Housing Delivery Authority, and do you think we're running into the problem of a mad rush to approve anything that comes across your desk, even if the proponent hasn't got authority over the land?
In terms of review, Ms. Boyd might remind me, have we got a formal review process that we established in the terms of reference? I think there might be.
We can take that on notice and check.
They'll take that part on notice, but for the second part of your question, there's no mad rush to approve everything. I think probably, I don't know the exact numbers, but I'd say probably about half of the matters that come before the Housing Delivery Authority get recommended for declaration by the Minister, and about half do not.
Yeah, are you willing to meet with the
Order.
three private landowners
to from Mr. Latham is concluded.
Hear the nature of the
Order.
problem? And
you don't have to answer this. The Greens.
Apologise them to them
Order.
for their competence.
Ms. Boyd's turn.
Ms. Boyd.
Thank you, Chair. Mr. Draper, I think this is a question to you. So in October last year, a new Treasury policy and guideline document was released called TPG 23-27 Gender Impact Assessment Policy. In the 10 months since that policy has come into place, how many new policy proposals have gone through that gender impact assessment process?
Look, I'm going to take that on notice. I'd probably have to, I don't have that information with me.
Are you aware whether the government's workers' compensation policy was subject to that process?
No, I'm not aware.
If you could take it on notice,
Take it on notice,
and
sure.
find out if it was, that would be very useful. Thank you. In November last year, Treasury released the new guideline TPG 24-30, which allowed fast-track business case and investment assurance for government capital commitments, which I think I described at the time as allowing things to be fast-tracked if they're subject to a media announcement. How many times has that fast-track business case process been used?
Again, I don't know the number that has been used, but I don't agree with your characterisation of it.
I'm sure you don't.
I mean, just for context, and I won't take up too much of your time, but the reality is that business cases, and I think the Premier spoke about this morning in response to another question, business cases are a way of informing decision making, but there are times when spending a lot of time and money on a business case isn't warranted by the decision that has to be made.
No one's disputing that, but one of the parts, like part of that guideline actually says that one of the cases in which you can have a fast-track business case is where there has been an announcement by media, by press release. So it's, just I don't think it's a stretch to say that this is fast-tracking.
I don't recall if it says that, but what I will say is that if there's been a decision, I've seen a lot of times when there's been a pretty clear decision of government to go ahead and do something, and then people go away and do a business case which just costs a lot of money and takes up time, and it's inevitable that that's going to go ahead.
Sure.
It doesn't add a lot of value to the decision-making process.
No, I think, again, no one's disputing that. I think what we're disputing is that the idea that you could just bypass that process for all proposals seems a little extreme. But
yeah, we wouldn't do that for all proposals.
No.
I think there's lots of circumstances, I should say, where elaborate business cases are very warranted and have proven useful in filtering out projects which shouldn't proceed.
If you could perhaps just take on notice how many have been shortcut through that new policy document and what they were, that would be very useful. And finally, why is the government refusing the community preschools supported bargaining case?
I might have to. You familiar with that one?
No, I'm not. I'm sorry. I'll have to take that on notice.
We've taken on notice. Sorry.
Thank you.
Sorry, just to check. That's a wage application, is it? That we
yes. Yep. So we're looking for funding from the New South Wales government.
Can I just ask about trauma-informed communications from within Premier's department? And has everybody undertaken training? Is that something that
I have? Yeah.
You have?
Yeah, and a number of members of my staff have. Yes.
Great. And has the Premier undertaken trauma-informed comms?
I think you'd have to ask him that, but he
Yeah.
has had a lot of discussions with people that are trauma affected, and he regularly meets with victims and their families, and so is not a stranger to those kinds of interactions.
Thank you. Do you think he was provided any advice on the way he was communicating about Kathleen Folbig recently?
I'm not sure. You'd have to ask the Premier.
Okay. Thank you. Do you think that was there any staff in Premier's department who provided him any advice before he went out and on Monday the 14th of July said about requests to meet with Kathleen Folbig, there's a lot of difficult calls for me to make as Premier. This isn't one of them. Was there any advice given to him, do you know, before he went and said that?
No, look, we didn't advise on that specific specific comments, but we have provided him with advice around the general matter, yes.
And in relation to that, I know that you have already provided advice today about how ex gratia payments are very discretionary. Today, the Premier gave evidence, and it was very clear that he said a determination had been made that that was the highest amount that ought to be made from the AG as an ex gratia payment. Can you provide any understanding, any information, evidence to this inquiry to help us understand how a ceiling may have been determined?
Look, I think I'd refer you to the hearing for the attorney's portfolio. I think the Department of Communities and Justice would be in a far better position to take you through the variety of factors, analogies, other precedents that they considered in advising the attorney. It's clearly a really extraordinary and exceptional case, and so there's a wide variety of criteria or factors that would influence that decision, and it's a very complex one. So I wouldn't want to. I wouldn't do it justice here. I think we should speak to those officials directly.
I will absolutely in the AG's budget estimates, and I'll be bringing it up. I've been raising it with the AG for some time, but I'm very interested in your understanding about a ceiling on any ex gratia payment. Has that ever been contemplated, to your knowledge, from any form of ex gratia payment from the New South Wales government, any department, any portfolio, any minister?
Yeah, I wouldn't say a ceiling, but of course the other demands on the state budget are highly relevant to the quantum, and so it's not surprising to me that that was an important factor in the decision.
Do you have any understanding of why the Premier would have said this is not a difficult decision for me in terms of not meeting with Kathleen Folbig?
Well, perhaps because it wasn't his decision. I think his evidence this morning was that it was for somebody else, the attorney, to make the decision. So I don't know if that's the context in which he.
Do you know whether the Premier has ever met with other people that relate their matters and their calls for justice might relate to a different minister or portfolio? Has he done that before?
Look, the Premier regularly meets with a range of
He does, doesn't
people.
he?
Yes.
Yeah. Do you think, is there anything that, if Ms Folbig was to make an approach to you as the Premier's staff in the department and the senior people, if she made an approach to you, asking you if she could meet with the Premier, do you think you would advise the Premier it might be good to meet with her?
I'd have to consider that. If it arose, we would consider that.
There's been a lot of discussion, including from the Premier, that in public that she could sue the government. I think it's reasonable for anybody who has any knowledge of legal proceedings. She is not with a cause of action. It's an incredibly difficult position she's been placed into. Yet the Premier was standing suggesting that perhaps if she had sued the government, or she could, then, in any reasonable context is fairly outrageous. But I accept he said it, he's done it. Would it be prudent for you as his senior staff to advise him in some manner and form that maybe he should reconsider his position at this point?
Oh, look, I wouldn't take the Premier's comments as recommending that she sue the state or advising her to do so, or it's really just a statement that she has legal rights and those are always available to people. I think the decision has been made to provide her with $2 million in the form of an ex gratia payment, and that's the government's position on the matter.
Is there anywhere that you're aware of within government that Ms Folbig can go to make an appeal to explain how that is just not remotely a just outcome for her, and obviously her representatives? Is there anywhere she can go?
Oh, look, it's open to anyone to correspond with government and the agencies of government if they feel aggrieved or if they have concerns that they feel can be addressed by government. So, yes.
Thank you. As somebody in your position, do you think that there is any level of a kind of misogynist outcome for Ms Folbig, considering she was a woman wrongly convicted, lost 4 children, spent 20 years of her life in prison, that that her life has, and all of that injustice has been valued at $2 million. Do you think it might have been a different outcome if it was a male?
I honestly couldn't comment on that. It's so many things would be different. It's too difficult to say. But what I would say is that on behalf of all the public officials involved in this matter, a great deal of thought and analysis has gone into the matter. It's an incredibly difficult and discretionary decision. And look, I acknowledge Miss Folbig's plight. It's an incredibly difficult one. But in the circumstances, the attorney has balanced all of those factors and made a decision about quantum. And you know, I am very sorry that she's not happy with that, but that is the decision. So
thank you, Ms. Boyd. Thank you.
The opposition.
Ms. Boyd, just a couple of follow-up questions, if I may. I wonder if you could provide on notice the invoices in respect of the legal advice that was provided to those staff members.
I'm happy to take that on notice, yeah.
Thank you. And with respect to, so as I understand it, you're arguing that if the memorandum wasn't followed, that there was the executive power at common law that had been delegated. What was the process for managing the conflict of interest between the decision maker making the decision about an ex gratia payment, essentially in respect of colleagues?
I can take that on notice and consider that. I'm not sure I'd call it a conflict of interest, given that there was no private interest of the attorney or the secretary of DCJ in relation to this matter. It's an official function, and that is their role as a decision maker in relation to ex gratia legal assistance. It's not uncommon that they would know the parties that are making the requests for assistance.
I think the issue perhaps is that the part of the reason we have conflicts of interest processes are to ensure the public that there has been no conflict and that decisions have been made impartially and not swayed by professional or personal relationships. And so I think it's very important that that process be very clear to the public how it may or may not have been followed. So if you could take that on notice, I'd be very grateful.
And I think, as I said before, the Secretary of the Department of Communities and Justice was the decision maker on the application, so it was at arm's length from the Minister.
Yeah, and I'm not imputing anything to the decision maker. I'm just curious as to how the conflict of interest process was managed. Okay,
understood.
Thank you.
Thank you. Sorry, Mr. Tudor.
In respect of the documents which have been provided to the Speaker of the Legislative Assembly, the Leader of the Government, in addressing the issue about whether they should be produced to the Legislative Council, said that they were available for inspection by members of the Legislative Assembly. And it almost, I think, in the manner in which documents are available to be inspected by members of the Legislative Council when documents are produced in the Legislative Council. Is that your understanding of what the process is? Is that they are now the documents which have been produced purportedly in response to the order of the Legislative Council are in the possession of the Speaker of the Legislative Assembly and available for inspection by members of that House?
I think you might want to direct that inquiry to the Clerk of the LA. I think they'll be able to give you more accurate advice about the procedure for inspection of those documents and who they're available to. I couldn't speak to that. It's up to the Speaker.
Thanks very much, Ms. Boyd. Ms. Boyd.
Thank you. It's very cool.
I love it.
Mr. Draper, what is Project Onyx?
Project Onyx.
Hmm.
I'm not sure if I can recall what that one is.
I don't think I know that one.
You don't know what Project Onyx is? The
Sounds
Premier's,
like we better take that one on notice.
Yeah, the Premier's Department is paying Allens, I believe, for legal advice in relation to Project Onyx, according to e-tender. Project Onyx has also been bandied about as the name of a social media surveillance artificial intelligence tool that the police force were going to use. Is it related to that?
I don't think so, but given I don't know what it is, I can't answer certainly.
Yeah.
So I'm
if
happy
you
to
could take
that
that on notice, that would be very useful. Thank you.
No more from the Greens. One more, Ms. Carter, Mrs. Carter.
Ms. Boyd, did you advise the staff not to attend the Dural Caravan hearings?
Our role when public official witnesses are called to committees is to advise them about the procedure and about what they should expect when they come to give evidence. In this case, there were some issues that were specific to this case, which advice was provided, but that was not exclusively by the Cabinet Office.
And so, yes or no, did you advise them yes to attend or no not to attend?
It wouldn't be our role to tell them what to do. They've got to make a decision themselves, but we do provide them with advice.
You indicated this was a complex matter. Given the complexities that you saw in attending an upper house inquiry, did you give any advice that could be construed as a do not attend this hearing?
Well, no, they attended, so I think I'll just let that speak for
But
itself.
they attended after a very long, drawn-out process, and they didn't attend on the first occasions. Did you give any advice on the earlier occasions that they did not need to attend or they could not attend?
No, look, they're grown-ups and they make their own decisions in relation to these matters, and yes, we provide guidance about and advice about the powers of the House from time to time.
It's curious, though, that 5 grown-ups would all have unanimity of opinion about this matter, isn't it?
It's not uncommon that there is a collective position taken by government on all sorts of matters.
So individuals called as witnesses had a collective government opinion, and who influenced that collective government opinion?
Look, you'd have to ask them, and I think you did at the time. So I would just say that those are matters for them. Individual witnesses are open to. It's open to them to seek counsel from a range of people about those decisions as to whether to appear. And I note that they did appear. So.
Can I just ask very quickly? Are you aware, will the Premier rock up to the announcement of the Great Koala National Park, which is going to happen very soon?
You have to ask the Premier.
Thank you, Ms Boyd. Thank you all for your attendance, for the questions, for your work for the people of New South Wales. The Secretariat will be in contact in due course with any seeking those questions taken on notice or any supplementary questions. Thank you very much again for your attendance.
Thank you.
We'll just have to have a short
I'll be sure to pass this on.
Thank you.